Thank you. Good morning, everybody. Apologies for a slightly gravelly voice today. I spent most of last night coughing for some reason. I'm blaming grandchildren, so I'll sort of try and keep a voice going through the day, and we'll see what happens. Just to reprise what we did yesterday afternoon in terms of site visits, and we collectively have to thank our incredible chauffeur. I mean, we had some really exciting experiences with the new electric vehicle, which none of us had any idea how to operate. So yes, some of the bus drivers around Hamilton were a little bit intrigued by some of the behavioural characteristics in a council van. So yeah, it was good fun. Anyway, it's more serious matters. So in terms of trees, we specifically looked at for Cameron Gray, the Blue Cedar in Blue Cedar Lane for Mr. Reddy. We had a look at the London Plane at 242 Grey Street. Had a look at a similar for the Wise Trust, and also the non-existent planes in Mariri Avenue. So we had a reasonable look at the ones that had been brought to our attention.
And the ginkgo.
And the ginkgo, that's right, the ginkgo biloba. Biloba? Yes, it was biloba, wasn't it? Magnificent tree, my word, that's a serious piece of kit, that tree. But apparently it's not going to be, so anyway, so we certainly looked at those. In terms of HHAs, again, we'll do quite a few of these again, I think, before the hearing closes. But just a quick rundown: Claudelands, Acacia Crescent, Casey Avenue, Hayes Paddock, Mariri Hino Rata, Oxford Street, Frankton, Sare or Sari, how do you say that? SARS? Anybody, how do you say S-A-R-E? Okay, all right. Tiaraha, and we went looking for Frankton Railway Village, but gave up at the end. I think by that time we'd pretty well exhausted ourselves in terms of looking at things. So a really good feel for both trees and the areas, and we'll hear more about that next week, obviously. Just a couple of, just coming out of that, one of the things that we found a little bit difficult was to locate some of these things, because in some circumstances the area was not well defined in the text by address or whatever. And there's a similar issue, I think, with the SNAs, and maybe just a plea that we get a better indexing of the street addresses for some of these things. And Dean, if you wouldn't mind, I think when we come to you, in terms of the aerials, they're fine, but I mean there's a locational logic obviously to them, but in terms of actually identifying the submitter and the submitter address and that, it would be useful to have a cross-reference sheet that we've got for those, because they don't follow a sequential numbering from the submitters or something like that, so we're just going all over the place looking for them. So if we could have a little bit better indexing, that would be helpful. And again, maybe with Richard Knott next week, if he could do something similar, so that when we're using it for driving around or whatever, it's a little bit clearer as to what the sequence should be in terms of being on the road. Yeah, okay, that's that. Is there anything else? Right, so we're sort of turning our focus now to significant natural areas. Just a note, I guess, just more for the record than anything else, because we haven't finished with notable trees, because not all submitters were cleanly divisible into the three topic areas that we're dealing with. So we will hear more notable tree stuff, I suspect, next week, when some of the HHA submitters also talk about trees and talk about SNAs. So and I guess that's another reason, Ms. Mardani, why we're not closing at the end of each topic as well, because we won't actually have that until the end of next week. So just to note that. And I'll now give my voice a rest and hand over to you. Yeah.
Thanks, Sir. There are separate legal submissions dealing with the topic of significant natural areas, so I'm going to read from those. Take it you all have copies. Just one practical question, just in terms of the panel's familiarity now with the district plan, the online version, and the maps and the layers and the way you can manipulate the layers, is that now becoming more familiar to the panel?
Yes, it is. Although the online version, in terms of street address finding, is actually pretty random.
Right.
You
Yes,
put a street address in and it doesn't give it to you. So,
Well,
so we're having to go between Google and so on and try and get an idea. So,
Yep.
But I mean that's a mechanical issue which probably isn't going to be solved this week.
One of the reasons I ask is that there is probably some benefit in being able to just go in and manipulate the layers to just understand spatially just the extent of some of the impacts of Plan Change 9. For example, you can show the intersection between the notable trees and the SNA layer, so that can answer the question that Ms Morrison Shaw had, which was how many notable trees are there in the SNAs, where you can just put the layers on and make that work. And the other point, and this is one that I was having help with this morning, is you can obviously also have a look at the current level of mapping of the SNAs, and then you can click the PC9 layer, and you can get this kind of visual comparison extent, and you sort of see the SNA layer just sort of blow up as a consequence of PC9. So as a tool, it may just be of assistance to you.
Yeah, no, it absolutely is.
So just turning to the legal submission, starting from paragraph 3. So the operative district plan contains provisions based on a mapping exercise that was undertaken in 2010, which identified and protects 59 SNAs within the city. And while these areas are recognised and protected, there has been a growing recognition that the extent of the mapped SNAs within the ODP is seriously inadequate, with extensive areas of the city, particularly within the gully and river networks, clearly warranting greater recognition and protection. And PC9 sets out to resolve this. The ecological significance of these currently unmapped areas of the city has come under recent judicial scrutiny in the context of the proposed urban development within the Peacock Structure Plan area and its potential effect on the habitat of the nationally critical long-tailed bats. The Environment Court in the Western Lee case had this to say, and I'm going to read it because it is important. This was Judge Smith. In accordance with the provisions of Section 75 of the Act, the operative district plan gives effect to the provisions set out in the Waikato Regional Policy Statement, and the purpose of the plan is to enable the Council to carry out its functions under the Act, and of most relevance to these proceedings, as agreed by the parties, are the provisions of Chapter 20, Natural Environments. These provisions respond to the imperatives of the Act in respect of the protection of areas of significant Indigenous vegetation and significant habitats of Indigenous fauna as a matter of national importance. In formal terms, Chapter 20 identifies areas of significant Indigenous vegetation, biodiversity and habitats of Indigenous fauna which qualify as significant natural areas. And to realise this ambition, the plan contains a number of sites that qualify for inclusion. The sites are identified in the planning maps and are listed in Schedule 9C, and such significant natural areas include identified areas of the Waikato River Corridor and gully areas, the peat lakes and wetlands and remnant Indigenous vegetation or trees. But it therefore comes as a surprise to the Court, in light of the warranted concern held for the future of the long-tailed bat, that no commonly identified and scheduled areas of bat protection are currently contained in Schedule 9C. This is an unfortunate oversight, and it's a matter requiring urgent redress. In fairness, we understand this to be the case, with the necessary policy development work being undertaken by the Council. At the same time, the oversight cannot be ignored. There is a diminishing population of an endangered species of native New Zealand fauna, deemed to be so rare as to be classified as nationally critical pursuant to the New Zealand Threat Classification System, and given the acknowledged adverse effects from land use development, appropriate steps need to be taken based on Part 2 of the Act and Section 6C and relevant plans. The City has a simple process in respect of identifying and protecting SNAs. It's an ongoing process with the end result that there may no longer be any qualifying feature unscheduled. as restoration efforts continue in the city, additional significant natural areas may be created. These will be added to Schedule 9C through changes to the plan through the first schedule process under the RMA, and that's where we are today. So as the court recognised in Westernlea, the city has been undertaking its policy review of the SNA provisions since 2020, with the intent that there be an ongoing process of successive plan changes which add SNAs where the qualifying features exist, and the PC9 SNA topic represents this first significant step to what the court described as an end result where there's no longer any qualifying feature unscheduled. The statutory imperative to make provision for SNAs within the ODP derives from section 74(1)(b) of the RMA, which requires a territorial authority to prepare and change its district plan in accordance with Part 2 and Section 6. And of course Section 6 is familiar to the panel. And in today's context, in the context of SNAs, the relevant subsection is Section C, which requires that you recognise and provide for the following matter of national importance: the protection of areas of significant indigenous vegetation and significant habitats of indigenous fauna. As observed by the court in Westernlea, pursuant to Section 6C, the city is under a statutory obligation to take appropriate steps to ensure protection of the specified values and those areas of significant indigenous flora and significant habitats of indigenous fauna. And protection is the imperative in the section, and the Section 6 matters must be provided for as part of the sustainable management of the natural and physical resources, which of course is the purpose of the Act. So accordingly, the incorporation of SNAs within the ODP represents a critical resource management tool for the discharging of these statutory requirements, with their inclusion within the ODP reflecting Hamilton City's recognition of its role and function under the RMA.
I just have a question, and some of the submitted evidence, particularly the lay submitted evidence, they take a bit of an issue with the label significant natural area, and say that it's not naturally occurring, and therefore it's not a significant natural area. And looking at the definition of it in Section 6 of what we need to look at, significant indigenous vegetation and significant habitats, is the term significant natural area just a label to describe those Section 6C matters, or is there a sort of a standalone definition of what constitutes a significant natural area, and does it have to be limited to natural planting? It's a question that came up for me from reading the evidence.
Yeah, I mean, I think it is a label, but I do consider it to be an apt label, and I think probably the point that is important here in response to those submitters that draw a distinction between indigenous biodiversity on the one hand and something that they consider not natural or planted, exotic or grass or whatever, is it's really the second part of Section C, which talks about not just significant indigenous vegetation, but also significant habitats of indigenous fauna. And of course, you'll hear from Dr. Mueller about long-tailed bats and what are the significant habitats of long-tailed bats, which are the indigenous fauna. And the evidence is that those areas that those submitters point to, which aren't necessarily indigenous, grass, whatever, introduced species, they still represent significant habitat for indigenous fauna. So that's where the connections and the links are made.
And that would be the same response then too to the submissions where they say, well, I actually planted this, and so it was human planted, it wasn't naturally occurring, and therefore if it still fulfills that function of being significant for a particular fauna, or they might have planted indigenous trees and it's now viewed as having those significant characteristics, that's what captures it, rather than who actually planted it.
Yes, that's exactly right.
Yeah.
And of course the question of whether there's still a factual determination for you to make, which is, well, is it in fact significant habitat for indigenous fauna? That's a factual question, and that's where you can test the evidence of Mr. Dean, who has done the mapping in collaboration with Dr. Mueller. And if you're not satisfied that an area is in fact as significant as the experts say, well then it's obviously open to be remapped or excluded from the mapping.
Thank you.
Just to take that one step further, obviously we're sitting here in PC9, not PC12, where this topic comes up as a qualifying matter, and that looks at a site-by-site analysis. So I think that the discussion we've just had probably takes that point a bit further again as to whether you take that sort of overall ecological approach of saying this is part of that ecology and is used by as habitat, even though it doesn't have the particular vegetative qualities that you might, that particular item of fauna might be looking for. So
yes,
that's the contest.
It is, and again that may be an issue you wish to explore with the experts. This idea that, particularly in relation to the corridor SNAs, which is dealing with this kind of habitat, the idea of just almost slicing and dicing the habitat and saying, well, it in of itself just doesn't seem significant or material, but it's part of an overall system, an ecosystem, a connected ecosystem, and a corridor. You can test with those witnesses, the merits or otherwise of slicing a piece off, because it just in and of itself just does not appear to be of any great consequence. The experts would say that it's all part of a connected ecosystem and a corridor that matters and needs to stay connected, but again, I see that as a factual question that needs testing.
And I mean, just flagging an issue for me as well. I'm comfortable with the distinction between floristic and corridor, and that to me makes sense. But when I look at the provisions, and I know that some of the submitters will be more concerned about the provisions that will apply to them in the corridor, I'm wondering whether in actual fact that distinction has been thought through sufficiently well in the provisions. So just a bit of a flag that I want to hear more about that.
Thank you for the flag. I mean, there are distinctions. The provisions do make distinctions between the two in terms of land use controls, but we'll certainly have a think about that question of whether they are sharp enough.
Yeah, or loose enough in some cases. Yeah.
Sorry, just one further question before we move on. Is there a definition of SNA anywhere in the operative plan or in the plan change? I'm just thinking in terms of assisting the submitters that have not quite understood what the significant natural area actually applies to.
Yes, I'm not sure. I'll check that with you. I mean, there's certainly a purpose statement, and there's sort of collateral that sits within the chapter that would help with the understanding, but whether it's been distilled down to a definition, we'll check. I'm not sure. We can get an answer for that pretty quickly.
And of course, just wrap this one up. All of us sat on PC5, so I mean we're very familiar with long-tailed bats. Oh, you didn't? That's right. Sorry. No, yes, I thought you were Nigel for a moment, but you're not. Right. Well, all that long-tailed bat, it goes to him. Right.
Well, I'm sure that Commissioner Sargent's sufficiently familiar, particularly with the Western League context that drives it.
Yes. No, you are, aren't you? Thank you.
So, just dealing quickly with the operative provisions, as was signalled in that judgment, Chapter 20 is the critical chapter that addresses the question of SNAs. In paragraph 10, I've just set out the objective, the current objective, that SNAs are protected, maintained, restored and enhanced, and it's supported by a fairly comprehensive policy set, including a policy that adverse effects of development on the city's significant natural areas shall be avoided, and that the loss of habitat that supports indigenous species classified as at risk or threat shall be avoided. So Rule 20 then establishes the activity status within the SNAs, and it enables a certain limited amount of permitted activities such as pruning, maintenance, pest control and planting of indigenous vegetation and trees, and then it has some stronger controls, mostly non-complying activity status in relation to earthworks, buildings or structures, and the removal of indigenous vegetation. And then you move to Schedule 9C, which sets out the list of SNAs, and it individually lists the SNAs from SNA 1 to SNA 59, with each having a map reference, and then the SNAs are then mapped spatially. The SNAs operate as an overlay sitting across an underlying natural open space zone. Notably, there are a number of natural open space zones which do not carry the SNA overlay. So as the name suggests, the natural open space zone recognises and protects natural character, but it does allow for limited urban activities, including buildings, walkways and cycleways and recreation. So while it offers a degree of protection, it doesn't adequately protect any significant indigenous vegetation and significant habitats of indigenous fauna that might exist within the zone, and the additional SNAs would of course cure that shortcoming.
So just generally, is the SNA overlay now over all natural open space zones? Has that just been
I
assumed?
haven't done that exercise,
Yeah.
but I suspect so. I don't. Yeah, because
I mean,
most
that's
of
the
that,
import of what you're telling us. I'd have thought that was the
yeah,
case.
most of that river and gully network is open space zone, and it's all been captured through the mapping.
Yeah.
There might have been a slightly different. I mean, there has been a slightly different mapping approach taken to the SNAs, which Mr. Dean can explain, and it may be that the zone maps have, the boundaries of the zone mapping. There was a different methodology, so there might be some minor inconsistencies, but generally speaking, that's the outcome. So dealing now with changes, a key ecological feature within Hamilton City is of course the Waikato River, which bisects the city along a 16-kilometre stretch of its reach, and the extensive gully network that feeds into it. This network, together with a range of distinct areas and corridors of largely natural character, hold important ecological significance, particularly indigenous flora and as habitat for indigenous fauna. Vast parts of these areas are not currently recognised as SNAs, despite having characteristics that meet the criteria in Section 6 and the 11 criteria for SNAs that are set out in Policy 11A of the Regional Policy Statement. And to illustrate the importance of recognising and protecting these areas, the Section 32 evaluation put it pretty starkly. Within the Hamilton City Ecological District, it's estimated that since 1840, the Hamilton Ecological District has had a 97.8% reduction in indigenous vegetation. Vegetation areas that are left, predominantly in gullies and along the Waikato River, are the habitat for several threatened and or regionally uncommon species, notably the long-tailed bat, where Hamilton is one of only a few cities in New Zealand where long-tailed bats are known to persist in an urban landscape. The overall picture is of a significantly depleted ecological system, with only 1.5% of the total city area protected by the current SNA overlay, and numerous areas of key habitat for fauna that are not protected by the operative SNA overlay. So, in response to the situation in 2021, the city engaged Foresight Ecology to review the current SNAs and identify and map other areas within the city which met the threshold in Section 6 and the RPS criteria. And as a result, two spatial data sets were created. The first is the floristic SNA, which are distinct areas of wetland or terrestrial vegetation communities dominated by naturally occurring indigenous plant communities, or where naturally occurring indigenous vegetation define the primary aspect of the natural area, which make it significant in terms of Section 6C. And then secondly, corridor or indigenous fauna habitat SNAs, or CSNAs, and these areas are able to be delineated by topographical or vegetation features such as gully systems, which can be dominated by exotic vegetation or restoration planting, which provides significant fauna habitats, including stepping stones or corridor habitats, including regularly used habitats by nationally at-risk or threatened indigenous fauna species, and provide ecological buffering to a regionally or nationally important SNA. So there were a total of 52 CSNAs identified, which equates to approximately 6.1% of the city's area and covers 671 hectares. And the area includes the Waikato River and water bodies of the city's peat lakes, and then 63% of the significant sites were assessed as nationally or regionally significant, primarily as a result of the threatened and nationally critical bat species that were utilising the sites. There were also a total of 65 FSNAs assessed as significant, comprising an area of 121 hectares of high quality vegetation situated within or overlapping the CSNA layer. And of the significant FSNAs, 60% were assessed as nationally significant, 16% regionally significant, and 24% locally significant. So with that data having been collected, on the 2nd of February, Hamilton City sent out approximately 1,700 letters to property owners of land with potential SNAs, areas identified on their boundary, on their property. Ground truthing of particular SNA boundaries occurred where public feedback indicated that further checking was required. There were a total of 39 private landowners visited to review potential mapping and the CSNAs, and a total of 13 landowners for FSNAs, and 8 FSNAs on public land were also visited and ground truthed, and changes made to the extent of the number of sites. In addition to the revised mapping, a planning review of the ODP provisions related to SNAs was also undertaken to ensure they were fit for purpose and aligned with what was then the exposure draft to the National Policy Statement for Indigenous Biodiversity. So then the provisions were notified. They gave full effect to this reassessment of all existing SNAs within the ODP, but that excluded the Peacock Structure Plan area, which was being separately dealt with and updated under PC5. But it looked at also all other potential SNAs across the city. And Schedule 9C was then updated to incorporate the new expanded list of SNAs within the city, and all planning maps were updated accordingly. The policies in Chapter 20 which related to SNAs were updated to change the focus from an absolute avoidance approach to an effects management approach, focusing first on avoidance of effects on key ecological values and functions, and from there reflecting the effects management hierarchy to protect SNAs. There was a revised activity status, Rule 20.3, and some revised standards in Section 20.5 to reflect the new management regime, with clearer permitted and consenting pathways for certain activities, including taking the different approach to the management of FSNAs and CSNAs for some activities, recognising their different functions and values. And then there was some updated definitions and terms, and of course assessment criteria. So to the submissions, of the 2025 submission points that were raised on PC9, 472 related to the SNA topic, received from a total of 140 individual submitters. And the key themes that emerged from the submissions included, firstly, the impact on landowner and private property rights. Unsurprisingly, a number of submitters raised concerns about the impact that the identification of an SNA and the plan provisions would have on their private property rights, future development aspirations, values, the ability to build, replace and maintain structures and carry out works. There was support for the SNA mapping, with a number of submissions generally supportive of the intent to protect SNAs and extend SNAs to cover the gully areas of the city, and they generally didn't seek any wholesale changes or that the regime be rejected. There were submissions in opposition to the SNA extent, with many submissions concerned about the extent on specific properties and seeking either the adjustment of the boundary of the SNA or the exclusion of the property from the SNA. The reasons for the change extent included concerns about encroachment on private property, the burden of consenting requirements, or challenges to the quality of the area, degraded vegetation, the dominance of exotics and weeds, the removal of vegetation, or the lack of ground truthing. There were requests to amend the policy and rule framework associated with the SNAs, with a number of submitters seeking amendments to the policy and rule framework. Generally, they were seeking greater flexibility to undertake activities within or adjacent to SNAs. And then, of course, there was support for the policy and rule framework as well, with a number of submissions seeking more effective and extensive protection of biodiversity values. Expert witnessing witness conferencing was convened on 14th of March The city had in attendance Dr. Mueller and Mr. Dean for ecology and Ms. Galt for planning. There was also an additional expert conferencing session held on planning on the 20th of March that Ms. Galt attended. At 26, I note that there was a joint witness statement produced and signed by attendees, and there's a summary of the proposed amendments to PC9 that were effectively agreed at conferencing. And you can just sort of work through those fairly quickly. There was an agreement regarding the SNA extent and an adjustment relating to the Fonterra site. There was agreement regarding new objectives and policies to give recognition to the citywide approach to long-tail bats. There was a wording change to Rule 20.3b recommended, and the definition of pest control to better enable clearance of pest plants. There was a wording change with Kaingaora to provide for pruning in proximity to existing buildings. An amendment to the activity table to make it clear what specific rules apply to the Peacock precinct rather than the citywide rules. And clarification again related to pruning of trees overhanging SNA boundaries. Some minor wording changes also in relation to Appendix 1.2.1. Notably, there was an agreement on a DOC proposition that it be included, or a rule be included within the plan that it be recorded as an affected party for activities engaging with SNAs. And there was not agreement reached on the definition of restoration either. So those are matters that remain live for the hearing. However, the city does consider that the proposed updated PC9 provisions that are appended to Ms. Galt's primary evidence do incorporate most of the drafting edits that were agreed, or if not all of the drafting edits agreed at the conferencing. There has been a further Section 42A report. There was the initial themes and issues report which preceded the conferencing, which really was a summary of the submissions received, and there's been a further report produced subsequent to conferencing. And again, there's good alignment between Hamilton City as the proponent of the plan change and what the 42A authors are saying. So we've worked hard to maintain that alignment. Turning to the response to submissions, so there's been a fairly comprehensive review of the PC9 provisions in light of the submissions. And starting at paragraph 30, I note that Dr. Mueller and Mr. Dean undertook a comprehensive review of each of the SNAs identified in the submissions. And in relation to the submissions that challenged the SNA extent, there were roughly 100 properties that were the subject of submissions requiring further investigation into boundaries and the like. And for most sites, this consisted of a desktop appraisal where landowner permission was granted. However, there was a site visit to ground truth, the overlay. An assessment was then made as to whether the line work and the notified mapping was accurate, or whether features such as lawns, buildings or orchards had been captured, and recommendations for boundary adjustments or removal of SNAs weren't made unless it was clearly misidentified. In total, 89 site visits were conducted in response to submissions, and 31 of those sites were recommended to be changed as a result. And so Mr. Dean, in his evidence, confirms those changes and shows the revised mapping. Mr. Dean recommends that changes are made to the extent of 22 SNAs relating to 32 submissions, and those are detailed in the aerial mapping set out in attachment 1 to his primary evidence and to the table in attachment 2. Mr. Dean otherwise does not support wholesale changes or deletions of SNAs from individual properties. His evidence is that in most cases they form part of a much larger SNA site, and to consider them on a standalone basis is not ecologically sound, which was that point I was raising with you earlier. In addition to the mapping changes, he supports changes to the notified provisions relating to restoration, vegetation clearance and weed control that have been proposed as a result of submissions, including a tightening of the permitted activity standard so that a total clearance area applies per asset and replanting is required if a cleared area is not needed for ongoing access.
Sorry, just before we move on, what does per asset mean? I wasn't clear on what that means.
I think that's the SNA asset.
SNA asset as a whole, or is across that particular site, or?
I'm not quite sure what it, we may need to return to that, whether it's site specific or whether it's actually part of the entire system. Again, that may be a matter that we can raise with Mr. Dean. There's new allowance for small structures associated with restoration and access, amendment to pest control, and an allowance for greater than 50 square metres of clearance of pest species where a particular standard can be complied with. So Mr. Dean's evidence is that the amended PC9 provisions relating to SNAs provide good protection for the natural values of these sites without unduly restricting the restoration activities of individuals and groups, which are so vital to biodiversity protection and enhancement in the city. The submissions from Royal Forest Bird and DOC sought amendments to SNA provisions with respect to the effects of lighting on fauna within SNA. And having reviewed those submissions, Mr. Mackenzie supports the notified provisions with respect to lighting effects, subject to the introduction of a new rule that controls light sources in proximity to or within SNAs, which of course excludes the Peacock precinct, which is separately addressed. Dr. Mueller has provided evidence responding to some of the issues raised in the DOC submission relating to lighting, the infrastructure within SNAs and the habitat mapping beyond SNAs, and offsetting and compensation. She supports the addition of further provisions to limit the effects of light intrusion of any new lighting on an SNA as recommended by Mr. Mackenzie, and controls on additional lighting, screening and setbacks to achieve minimisation of lighting effects within SNAs. Changes to the provisions that control public access to SNAs to ensure there's no additional light intrusions into SNAs and that no future conflicts are created between public access and the requirement to protect potential bat habitat or potential bat roosting, and the inclusion of a reference to best practice guidelines for offsetting and compensation. So in addition to that expert evidence, the city's planning expert, Ms. Galt, has reviewed the amended plan provisions that were appended to the Section 42A report and the evidence of Mr. Dean and Mr. Mackenzie and Dr. Mueller, and supports the updated SNA mapping recommended by Mr. Dean and the provisions that are attached to the 42A report. There is, however, one small issue concerning the difference between an outdoor lighting colour temperature of 2,700 Kelvin or 3,000 Kelvin, and she prefers 2,700 as recommended by Mr. Mackenzie, and DOC also supports that colour temperature limit. I understand that point is simply about the availability of these bulbs and what's easy to source. I understand from the experts that there's not a significant noticeable difference in the illumination or the warmth. I think it is. This is dealing with warmth, light. So I don't know that there's a really big issue with the difference between 2,700 or 3,000, but I think it's about the ability to actually find
But all
bulbs.
the experts go for 2.7 rather than 3, and the Section 42A authors disagree. That's the nub of it, isn't it?
Yeah, and I'm not even sure whether there's strong disagreement on that point. It may just be that it was just a question of what's practical. So again, I don't think there's a fundamental issue here with the effects difference between 2,700 and 3,000 Kelvin. I think was just a practical question of whether people get their hands on these bulbs. But
same argument that runs about climate change, isn't it? It's hard to do. Yes.
Yeah, well, I guess my other observation would be that if the rule is set at 2,700, the market will respond.
Yes.
And they'll become easier to source.
Yep.
So.
Yep. I guess I'm just signaling that we would like to hear some evidence as to what the problem is. From I guess that may. I mean, if that remains an issue, we may need to hear from a lighting retailer or something on that matter.
So dealing with sort of the critical outstanding issues, of the 140 submitters on the topic, only 5 lodged expert evidence. Firstly, Fonterra, who lodged evidence from Mr Crisp, confirming its support for the recommendations in the planning report to delete part of SNA C59 from the northeastern part of the Te Rapa site as shown in Annexure 1 to the joint witness statement, and in his planning evidence. Mr Dean's evidence acknowledges that in accordance with an exemption in the RPS criteria concerning vegetation that's been created in connection with artificial structures, planning decision was made during expert conferencing to exclude the areas as directly associated with water control structures and ponds on the Fonterra site. He recommends that the remaining area of C59 that are not associated with the structures be retained, and he's shown the amended mapping attachment 1 to his evidence. Te Awa Lakes seek removal of SNA C59 and C76 from the land it describes as Horatu East North and Horatu East South. Discussions and a site visit relating to the submission occurred after expert conferencing. Ms Gold has reviewed and supports Mr Dean's recommendations to amend the SNA boundary to exclude the area where vegetation removal has already occurred and the area covered by track for SNA C59 and C76 as shown in attachment 1 of Mr Dean's evidence. And in respect of the submission point seeking the removal of C59 pines and C76 riparian vegetation which still physically exist, as advised by the ecologist, the ecological values warrant protection through SNA mapping. Subject to one matter of clarification to be made by Mr Dean, Ms Gold and Mr Dean agree that areas 2 and 4 on the Te Awa Lakes site should be retained unless the vegetation and the ecological values are guaranteed to be removed. Just a point about this, I mean, I think it all sounds awfully complicated and it's not. The point is that these sites are subject to resource consents that are held by Te Awa Lakes, and those resource consents enable vegetation clearance. And that vegetation clearance includes areas which have currently been mapped as SNAs. So you've got, on the one hand, you've got the ecologists have looked at the vegetation which exists and have said it's got ecological values that warrant protecting as an SNA. And then you've got Te Awa Lakes saying, what's the point? I've got a resource consent to clear it. And so the approach that's been taken by the city is to say, well, look, to the extent that you have actually cleared the vegetation, yeah, there's certainly no point. If you've exercised your consent, at least partially, and you've cleared the vegetation, then we get it. There's no point in continuing with the mapping. But for the areas where the vegetation exists, we can't stand in judgment of whether the consent will be fully exercised, and if so, under what particular conditions. So it really is for Te Awa Lakes to make the running in front of you on this point and convince you that there's just no point. But that feels like it's an evidential burden that sits with Te Awa Lakes.
Just practically, if the current provisions are adopted, would that then require Te Awa Lakes to apply for an additional consent? Or is there existing consent? Would that cover the removal?
Yeah, there's an existing resource consent, so you have your consent.
Yeah. So you don't see that imposes any additional burden on them? I mean, that's the issue, isn't it, for them?
Yeah. I mean, that's the way a land use consent works.
Yeah, well, that's what I would have thought. Yes. Yeah. And if they don't exercise the consent, well, it stays anyway.
Well, then it stays.
Yeah, all right.
Just a follow-on question from that. Do we have any idea of whether the consent allows the clearance of all of the area of SNA that's covered by the consent, or is it only partial? I couldn't see a plan anywhere as to what was covered and what wasn't.
I haven't undertaken an investigation of the relevant consents and the conditions. I mean, I imagine that the vegetation clearance, for example, will be subject to a vegetation management plan of some sort. That management plan may or may not produce an outcome which says that actually there's some parts that could be retained and potentially should be retained, in which case the SNA might still be relevant. It just feels like there's some detail to be picked through here. And that it's for Te Awa Lakes really to present not only the detail of the consent, how it intends to implement it, but any of those other relevant management plans and so on.
And in terms of just picking up on the Chair's point about the existing consent, I guess the SNA would bite, if you like, if they were seeking to vary the existing consent that they hold, so then they would be held
Yes,
to a...
that would bite at that
Yes.
point.
Yeah.
Yep. Or if there was a lapse.
Yes.
Yeah.
Yep.
Thank you.
The Eisendawn matter is, again, is one of these sort of site-specific, slightly curious situations. They're seeking the removal of the SNA over 29 Petersburg Place in Flagstaff, and they've provided both planning and ecological evidence to support their submission. Ms Gold agrees that the SNA should be removed from the area over which there is an easement which restricts planting. However, she disagrees that there should be any modification to the SNA extent on the basis that the submitter has applied to the City Council for a resource consent to establish a duplex dwelling on the site. Now, the planning issues on the site are slightly complex. There's a strong opposition from neighbours to the application, which has been slow to progress, and the hearing is yet to be scheduled. Mr Dean and Ms Andrews have assessed the planted indigenous vegetation on the property as significant, and Mr Dean considers that these ecological values do warrant protection. So accordingly, other than on the easement area, neither Ms Galt nor Mr Dean support removal of the SNA from 29 Petersburg Place. Now again, just a little bit more background on this one. There's a zoning anomaly in the sense that it's zoned, I think, open space, but it's a small lot in a residential area in private ownership. You know, the Eisendawns purchased it with that zoning understood, and now they're seeking a dwelling. I guess it's a non-complying activity status dwelling for the property, and so that application has been around for at least a year, back and forth, tidying up certain Section 92 issues and revisions and so on. And I understand it's sort of back and at some point is going to be heard, at least in the sort of medium-term future. And so their argument is, well, we've got a resource consent application in with council, we've got a land use activity proposed for a duplex dwelling. The last thing we need is an SNA across the property when the application comes to be heard. And okay, that's their argument. Council's argument is that the site has ecological values that warrant protection. And it may be that it complicates the assessment of the resource consent application. But
yeah. And the SNA values hold regardless of there being a hole in the middle, I take it?
that is the evidence, yes.
Yeah.
That's the evidence.
And just the dwelling they're seeking to put on their lot, is that within the SNA area? Do you?
Yeah, there is an overlap. Yeah, I mean, I think there's parts of it. I think the footprint is intended to, to avoid it, but there is a loss of vegetation.
So just to scaffold onto that one, the application for the duplex, does that also include an application to clear a certain extent of vegetation to enable the duplex to be situated there? I mean, are we talking the whole SNA across the site or just part?
I think it's just part. I'd have to go back and remind myself of whether or not the necessary vegetation clearance was triggering a consent. I just can't recall. It was? Yeah, I'm told it was.
Right.
Okay, so turning to DOC. So the DOC submission is supportive of the PC9 approach to increasing the level of mapping of SNAs in the city. However, it does seek a small number of changes relating to the noise, lighting, unmapped SNAs and the notification rules. And it's provided ecological and planning evidence in support of its relief. Regarding noise, Dr. Kerry Borkin's ecological evidence refers to recent research that noise may adversely affect long-tailed bats and their usage of habitat, and recommends that noise controls be introduced under PC9. Dr. Mueller acknowledges that the research in this area is still emerging and there is currently insufficient evidence available to fully understand the effects of noise or to guide the implementation of effective controls, limits and potential mitigation measures. As Ms. Galt states in her evidence, it would be challenging to implement such rules within an existing urban environment. Further, in developing PC9, no consideration was given to introducing noise standards, which raises doubt as to whether such relief would be on PC9 in terms of the Clearwater test. But regardless of that scope question, dealing with the merits, Ms. Galt considers that further work and research is required to understand the effects of noise on long-tailed bats before any changes are made to plan provisions controlling noise in an existing urban environment. So accordingly, HCC does not support any amendments to address the noise effects within an SNA. Just on this point, I mean, there's a similar issue in relation to controlling lighting. I mean, putting aside for a moment the first point, which is that the city would say there's just not enough developed empirical evidence about this noise issue in relation to long-tailed bats to be able to safely establish a noise limit that works but doesn't overreach, for example. So we say that the issue still needs refining. But even if those uncertainties weren't there, we still have this challenge with introducing noise controls into an existing urban area. So what you'd be doing is you'd be controlling the amount of noise that can be emitted from a new land use activity, a new dwelling, when the neighbour wouldn't be subject to the same noise control. So there's a real practicality problem with controls of this nature. Lighting has the same characteristic, but is probably just a little bit less difficult to manage, because you can discern where light is coming from in a way that noise can sometimes be a little bit less easy to discern. But we certainly see from this noise, on this noise issue, we say we just don't yet have enough good information to determine what would be the appropriate control anyway, and even if we did know what it was, imposing it into an existing urban environment with noise sources operating under different noise controls, it just feels very, very, very challenging.
I was just going to ask, are there any SNAs that in actual fact aren't surrounded by existing urban environments where in actual fact a noise control might be feasibly imposed?
We'll look.
Yeah,
I suspect not. I mean, these are existing urban environments.
That would be my presumption.
Yeah,
but it would be interesting to know whether in actual fact there is a discrete one somewhere where that might apply.
Yeah, I mean, they will all be, I suspect, in existing urban environment, or at least adjoining. There'll be open space zonings adjoining mostly residential areas.
Yeah.
But possibly even some industrial areas.
My question was just on the scope issue. So you've obviously addressed the merits. There isn't a sufficient evidential base at this time to determine what those provisions might be and look at the workability. And then you've said to us that there's also potentially a scope issue in terms of Clearwater and it not being on the plan change. What about the second limb of Clearwater? Do you think there's an issue there as well, and people not reasonably being able to anticipate that noise controls could be brought in to address that issue?
Yeah, I think that's a problem. There's no question. I mean, I haven't sort of gone there on the scope point too hard in the submissions, because I sort of felt that even if you just accept for a moment that we don't have a scope problem, I think there's a real merits problem at this point. But no, coming back, I mean, I certainly don't want my lack of detail on scope in my submissions to indicate that I didn't genuinely feel there was a problem. I think there's a major issue with Clearwater. I mean, I think if you objectively looked at the SNA topic, who would have thought there was a new noise control rule coming with the plan change? It just feels right out of left field. As Justice Koch described it in Motor Machinist, a submissional sidewind. Yeah. So turning to lighting, Dr. Borkin's evidence is that a lower lux limit of 0.1 lux at an SNA boundary rather than a 0.3 lux would further reduce potential adverse effects on bats associated with artificial lighting. This is acknowledged by Mr. McKenzie. However, he considers that it is impractical to implement in an existing built environment. Instead, mitigation measures are proposed to achieve the minimum light spill practical. There's a lighting rule in the 42A report recommending a maximum colour temperature of the 3000, and we've talked about the 2000, and we understand, as I say, that that's just simply around some practicality. So that outdoor lighting rule that Mr. McKenzie is recommending, we say should control adequately the effects of any new land uses introduced. DOC also seeks an amendment to that lighting rule to reduce the security lighting duration from 5 minutes to 1 minute. Dr. Mueller states in her evidence that there's no scientific evidence that shows that the length of motion sensor timers minimises effects on long-tail bats. The amendments are not supported by Mr. McKenzie or Ms. Gold. DOC also seeks that the additional areas that meet the SNA criteria for significance under the WRPS, such as the black mudfish habitat, be mapped under PC9. And it seeks new policies in Chapter 20 to recognise areas of significant indigenous vegetation and habitat on indigenous fauna, and account for unmapped areas of significant indigenous biodiversity. Ms. Galt considers the policies to be unnecessary as the existing provisions sufficiently cover these matters, and that the mapping of mudfish habitat has not been undertaken, and the SNA mapping cannot occur without it. More fundamentally, however, it's not within the scope of PC9 to map additional areas relating to mudfish, and as the court described in Western Lee, the SNAs will be progressively mapped and introduced via successive plan change processes. I mean, just on this point, the DOC submission, as I understand it, is that it's basically, the proposition is, well, you just haven't gone far enough. There's other areas within the city that you should have mapped, and it points to black mudfish, but also in its evidence and submission says, well, it's not just about black mudfish, there are other things as well. But the problem with the DOC proposition is that, you know, we can readily accept that there could be more habitat and SNAs that could warrant protection, but the work needs to be done. It's very easy to just simply say, oh, you haven't gone far enough, but do the work. Firstly, if we take black mudfish, for example, this would require mapping of the habitat. Black mudfish are notoriously hard to find. They are there. They're obviously a threatened species. That might be part of the reason. But they're existing in farm drains and on private land in parts of the city that you know haven't been mapped. So the habitat has not been defined. And without the habitat being defined, we can't then map the SNA. And certainly not without engaging in a whole lot of excitement from landowners who say you got your boundary wrong. So there's just so much to do to give DOC what they're looking for here, and the work needs to be done.
Was this brought up during expert conferencing?
I don't know, I wasn't there.
It was?
Yes, it was.
Well, we've got yeses and nos. Was for Dr. Mueller, do you recall this? It might have been done in the planners, but was it done in the...
There wasn't an inverted logic,
Yeah, well, last doc anyway. I mean,
But
it does seem as though it's emerged subsequently.
the short point for the city is, look, we don't necessarily disagree,
Yeah.
but there's work to be done.
Yeah, pick your fight.
It would be very difficult for you. I just simply say you just wouldn't have an evidence, even if you had scope. Again, let's say you had scope, you just simply do not have an evidential basis to identify some habitat and get it mapped as an SNA in relation to these extra areas and species.
I just have a question before we move on. You've said in there, Ms. Galt considers the policy to be unnecessary as the existing provisions sufficiently cover these matters. So I guess in the absence of this mapping, we're not left with a lacuna in the plan where if there is mudfish habitat discovered, that they can't be protected or can't be given appropriate consideration through a consenting process, etc.
That is exactly the point. I think that, we're not dealing with a situation where these issues aren't captured through some other means. So there'll be regional consents. If we're dealing with watercourses and anything relating to amendments to those watercourses or removal, you're immediately engaging in regional council consenting processes where the black mudfish issues would be addressed. So yeah, it's not as if the issue goes unaddressed.
Yeah. I'm going to be helpful in due course for Ms. Galt to just take us to where she thinks that's covered off. It's also because we'll have that conversation with Doc later on, obviously.
And then just finally on the Doc submission, Ms. Galt doesn't support the request in Ms. Sycamore's evidence to change figure 1.19a to make Doc an affected party to be limited notified in relation to activities that are restricted discretionary activities. The amendment was not supported in expert conferencing by the parties, nor is it supported by Ms. Galt. In practical terms, the flowchart simply does not apply to the activities, the subject of Doc's submission, which have non-complying status. Ms. Galt considers that Doc should be satisfied that any non-complying activity that causes a minor or more than minor adverse effect on bats or any other threatened or at-risk indigenous fauna will be evaluated under section 95 in the usual way, which will ensure Doc is a notified party where appropriate.
Just a question on that. Are there other parts of the plan where you do have certain parties like Doc identified as parties that need to be specifically notified?
Well, yes, that rule that's referred to there, it's a figure 1.19a. That's a flowchart that you'll find, and it's actually, I think it might be illustrated in Ms. Galt's evidence, but we can get it to you. It's a flowchart and it's a notification flowchart, but I think it relies only to restricted discretionary activities, but it does have automatic defaults to notification for certain parties. So I think there might be a particular activity that automatically captures Waka Kotahi. There might be another one that captures Kiwi Rail.
And historic places.
Hamilton Airport, Heritage New Zealand. So there is a rule which does deal with that. And basically what that submission point from Doc is doing is it's wanting to get into that figure and be a notified party. But as we say, it's a figure and a flowchart that relates to restricted discretionary activities and won't apply to the things that Doc's concerned about. So just now moving through to the Adair Company, they've provided planning evidence from Mr. Inga, and he confirms that many of the issues addressed in the Adair submission and further submission have been satisfactorily resolved in the 42A report. There are a small number of matters that he supports different or further changes as follows. There's some proposed wording for the explanation following the objective and policies for the long-tailed bat, where Ms. Galt supports the inclusion of the explanation, but she's made slight amendments to what Mr. Inga was suggesting. And there's some numbering corrections following activity table 20.3, which Ms. Galt agrees with, and they're just minor administrative matters. Mr. Inga is seeking deletion of the Eurobats guideline and the explanation which follows the objective and policy for lighting and glare. And Ms. Galt disagrees that the reference should be removed on the basis that it makes the provisions less clear, and so she has no objection to its inclusion. And there is proposed deletion of the reference to best practice guidance for offsetting and compensation and the information requirements, which Ms. Galt disagrees with and considers it's appropriate. To the lay presentation, so of the 140 submitters on the topic, there's a comparatively small number have indicated they wish to present at the hearing. And so again, without pre-circulation of their evidence, it's difficult to provide a comprehensive account and response. But we've attempted to provide a bit of a summary for the panel in terms of navigating the key issues. So firstly, there's Patricia Morgan, whose submission seems to express concern about her garden being identified as an SNA, and Mr. Dean has recommended that the SNA extent to be amended to exclude the garden and lawn. There's Mr. Gillespie and Ms. Breen, submissions seeking strong protection for the natural environment and restoration of degraded areas, which is exactly what PC9 intends to do. And so hopefully there's no residual concerns in relation to that submitter. Michael John and Julia Griffin, a submission seeking no plan change to our property. Some of the states that the SNA is not justified as there's no native trees in the area, covered in gorse and blackberry instead, and concerned about impacts on property values. and Mr Dean has made a recommendation that the boundary include a slight adjustment to exclude a paddock area and to follow a fence line. Mary Burden and the Landscape Design Studio. This submitter supports the protection of SNAs on public land, but opposes it on private land, including in respect of her land. The submitter opposes restrictions being placed on the large gully section, and Mr Dean recommends that the SNA be retained as notified. He notes that it includes some open grass areas, but the overall ecological value is consistent with the rest of the SNA. Mr Karatis seeks that the SNA over his property be removed. He's opposed to the restrictions that are imposed, and Mr Dean recommends that it be retained as it has established indigenous vegetation connected to important bat habitat. Mr and Mrs Sharps have made a detailed submission on the topic. They support greater biodiversity protection, but they're concerned with the restrictions on maintenance and pruning within the SNAs. They have a property at 48 Amanda Avenue which adjoins an SNA, and they say that if it's unmanaged it presents a risk to life and property should vegetation fall on the dwelling, and they've challenged the classification given the number of exotic species included. Mr Dean recommends that the boundary be adjusted to follow the property boundary so that the gardens along the edge of the SNA are excluded. Mr and Mrs Paris at 27 Keswick Crescent are seeking the removal of an SNA from their property, and Mr Dean has recommended that the SNA boundary be subject to a small adjustment, but doesn't support deletion, obviously, of it in its entirety, all the rules. Stephen Gale seeks removal of the SNA from the property at 1858 Victoria River Road, given its garden and not indigenous natural vegetation, and Mr Dean recommends it be retained. There's the Kaga Mactan Property Trust in relation to a property at 913 River Road, where they say that if HCC needs to maintain the area and prevent further erosion and deterioration, and seeks that SNA C54 be removed from Tauhara Drive as shown in map 2, and Mr Dean recommends that the SNA be retained as notified. Mr Williams at 440 Peacock Road seeks that the HCC forfeit rates on any portion of land declared to be an SNA, or that it pay for the land to be taken as SNA, or reimburse works undertaken by private landowners to improve the SNA. And Ms Gold, in her evidence, considers that those are matters that are outside the purview of PC9 and are not part of HCC policy. Mr Williamson at 7 Opal Place, Chartwell, again concerned that there's no indigenous vegetation on the property. Mr Dean recommends that it be removed. He states that the area is weedy and connected to a recently cleared gully arm and has little visible ecological value with no corridor or buffer value. Mr and Mrs Nielsen are seeking removal or amendment to SNA C78 at a property at 1877 River Road, so that it applies to the land and vegetation that is an SNA, ground truthed, and that there be amendments to the rule framework to reduce constraints on what can occur. Specific amendments haven't been provided, but Mr Dean recommends a minor adjustment to the SNA to exclude certain fruit trees on the property. And then Ms Vanderpoel at 11 Ballock Street seeks removal of the SNA, and Mr Dean seeks to retain it as it includes wetland vegetation and values that are consistent with the rest of the SNA and the gully. Then of the remaining submitters who have indicated they intend to present, again without the benefit of evidence, it's difficult to accurately capture exactly what the relief is in the response, and I've set those out. And so really just in relation to those matters, we just reserve our position to come back to you if we need to. In respect of the submitter seeking removal or alteration of the boundary of SNAs over particular properties, except for the Eisendawn and the Te Awa Lakes submitters, none have provided ecological evidence in support of their challenge to Mr Dean's recommendations. And while the evidence of these lay submitters or witnesses is helpful to the panel in its deliberations on matters of ecology and biodiversity, the panel should place strong reliance on the evidence of Mr. Dean and Dr. Mueller. I should just qualify paragraph 51 to acknowledge Doc, and I omitted to do so there. So in conclusion, Hamilton City is fortunate to have substantial areas of land with high ecological values, much of which supports nationally threatened or at-risk species. The revised and expanded ECNA provisions proposed in PC9 represent a major step in the city's ongoing efforts to ensure the protection of these areas of significant indigenous flora and significant habitats of indigenous fauna. Inevitably, this additional protection impacts both public and private property, and where private property interests are affected, PC9 seeks to minimise that impact while ensuring that the necessary protection is afforded, and the city is confident that PC9 strikes the appropriate balance. Subject to any minor modifications which are justified on the evidence presented to the panel, Hamilton City seeks that the panel's decision be to approve this topic of PC9. And then just to the evidence, we'll hear firstly from Dr. Mueller on ecology. She was mostly responsible for identification of ecological values, particularly so far as it relates to the long-tailed bat. And then we'll hear from Mr. Dean, who was principally responsible for the mapping exercise. And then from Mr. McKenzie, who will deal with that relatively narrow lighting issue for you, and then wrapped up with the planning evidence of Ms. Gold.
Thank you.
Just a further question on scope from me. So there's been some submissions, I think I saw reference to in your legal submissions, that are seeking the removal of all SNAs, that's correct? So we've got a relatively broad scope, I guess, if we make some factual findings, putting aside the merits at this stage, but a relatively broad scope to remove areas of SNA based on what's in submissions. Have there been any submissions seeking a wholesale extension of SNAs? Or is it just sort of the DOC submission that's seeking the additional SNAs for particular indigenous species?
Yes, I think that's probably the main one that has sought the extension on the basis that the city hasn't gone far enough. I'll do a trawl through of the submissions and see if there's any others that have sought broader, more extensions to SNAs. Come back to you on that. I mean, you're obviously interested in terms of defining what your scope is and isn't. Yep.
Thank you.
Okay.
Thank you, Mr. Muldowney.
Thanks, sir. I'll hand over to my learned friend to introduce some evidence.
Thank you. Hamilton's first witness is Dr. Mueller. I'll ask you to come up and sit next to me. Get you to confirm that your full name is Dr. Hannah Mueller, and you are the Principal Ecologist and Director at Phoenix Ecology Limited.
That's correct.
And you have provided a statement of evidence dated 14 April 2023 and a rebuttal statement of evidence dated 12 May 2023.
That's correct.
And to the best of your knowledge, both are true and correct.
Yes.
I'll get you to read the executive summary of your primary statement and then proceed to read your rebuttal statement.
Thank you.
Well, Dr. Mueller, again.
Good
Yes.
morning. Okay. I have been involved in the review and identification of SNAs on behalf of Hamilton City Council since 2021. Mainly providing high-level technical inputs and project management support in the initial phase of reviewing the original SNA dataset, which informed the notified version of PC9 to the operative district plan. The current SNAs within the ODP cover only areas of indigenous flora and do not necessarily include areas of significant habitats for indigenous fauna. PC9 addresses this gap by extending those SNAs to include other vegetation or areas, predominantly in gullies and along the Waikato River, that are the habitat for several threatened and or regionally uncommon indigenous fauna species, notably nationally critical long-tailed bats. I have been directly involved in the review of submissions on PC9 and have co-authored the technical report dated 8th March 2023, which responds to submitter issues. I also attended expert conferencing and have reviewed the evidence for HCC relating to the final set of proposed S&A provisions within PC9. I support the addition of further provisions to limit the effects of light intrusion of any new lighting on an S&A as recommended by Mr. McKenzie for HCC. In particular, I support controls on any additional lighting, screening and building setbacks to ensure additional lighting effects on S&As are minimised. I support the further changes to the provisions that address what activities with respect to public access to S&As, for example, walkways or cycleways, are appropriate. These infrastructure types should be controlled in a way that there is no additional light intrusion into S&As and that no future conflicts are created between public access and the requirement to protect potential bat habitat or potential bat roosting trees. I recognise that mudfish habitat is currently unprotected where habitat falls outside of identified S&As, such as farm drains. While there are some rules and regional policy provisions addressing mudfish, there is uncertainty with respect to where mudfish are located, which requires addressing. Once that habitat is identified with greater certainty, it is my view that further steps, including a plan change to extend the proposed S&As, would be appropriate in order to protect mudfish habitat. Within the PC9 provisions, I recommend the inclusion of reference to best practice offsetting and compensation guidelines to provide clearer guidance on biodiversity offsetting and compensation as part of effects management of any new resource consent applications that have the potential to adversely affect S&As. I'm moving to the rebuttal evidence.
Okay.
The purpose of this rebuttal statement of evidence, which is provided on behalf of Hamilton City Council as Plan Change 9 proponent, is to briefly respond to ecology comments in the statements of evidence of Dr. Kerry Borkin for ecology and Ms. Ashley Sycamore Planning on behalf of the Director General of Conservation, and Mr. Chad Croft for ecology on behalf of Te Awa Lakes Incorporated joint venture. My responses are limited to lighting effects, noise, vegetation removal, and bat habitat. For Dr. Kerry Borkin, paragraph 13.6, noise. It is my understanding that the recent research into the effects of noise on long-tailed bats explained by Dr. Borkin shows the potential of noise to negatively affect long-tailed bats and the usage of habitat. I acknowledge these research findings and agree that if we were to apply the precautionary principle, noise in significant natural areas should be limited as much as possible to avoid adverse effects on long-tailed bats. However, I know that the research in this area is still emerging and there is currently insufficient evidence available to fully understand the effects or to guide the implementation of effective controls, limits, and potential mitigation measures. In addition, it is my understanding that in the context of PC9, it would be challenging to implement rules to limit noise in S&As within an existing urban environment. This matter is addressed in the planning evidence prepared by Ms. Laura Gold. Paragraph 14.5, lighting temperature limit. Applying the precautionary principle, I agree that a maximum colour temperature limit of 2,700 K rather than 3,000 K would be preferable to minimise adverse effects on bats associated with artificial lighting. As Dr. Borkin explains, current research on long-tailed bats suggests that lighting has adverse effects and that warmer colour lighting may reduce these effects. However, I note there is no explicit research showing that 3000 K, which is a relatively warm colour with limited blue components, would have adverse effects over 2700 K, and that research shows that blue filtered light, 3000 K, only has a limited amount of blue light in its spectrum, is preferable over white lighting tones with high amounts of blue light. Accordingly, until further evidence becomes available, I am comfortable with 3000 K colour temperature limit with a 3000 K colour temperature limit for outdoor lighting within 20 metres of an S&A. Paragraphs 15.1, 16.3 and 22.1 light spill. Based on international research, I agree with Dr. Borkin that a lower lux limit of 0.1 lux at an S&A boundary rather than 0.3 lux would further reduce potential adverse effects on bats associated with artificial lighting. The 0.1 lux limit at the SNA boundary may also be more aligned with the lighting controls imposed at the Amberfield subdivision as part of the Western Lee Environment Court decision, which included a 0.3 lux limit at the property boundary and a 5-metre setback at this boundary from any bat habitat. Based on the Western Lee approach, if lower lux limits at the SNA boundary are not provided for, building setbacks for any additional buildings could achieve the same goal of limiting light intrusion into SNAs. Paragraph 19.1, sensor timer. I am not aware of any scientific evidence that provide guidelines on the length of motion sensor timers with respect to minimizing effects on long-tailed bats. However, to achieve as little artificial light intrusion as possible, a shorter sensor timer would obviously be preferable. Whether the shorter period proposed by DOC as material is unknown. Paragraph 20.8 and 20.13, tree removal. I agree with Dr. Borkin that bat habitat, in particular suitable potential bat roost trees, are limited within the Hamilton City urban landscape, and that preserving as many mature trees as possible, as well as encouraging succession, is critical to preserving habitat for this species. A reduction in the amount of tree removal enabled within SNAs would further minimise the risk of removing known, undiscovered or potential roosts, and contribute to maintaining functionality of habitat for bats. Paragraph 22.2, setbacks. As I discussed in paragraph 12, depending on lighting controls, wider setbacks may need to be considered to further reduce light intrusion from residential housing into SNAs. It is my understanding that current provisions would result in 0.3 lux at the SNA boundary, but only assuming curtains are closed to minimise lighting. Wider setbacks and or buffer plantings may be more suitable tools to achieve the objective of reducing lighting impacts on long-tailed bats. Paragraph 23.3, infrastructure and structures. My main concern with respect to the installation of additional infrastructure or structures in SNAs, assuming no lighting is installed and no vegetation removal is required, is the incompatibility of the nature of potential bat roost trees with ensuring safe public access. Bat roost trees are often mature, failing trees with broken features. This means that over time, potential bat roost trees may require removal to ensure safe usage of infrastructure. In my view, this is not in alignment with the objective of identifying and protecting SNAs as Indigenous fauna habitat. Now moving to Ms. Ashley Sycamore's planning evidence. Paragraph 24, lighting temperature. As I discussed in paragraphs 8 and 13 above, applying the precautionary principle, the adoption of 2,700 K instead of 3,000 K and a lower motion sensor timer limit would likely be preferable from an ecological perspective. However, there is a lack of precise scientific evidence informing these numbers and uncertainty regarding the level of materiality. If sufficient setbacks of any new buildings are provided for, the existing lighting controls should be adequate to minimise any additional light intrusion into SNAs. As I discussed in paragraph 16, current light intrusion into SNAs may be insufficiently minimised by the existing controls, and a widening of the setback for new development instead of further lighting restrictions would likely be one option to minimise any new effects. Paragraph 25, setbacks. I agree that if the effects of any additional lighting on SNAs are not otherwise controlled, buffers, i.e. setbacks and or planted screens, could be introduced to minimise effects on potential bat habitat in SNAs. Paragraph 29, noise. I have addressed the issue of noise above. I agree that noise effects on Indigenous fauna and SNAs should be minimised. However, as I discussed in paragraph 7, the research in this area is still emerging, and the challenges with respect to the implementation of noise rules in an existing urban environment are not an ecological matter and are addressed by Ms. Gold. Paragraph 46, mudfish. As I have discussed in my primary evidence, all mudfish habitat meets SNA criteria and should be formally protected from further degradation and habitat loss. The scope to introduce mechanisms for protection of these areas in PC9, whether mapped or otherwise, is not an ecological matter and is addressed in the evidence of Ms. Gold. Lastly, evidence of Mr. Chadcroft for ecology. Paragraph 7, S&A on the TAL site. It is my understanding that areas 3 and 5 have already been removed from the data set as vegetation present in these locations has been removed, which I have confirmed during a recent site visit. Area 2 is a stand of eucalypts that has the potential to provide for bat roosting. It is also contiguous with the remaining S&A and the Waikato River riparian vegetation. I understand from communications with Ecology New Zealand that bats have been recorded at the site recently. Bats are also known to be present in the wider landscape and along the Waikato River corridor. Area 4 forms part of the Waikato River riparian vegetation and in line with the S&A assessments across the city forms a critical component of buffering the river system and providing a corridor to enable the movement of indigenous fauna species. Therefore, all areas that have not been subject to vegetation clearance to date fulfill an important function of buffering and providing bat habitat, including foraging and potential roosting. They do provide critical habitat and have correctly been identified as S&A for these functions. Conclusion, the current PC9 plan provisions proposed by HCC provide a robust framework to identify and protect S&As from urban encroachment, including controls on lighting, setbacks and vegetation clearance. Applying the precautionary principle, further protection of indigenous fauna and S&As, particularly bats, could be provided through additional controls with respect to lighting, setbacks, buffers, noise control and vegetation clearance. However, the benefits are not quantified. If the panel is seeking increased mitigations, a key consideration may be the widening of the currently proposed building setbacks for any new buildings to further minimise their effects, including cumulative effects on S&As. I understand that some of these additional controls have implications in a planning context and may not be practical, which is discussed in Ms. Galt's evidence.
Thank you, Dr. Mueller. Please answer any questions.
Thank you, Dr. Moon. You? No? Yep.
Thank you, Dr. Mueller. I just have a few questions for you. In your evidence, you talk about the, I think it's a reference to the protection of the corridor SNA as being unusual throughout the country. I was just wondering whether you were aware of any other councils where they have followed a similar approach to what's being put forward now?
I am not aware of that approach having been taken anywhere else in the country. There are some bat habitat areas or zones that have been established, I think, in Timaru. I'm not very familiar with that legislation though, so I can't give much detail on that. But in terms of setting aside vegetation that's predominantly exotic dominated in parts for fauna values, I'm not aware of it, but that it may exist, but I haven't come across it.
Thank you. And I think you said before the difference between the 2,700 and the 3,000, that there's insufficient research as to whether or not that's material. Is that right, or is your view that it isn't material? But yeah, I wasn't quite clear.
Yep, apologies if that wasn't clear. It's just that we don't have any evidence that it is material. It may well be. It just hasn't been studied to that level of detail yet. Obviously, as I said, the precautionary principle says that the less, at the moment, our understanding is the warmer the colour temperature, the better for bats. It's just whether that difference between those two particular numbers makes a big difference for bats. We don't know, but if you want to be on the safe side, then less is better.
I mean, what's your advice there? Because, I mean, what we're dealing with is a nationally threatened species. And as pointed out, Section 6 matter.
Yep.
So, where there is a doubt and where there is uncertainty, which way do you think we should go?
Well, I mean, the precautionary principle
it's not just the light issue.
Yeah, the precautionary principle is not technically part of the RMA, but if that's what we want to adopt, which with a critically threatened species might be advisable, then of course going with a lower value might be advisable to, err on the side of caution. Yeah.
And that advice also pertains to noise and the other characteristics that you've noted are not yet scientifically knowable, but are in the frame anyway.
Yeah, in principle, absolutely, that would be the same approach. Yep.
Okay.
Just a couple more from me. I think in para 11 of your rebuttal, you referred to the 0.1 lux limit being more aligned with Amberfield. I can't remember now. Was that same limit adopted in PC5 or was it the 0.3?
I don't know all of the rules at the top of my head. I think there were some differences across the plan change, depending on whether they were immediately adjacent to a bat habitat area, whether they were part of the wider PC5 area, but I would have to look into that to be sure, yeah.
And then in para 12, and I think later on, you talk about if lower lux limits weren't provided for building setbacks could achieve the same goal. And I think you talk later on about, you know, sufficient setback. What is a sufficient setback? Are we talking the 5 metres, which is what was adopted in the Amberfield, or is that something that Mr. Mackenzie comments on in detail?
Yeah, Mr. Mackenzie will be commenting on that. The Amberfield case was a 0.3 lux limit at the property boundary and then a 5 metre setback and then the bat habitat area, whereas as it's currently proposed, we have a 0.3 limit at the boundary, which is effectively the bat habitat area.
So boundary
it's
with
like,
the SNA.
Yeah, basically. So, I mean, if it was to reproduce what Amberfield did, it would have to be that 0.3 limit at the property boundary. Well, what was meant to be achieved was a 0.1 limit at the boundary of the habitat. So we would have to lower the 0.3 to 0.1 basically, and that could be achieved by pulling back any light emitting infrastructure, i.e. houses, a little bit further back, and Mr. Mackenzie will be able to talk you through exactly the values that would have to be talking about. It's not my expertise, but yeah, basically just pulling it back further.
The issue we've got in this is that, you know, with Amberfield and with Peacock, we were dealing with greenfield areas for subdivision, so we could actually look at having those additional setbacks, whereas here we're in an existing urban environment where there is already houses.
That's correct. So all that can be controlled is any additional lighting. That, and we can't pull back existing housing, obviously.
And in your para 15 of your rebuttal, you talk about the reduction in the amount of tree removal enabled. Are you able to expand on that? What sort of reduction would you be looking for beyond what's already been incorporated in the...
Well, I mean, as an ecologist, obviously any tree removal should be avoided if it can be, if it's safe. I know that's a really vague answer. But we, like, from a purely ecological perspective, really, there should be no tree removal that isn't required, say, for controlling invasive species, like plant species, pest trees. Yeah. There's an ecological ground for that, but unless they are actually invasive species, if we're wanting to protect what could potentially be or turn into bat, especially roosting habitat, then we want to minimise as much as possible the removal of any additional trees, just because we have lost so much habitat from the landscape that every single tree is in fact really important in the Hamilton City context.
And then at your para 17 of your rebuttal, you talk about buffer plantings could be more suitable tools to achieve the objective of reducing lighting. Again, are you able to expand on what sort of extent of planting buffer would we be looking at, or is that a Mr. Mackenzie question?
It's probably a combination. There is some examples of buffer plantings that have been implemented as part of the Amberfield decision. There were some requirements around height levels to be achieved and sort of cover, like vertical cover of density of the plantings, so that ensures that lighting can actually be filtered out by it. But the intent is basically to use a combination of setbacks and or screen planting to filter out light before it gets to the SNA habitat area.
And then I guess just the final question from me is, you've talked about setbacks, controls on lighting, such as the the warmth of the bulb, the 0.1 lux versus the 0.3, and planted buffers, are they alternatives or are they things that you're recommending to us that we should have all of them? So we should have the setbacks, the controls on lighting, as well as the planted buffers, or are you satisfied that just one or the other would be okay?
I guess as long as we can achieve minimising, if we're talking about lighting, minimising light intrusion into the SNI to the 0.1 limit, which is basically as low as we can go, which is sort of the lowest measurable light, additional lighting, then I think it might need to be a sort of site-by-site determination which of those controls are most appropriate. I think my understanding is that it is easier to implement and potentially also control things such as setbacks rather than lighting, because just by the very nature of having a consent that has some lighting controls on it, it's probably easier to just pull back buildings and that's where they are, rather than trying to measure or figure out what lighting is actually emitted once everything has been consented and built. So I think I would have a slight preference for that reason to rely more heavily on setbacks and perhaps a little bit of screening rather than the actual lighting controls.
Just following that one up, I was just trying to find where the lux boundary limit is actually set. Whereabouts is that? Is it set? I don't think it is set. Is it in the provisions?
The 0.3
Yeah,
limit?
well, the 0.3, 0.1, whichever it is. I'm just looking for it.
I
No,
don't know
I don't
that
think
at the
there
top of
was
my head either.
So I mean, what I'm taking from what you're saying, Dr. Muller, is that in actual fact, there should be a standard in the plan that says that it has to be, whatever the metric is, that's the boundary limit of the SNA. You would prefer a metric in the provisions. And that could then drive back whether you have a setback or whether in actual fact you have a lower.
Yeah. I think, again, potentially Mr. Mackenzie might be better to speak to that, but it is my understanding that, especially because of the additionality of lighting, measuring things such as the additional lighting that comes from a house is going to be reasonably tricky, and to then work backwards onto lighting controls is also going to be difficult to implement. And I think having setbacks, which basically just means that if you're installing a source of lighting and it's sufficiently set back, then physics will have it that the lighting is not going to reach the SNA boundary. So I think that's why I said that that's probably a preferred approach over any particular lighting measurement controls.
But you're still going to have to.
But we still want to.
And you're still going to have to do the work to work backwards to.
Yeah, that's true.
So,
Yeah.
yeah. All right.
Yeah.
Dave.
Yep. Yes, thank you, Dr. Muller. In paragraph 22 of your primary brief, you refer to inclusion of reference to best practice offsetting compensation guidelines. Just on the matter of guidelines generally, by my count, we've got potentially that reference, and then when it comes to looking at that biodiversity, we've got the 2014 document, then we've got the work of the Biodiversity Managers Group 2018. So are there any inconsistencies? If I read those two, would I find any inconsistencies between what's been required?
I think potentially, if you, I haven't come across any inconsistency in my work yet. It doesn't mean that you might not be able to find them if you do.
Yes.
I think what is probably more important is that, and I think it is included in the provisions, is that if there is more recent documents that will be produced, that they should be referred to also. So these two are just two examples that have been given. I think it was important to include that to ensure that there is a certain level of consistency between the effects management approach and the assessment of ecological effects that is being done for resource consent applications, relies on those, what are currently the best practice guidelines. Granted, they will be updated at some point and then more
Well, they might be as a result of any finalisation of MPS
yeah.
biodiversity that
But
comes along.
having these as a sort of bottom line to make sure that everyone does refer to those as a minimum, I think was important to include.
I mean, they're not standards. You know, we refer to standards.
Yeah.
I notice somewhere else there's in terms of dealing with trees, there's sort of like reference to being consistent with international, national best practice arboricultural standards.
Yeah.
So that's sort of a general. It might come back to the way it's actually referred to, but I just wanted to be sure that about the level of consistency.
Yeah, yeah.
So we've got those two. We've also got reference to Eurobats. Can you clarify something for me, because this came from Doc.
Yep.
I noticed the reference to Eurobats is to 08/18, which is on the top of that document.
Yeah.
This is not called Eurobat. I won't find Eurobats anywhere.
Ah, okay.
Is this the document?
This is the document, yeah. I think it might be in the...
Is it just coincidental that 08/18 comes up? I guess, but I just want to be sure that if we start referring to these documents, we're very sure
Yeah.
about
Yeah.
what we are.
There might be, I'm not sure, there might be on one of the starting pages, there might be a sort of a list of authors. I think that does include Eurobats, which is a group that has developed those guidelines.
Right.
But I'm not 100% sure. It's been a
Okay.
little while since I looked at the
Right, so
document. Yeah.
we probably need to drill down a bit on that.
Yeah.
Okay, turning to your rebuttal. In terms of light spill, your comments at paragraphs 11 and 12. I'm just circling back a little bit on Commissioner's questioning. Just not quite sure. At 12 you say, based on the Western approach, if lower lux limits at the SNA boundary are not provided for building setbacks. Now we don't have any building setbacks, and we certainly have control of lighting. We've got rules on the control of lighting within 20 metres, but we don't actually have building setbacks per se. So I wasn't quite sure where you were going with that.
There
in terms of
is...
building setbacks.
There is a table of setbacks for various stories of housing, and again, this is probably
Yes.
also, this was developed by Mr. Mackenzie, so he's probably a better person to talk about that.
Right, okay.
But the comment that I made in paragraph 12 was referring to if we were to want to achieve a lower 0.1 lux limit at the boundary, then perhaps the best way to achieve that is to increase those setbacks.
Yes.
Yeah.
It's got a step back.
Yeah.
Okay, all right.
So that was just a way, instead of introducing more controls on the light itself, to just increase the setback would also have the same effect in terms of minimising light on the SNA.
Right, because you seem to you equated like the Western Lee situation, which was basically if your light source is set back, then you're more likely to achieve 0.1 than if you don't have the setback.
Yeah.
That's sort of the relationship you're talking about.
Yeah, correct. Yeah.
Okay. Down also in your rebuttal down at 18 and 19, where you deal with infrastructure within SNAs.
Mm-hmm.
Obviously there is, I mean it depends on the infrastructure, but if you're thinking about something like a shared pathway or something like that through an area that was known to be or potentially could be used by bats, then what you're saying is, you know, like bats like old trees fall down, therefore there's a safety issue. So
Yeah.
So is that simply a matter that needs to be assessed when if someone was proposing that and there were options about where that pathway went, that might be a factor that comes into that assessment?
That should definitely be a factor, and I guess it also goes as far as looking ahead into the succession of potential bat roost trees as well, because that's another issue that we're just so short of potential bat roost trees in the landscape that really everything that can be used we should hold on to. So even if there's something that isn't maybe not quite suitable for bat roosting right now, putting in a shared pathway that means that tree will have to maybe be removed in 20 years' time is also something that should be considered. And whether that is an appropriate location for a footpath or not, I think that's critical, because the last thing we want to create is issues where suddenly we have bats using trees and then having to chop them down because they might become a public health and safety matter, which of course takes precedent over bats, but we don't want to create that situation that we.
No, thank you. That's very good.
Thank you, Dr. Muller.
Thank you.
And obviously we're going to hear from Mr. Mackenzie in more detail because he's given us some graphs and plots to look at. But we'll take a break now, I think, for morning tea, and let's get back at 11:05. Thank you.
correct.
And you are the Principal Ecology Consultant at Foresight Consulting.
That is correct.
And you prepared a statement of evidence dated 14 April 2023 and a rebuttal statement dated 12 May 2023, and to the best of your knowledge they are true and correct.
Yes,
Thank you.
except that there is a change to
Yes, I'll just signal Mr. Dean is going to make a couple of corrections to his evidence. So he'll do that as he reads his executive summary and his rebuttal statement.
Thank you. Mr. Dean.
Good morning. Okay, my executive summary. I have provided expert ecological input and oversight in respect of the SNA aspects of PC9. I've assisted with quality control and site visits, co-authored the Ecology Technical Report, which establishes the proposed SNA maps, reviewed submissions and co-authored the updated technical report, which responded to submissions, participated in expert conferencing and made recommendations regarding the final form of the SNA provisions within PC9. 75 SNAs were identified in 2012 and were provided for in the operative district plan, but these focused almost solely on vegetation values. The significant indigenous vegetation part of section 6C of the RMA, and did not adequately identify significant habitats of indigenous fauna. In 2021, Foresight Consulting was engaged by Hamilton City Council to undertake an assessment of all existing and potential SNAs within Hamilton City. Hamilton City sought to both update its existing SNA dataset and to expand it to better capture significant habitats for indigenous fauna. I was part of a team that was responsible for undertaking that analysis. Full details of the SNA identification process, which informs PC9, can be found in the Significant Natural Area report. This report is set out in Appendix 12 to the Section 32 report, which accompanied the notified PC9 documentation. Broadly, that included 6 stages: methodology development, a literature review, GIS mapping and analysis, site significance assessment, review and ground truthing of selected sites. Since preparing the report, I have reviewed the submissions lodged in respect of PC9 and evaluated the matters raised in submissions, and participated in the expert conferencing session held on the 14th of March. I recommend that changes are made to the extent of 22 SNAs relating to 32 submissions, as detailed in the aerial mapping set out in Attachment 1. But otherwise, I do not support wholesale changes or deletion of SNAs from individual properties, as in most cases they form part of a much larger SNA site, and to consider them on a standalone basis is not ecologically sound. The detailed analysis of submissions and my and Dr. Mueller's response to submissions is contained in the updated technical ecology report dated 8th of March 2023, which is set out as attachment 2 to my evidence. I support changes to provisions relating to restoration, vegetation clearance, and weed control that have been proposed as a result of submissions, including tightening of permitted activity standard 20.5.7 so that the total clearance area applies per asset, and replanting is required if a cleared area is not needed for ongoing access. Do you want me to clarify the per asset, the question from before? That was per because it relates to infrastructure, so it's per infrastructure asset is my understanding. Yep.
Is that clarified somewhere else? I mean, that's obviously going to be confusion of anybody that reads that.
I think if you read it in the context of 20.5.7, the word asset's in there, I think.
Just hang on a second, and let's just whilst we're going through this. I mean, it certainly is headed up with reference to infrastructure, yes. Gosh, what qualifies as an asset, though, on the ground at that point? I mean, if you've got paths and bridges and lamps and lights and so on and so forth, that's
yeah.
I mean, 100 square metres around a lamp is a different thing from 100 square metres around 500 metres of track, for example.
Yeah, but up to though, eh?
Well, know what your experience is, but my experience is that if you go up to, most people go up to.
Yeah, fair.
Yeah. All right, well, that's a detail that we might pick up later on, but that clarifies what the asset means. So, yeah.
The next sub-point B is where I need to make a change. So it will now read, allowance for greater than 50 square metres of clearance of pest species where standard 20.5.6c can be complied with. And I note there that there is no reference to who can decide when a species is impacting on ecological values of a site or area. The new allowance for small structures associated with restoration and access, that's Rule 20.3JA, Standard 20.5.8. The change to the definition of pest control to cover a wider range of problem species and situations and better reflect impact on ecological values. My opinion is that with these amendments, the provisions relating to SNAs within PC9 provide good protection to the natural values of these sites without unduly restricting the restoration activities of individuals and groups, which are so vital to biodiversity protection and enhancement in Hamilton City. Now on to my... there was also a couple of additions which were oversights which should have been included in the primary evidence. These are a couple of site-specific things. So one is submission 356, which is Jason Lee. An error was made when considering the submission of Mr. Jason Lee. At first, it appeared that the SNA did not extend onto the property, which is why in my evidence I said no changes required. But zooming right in, it turned out that there's an overlap of less than 1 square metre. So it will be showing up on Mr. Lee's property in the map viewer for Hamilton City Council, but it shouldn't be there. So that has been removed, and in the updated mapping, it is included.
What's the property address listed in?
The property address...
Don't worry, I haven't got it.
I don't have that written in front of me, sorry. And then the Te Awa Lakes submission 454, there is an area of pines that have already been cleared that we did not adjust the boundary properly, so that has now been adjusted to include that, or to exclude that rather.
Yeah.
Okay, if I now go on to my rebuttal evidence. The purpose of this rebuttal statement of evidence, which is provided on behalf of Hamilton City Council as Plan Change 9 proponent, is to briefly respond to the statements of evidence of Mr. Chad Croft on behalf of Te Awa Lakes Unincorporated Joint Venture, Te Awa Lakes, and Miss Phoebe Andrews on behalf of David and Barbara Eisendorn. My responses deal with issues relating to the significance assessment of individual sites and potential impact of development. Te Awa Lakes, Mr. Chad Croft. In the paragraphs below, I respond to the evidence of Mr. Croft dated 28th of April 2023 and to the map provided in the memorandum by Mr. Croft dated 19th of August 2022 and attached to his evidence. I agree with Mr. Croft's statement in paragraph 7A that Area 1, an area of overmature pine forest with indigenous understory, meets criterion 3 of the Waikato Regional Policy Statement significance criteria. I agree also that areas 3 and 5 do not meet the criteria, paragraph 7C, because they have already been cleared of woody vegetation. However, I disagree that areas 2 and 4 are not significant as they are part of the larger SNA site. The canopy of Area 2 is contiguous with Area 1 and provides additional bat habitat, which Dr. Mueller has covered in paragraphs 26 and 28 of her rebuttal evidence, while Area 4 links to both Area 1 and the riparian vegetation that makes up the remaining part of SNA C76 along the Waikato River. Fragmentation and the cumulative effects of vegetation clearance or disturbance jeopardise the ecological viability of corridors across Hamilton City, and unnecessary fragmentation should be avoided. This has previously been discussed in the evidence of Dr. Mueller, and our approach to considering the exclusion of an area from an identified SNA has been covered in my primary evidence at paragraph 42. Eisendorn, Ms. Phoebe Andrews. In her evidence dated 3rd of May 2023, Ms. Andrews provides a summary and recap of her ecological impact assessment report, prepared in support of an application for resource consent to establish a duplex on the property. Ms. Galt addresses the resource consent process in more detail in her rebuttal evidence. Ms Andrews' evidence assesses the planted indigenous vegetation on the property at 29 Petersburg Drive as significant and the exotic grass areas as not significant. I agree that the indigenous vegetation on the site is significant and consider that there should be no change to the extent of the SNA as notified. I note that Ms Gould recommends in her rebuttal evidence that the SNA be removed from the part of the property over which there is an easement restricting planting. If that occurs, I maintain that the rest of the SNA over the property should remain as notified. Although the assessment of the effects of a proposed development on the property are not the subject of this process, I agree with Ms Andrews' assessments at paragraph 23 to 25 that subject to a full effects assessment in that process, the ecological effects of removing 230 square metres of the planted vegetation type can potentially be addressed. Conclusion, Mr Croft and I are in agreement on some of the issues raised in his statement of evidence, but I do not agree with the exclusion of areas 2 and 4 from the SNA. I generally agree with the evidence of Ms Phoebe Andrews. Subject to Ms Gould's recommendation in respect of the easement area, I recommend that the extent of the SNA on 29 Petersburg Drive be retained as notified.
Thank you, Mr Dean. You answer any questions. I'll just note as well for the panel that we do have the maps ready to go if you'd like to go to any particular.
Right, yes. Well, yes, I think we probably will want to do that. Just a question for me for starters, Ms Dean. When did the distinction between the corridor and the floristic SNA emerge? And what was behind the thinking of that distinction?
I don't know exactly when it emerged, but it was very early on. And the thinking behind it was so that provisions could be made to protect the values associated with the particular type of SNA. So we thought that there would probably be differences in what could and couldn't be done in a corridor of SNAs, where you're primarily looking at fauna protection, versus floristic, where you're primarily looking at protecting the vegetation.
And with the corridor one, what just characterise the values that you have captured in the corridor? I mean, they're not as extensive as flyways, for example.
They are vegetated areas. They protect waterways, so gullies, a lot of gullies, and so it's around fauna movement and also buffering other SNA areas or providing connectivity between other SNAs or to other SNAs.
Are some of those values more important than others when you came to make a distinction between, because presumably there'd be some really quite grey areas on the edges of what might be a floristic SNA as opposed to being a corridor SNA. I mean, that distinction, I imagine, is not clean in every instance.
No, it's not. The floristic SNAs were pretty well defined by the previous work done by the university, and we did not change those a great deal.
Right.
Some of those where the vegetation values were less, well, there were less vegetation values, they did get absorbed. There were a couple, I think, that got absorbed into CSNAs. But in general, if there's indigenous vegetation that's reasonably intact within the city, it's a floristic SNA.
Yeah. But in terms of corridors, and you might want to pick a couple of examples on the corridors that you'll be aware of and I won't be, sort of to demonstrate the I guess the way in which some of those values are more dominant than others. Just for example, just as an example, I mean, presumably some of the corridors are, I don't know, foraging areas. Maybe? I mean, I don't know, I'm guessing here.
Yeah,
I'm just trying to get a handle on it.
Okay, so if we think about Donny Park, just one off the top of my head.
Okay, let's pull up, if somebody can pull that up.
Ms Gould, can you assist us with the maps?
So Donny Park has a floristic SNA in the middle of it, which is largely based around a wetland.
Just hang on a second there, let's get the pictorial reference. Are we doing the aerials or are we doing a map?
Aerials.
Yes,
I can drive us there if you want. Yep.
I think there's a pointer on the desk too, if you wanted a pointer. I don't know whether that's helpful.
I don't know if it is, but so this gully is it's not working. It's okay. I don't know if it shows up on the screen anyway. Does it? Oh, yeah. So Donny Park. I can't recall the name of the gully system. Sorry. But in here is a floristic SNA, which is based, it's an SNA because it's got Indigenous wetland values. But the rest of the site is a CSNA, and it has a mix of exotic and Indigenous vegetation, some of it planted. It has records of bats through it, so bats obviously use that area. It is also a really highly valuable site for giant kōkapu, which is a native fish, the big native fish. So the CSNA both buffers the FSNA, reducing light effects and disturbance effects and all of those sorts of things, as well as buffering the stream, which is protecting the stream,
So
which
you
is
have a
obviously
buffer
highly
on.
valuable.
So you have a buffer on a buffer, is what you're saying, because there are provisions which buffer the SNA in terms of private landowners, in terms of setbacks and those sorts of things, which is effectively a buffering effect. And then you've got the corridor SNA around in this particular instance, around the floristic SNA. Right. All right. In terms of, talk to me about the connectivity element. In terms of that, I mean, I can't see what happens south of towards the bottom of the thing. That's the end of it, is it? It's not.
Yeah, it is the end of
It's
it.
not connected. It's not connected at the top end. So
No,
I
but
understand it's not connected east-west by the looks of it.
It itself connects to the Waikato River, which is, and it's not completely connected,
Right.
but it connects, there's a road between the two. And that's the connectivity function, is it's connecting to a highly significant river ecosystem.
Yeah. Okay. All right. All right. Try us with another one. I mean, we've obviously got submissions around the edges of these things where there's obviously concern about it. And I guess one of the things that we're having to think about is whether if we acceded to their request, whether it makes a material difference or not. And I think we may even have one, I think, in this area, haven't we?
Yeah,
One
we
or
do.
two. We've
Yep.
got a couple of that. Well, okay, so whilst we're there, talk about what the implications of removing any of those ones might be.
So
Maybe we need to enlarge it. Do we need to enlarge it to sort of see where they are?
we can, yeah.
So just orientate us. Where are we? What's the cul-de-sac there, for example?
I'm not sure.
Does anybody know?
But we've got
Locals?
River Road off to the left.
River-
Just outside
right.
the view of the
Okay.
map.
Okay.
Yep.
Yep.
So the address that I'm looking at there is a River Road address, 7 something.
Yes.
That property there has submitted, and they have got a sort of a landscaped kind of an area down there, but also some kakatea and things like that. The implications of removing something like that in and of itself is not massive, because it is a small area on a small arm of a corridor SNA. It is the overall implication of incrementally eating away at these areas that is
Understand
the
that.
issue.
I understand the cumulative potential, but I guess what we're faced with and we're having to justify is that why that at this particular point in time should be included, which isn't a cumulative issue because it's not there now.
Yeah.
But that's fine. I mean, I'm not making a finding or anything. It's just an argument basically at this point. Just trying to test what the net effect of that particular. So if I read you correctly, then if we agreed with that particular submitter that in actual fact there was no material effect of not having the corridor SNA on their property, you'd be, well, and I'm not saying you're going to be relaxed about that because you're concerned about the overall that you've done, but I'm having difficulty seeing how we would deny that submission, because it does seem to be the dead end of the corridor, and it doesn't sever.
Are we talking about the one right at the end, or are we talking about the one
I think it's that one.
there?
No, I thought you. Okay. All
Yeah.
right.
Not-
All
no,
right.
no,
All right. I thought you were talking about the one on the right-hand side. Okay. Well, that helps to be clear. It's the shakiness of your your hand.
Distance is hard.
So it's the one to the left of that, of the triangle. Okay. I was actually looking at the one which is the just go up and to the right. Yes, that one there. That's the one I was actually thought that we were focusing on. So talk about that one. Now I can see that I can see that if you actually remove the sort of the L shape, the inverted L shaped section there, that would bifurcate that area, and that would have significance. But there are going to be some. Well, I'm assuming there are going to be submissions where all you're doing is you're nibbling at the edges of those things, which isn't quite so significant, or doesn't appear to be quite so significant.
Yeah, and that is the concern, is that because if you look at individual properties and look at it at that scale, it is sometimes in these corridor SNAs where we're thinking about fauna values and buffering and things like that, it is easy to consider that they're not significant because that you're only looking at a limited scale. But you shouldn't be looking at it like that. It needs to be looked at the site scale. And if you went through and looked at every single individual property that has an SNA in it in Hamilton, you might get a different result. And it would be the wrong result because you're looking at individual, you're taking a reductionist approach to it.
Yeah, no, I understand that argument, but look at that lot that I'm talking about there. Its contribution to the corridor is what? How did you assess that one, for example?
It's just that it has contiguous vegetation as
right.
part of the wider site. Yep.
Okay. I mean, it's those triggers I think we need to understand when submitters come before us and say, take us out. We need to understand what the value of their particular section is to the overall. Yeah. All right. Okay. You want to take us somewhere else, just as a comparative?
Yep.
Do you have an example of a corridor SNA that doesn't buffer a floristic SNA, or do they typically always buffer a floristic SNA?
They don't always. Well, I'm not 100% sure actually whether they buffer floristic SNA, but most of them have a connectivity function to the river or something like that along those lines. I haven't sort of got one in mind, maybe two.
Just while he's doing that, could I just add, I've just checked with Ms. Gold. So the layers on the map don't split.
I'd anticipated that.
So we can't remove and then and then overlay.
Yeah.
You have to hit on a particular SNA and it'll tell you
And
whether
then it
it's
tells you.
floristic or corridor.
Right. Thanks for that. Yes. Yeah.
Tukugali would be another example. You can actually see that they're not which type of SNA they are, but I believe there's flora SNAs within that, but the bulk of the site is a corridor SNA.
I mean, that's a good example of connectivity, obviously. I mean,
Yeah.
that makes the point quite eloquently. Yeah. Okay. All right. I'll let my other questions into. Dave?
No, I haven't got any further questions. Thanks.
I just had one, and it related to the correction you made to your evidence about allowance for greater than 50 square metres of clearance of pest species, I think you said. Is the term pest species defined anywhere? Is that clear? If that's going to be a provision in the rule, is it clear what's covered by that?
Pest control is defined, yes.
Pest control is, but pest species? If that's the term you're going to be using?
I don't think pest species is, in that case
Pest control, yeah, there's a definition for the management of nuisance plants or animal species. Yeah, but no.
okay, perhaps that's not very well worded.
Just sorry to interpolate here. There will be a pest species list identified by the Waikato Regional Council as part of its biosecurity function.
Yep.
So it will have regional pest species and national pest species. So I suspect what we need to do is make a connection between the regional council's list.
I mean, that's actually been deleted from the definition. I was going to wonder whether, in actual fact, that should be put back in.
Yes, and that's not what the intent was. The intent is that I support the pest control, that you can clear larger areas of vegetation as pest control, which is what the definition is. If I can elaborate on it a bit, being able to do that is essential really for restoration activities, for restoration groups and even private individuals, because if they can't, then it is quite restrictive.
There was mention, and I think it was in Dr. Muller's or somewhere else this morning, or maybe it was in opening submissions, that there was disagreement on the redefinition or the definition of restoration. Can you just explain what that was about? Were you part of that conversation?
My understanding is that the submission was along the lines of getting the restoration definition aligned with the NES freshwater and including a reference to the Hamilton Gully Restoration Guide. And our response was that we didn't think it should be linked to those things as external things. One's directly related to freshwater and one's a guide, and it just would be a bit restrictive, that's all.
Oh, okay, so you were looking not to narrow the concept of restoration.
Exactly.
Righto, okay, thanks. Sorry.
So can I just come back to you on that definition point? So, the words prepared under the Biosecurity Act 1993 have been deleted. I mean, in some ways they are redundant, but the material point is that it does talk about the Waikato Regional Pest Management Plan, 2021 through 2031. So that will be where they'll have a defined list of identified pest species within the region.
So why's it got a strike through it?
Well, it's just got a strike through the words prepared under the Biosecurity
No,
Act.
mine's got a strike through from after the word area.
Yeah.
So maybe that's just a gremlin.
We'll sort out what version you're looking at versus the one I am. Certainly the one I'm looking at has got the Waikato Regional Pest Management Plan 2021-2031 in the definition.
Okay, well, that's important that we actually look at the right text. So, yeah.
Well, we might just check offline.
I'm not sure. Well, this was given to us at the beginning of the hearing by staff, so I'm not sure where it came from. I assumed it was updated.
The strikeout was intentional because of the limited scope of that, what the pests that are named in that strategy. My version is.
Right. Okay. So so we've got the 42A version.
Oh, okay.
In that
we're
case.
looking at the notified versions.
Right.
Sorry,
Okay.
I didn't quite understand the reasoning.
It was a scope of submission issue,
It
was
was
it?
a response to a submission from the Regional Council that noted their
pest management strategy didn't list the full range of pests that they would think should be able to be removed.
We probably should.
Yes, I mean, that's the statutory.
Sounds like their problem, not ours.
Yes, yeah. All right, well, that's something to be sorted, obviously.
Yeah, okay, well, we'll iron out that
Yeah.
kink,
Yeah.
but certainly there should be a comprehensive list somewhere of all of the plant pest species that are,
Well, otherwise it just leaves it open to too much discretion, doesn't
Yes.
it? Which I understand is what you want, but that's probably not what other people want, so, yeah. Okay. Ewan?
Yeah, if I could, Mr. Dean. Putting aside FSNAs and CSNAs and what differentiates them, is it your evidence that both of them are of significance?
Yes.
So when looking at a map, trying to determine which is which is academically helpful, but the underlying current of your evidence is they're significant and they're important.
Yes.
Okay, thank you. My next question is in regards to the last property we saw that was sort of part of the broader corridor. Is your concern that if it was not deemed an SNA, whether F or C, what could potentially happen on that site going forward and its material impact on the balance of what is identified as SNA? I'm just trying to...
Yes. That's right, yep.
Right. So it's that incremental creep that you're concerned about.
Yes.
Thank you.
Is there somewhere just trying to think whether there's somewhere that we can turn to in the research documents behind this that tell us why a particular section has been included or a particular lot has been included as, you know, what the values that were identified as being essential to inclusion? Is that, I mean, again, I'm thinking of submitters that are coming forward over the next couple of days.
Within those geospatial layers,
Yeah.
there is the information behind about what makes the entire site significant.
The entire, when you say site, what do you mean by site?
So-
Are you talking about parcels or are you
No,
talking... No, I didn't think you were, yeah.
Parcels were pretty much ignored
Yeah,
because they're not ecologically relevant, right?
Yep.
So
Yep.
when I talk about site, I talk about the whole, the polygon that was grouped as one SNA. So it's
Yes.
numbered as the same SNA.
yeah, okay, all right.
Yeah, just another question on the mapping of the CSNAs. You say every effort was made to exclude lawns, gardens, orchards and buildings and what have you. And when you've had submissions on that and you've gone back again, I mean, I recognise you actually excluded quite a few areas where someone said, well, this is a very, you know, domesticated area of lawn and garden, etc. Is that like always been the case, or is there a point at which, in your mind, to exclude a significant area like that just takes too much of a chunk out of the corridor, and you suspect at least that it is used by bats for, and we're only talking about bats here, I assume. I mean, in terms of fauna that move around, we're not talking about corridors for birds.
Well, we are talking about corridors for birds and invertebrates and things like that. It's just that there's less information about, especially invertebrates. So bats is just a really good example of how fauna moves around the landscape. And but yes, there have been times when some people have got gardens that extend right down into gullies and have all sorts of features, garden features down in there. And to remove those is to remove a massive chunk of a gully or whatever it is. So yes, we have tried to avoid any sort of manicured areas and things like retaining walls and whatnot, but the intention is that the provisions allow for those other areas that have still been included to be able to continue to be used and as gardens and for restoration and whatnot.
But not for the extension of building, obviously, and the lighting provisions come into play as well. Okay, that's just something we need to sort of keep in mind as to how you've gone about it as we go through the next couple of days.
So if I could, just on the back of that question, during your collection of evidence and looking at all of these areas, were there easily identified areas where you would have deemed them to be significant if they hadn't have been developed? I'm trying to get an understanding of an example of where there is potentially an ecological damage having occurred, and to help explain why the implementation of a broader SNA is so important. I probably haven't articulated my question well, but
No, I think I know what you mean, but no, I don't think there's any, well, not off the top of my head, anywhere that like that.
So we've never had any development, you weren't aware of any development that has gone ahead, actually in an SNA, that shouldn't have gone ahead?
I don't know about an SNA. I'm not on top of what consents have been issued, but undoubtedly development has gone on in Hamilton that has impacted on natural values.
Okay.
Yeah.
Thank you.
All right. All right. Thank you, Mr. Dean.
Thanks.
Council's next witness is Mr. Mackenzie.
Right.
Mr. Mackenzie, I'll get you to just confirm that your full name is John Kinross Mackenzie, and you are an executive engineer at LDP Limited.
That's correct.
And you have prepared a statement of evidence dated 14 April 2023 and a rebuttal statement dated 12 May 2023. And to the best of your knowledge, both are true and correct?
Yes, that is correct.
Thank you. Will you please read the executive summary of your statement of evidence and then proceed to read your rebuttal statement?
Thank you, Mr. Mackenzie. Again, welcome again.
Indeed, thank you.
It's becoming a little bit too well, I won't say, right.
Very regular.
Yes.
Starting at paragraph 10 of my executive summary. I have over 20 years experience advising as to environmental lighting effects. I've provided consultancy services for private client applications in local government regarding the assessment of lighting effects for a wide variety of activities, and have had previous experience in designing lighting to manage effects on the long-tail bat, including in relation to development within the Peacock Structure Plan area. I'm generally in agreement with the lighting provisions in PC9 as notified, but recommend additions and amendments to the provisions as set out in paragraph 46 of my evidence. The recommended additions and amendments respond to the fact that many of the proposed SNAs are located adjacent to existing urban areas where light spill already occurs lawfully. In this regard, the context differs from the situation I addressed in relation to Plan Change 5 and development within the Peacock Structure Plan area. For PC9, the lighting provisions need to reflect the existing environment while controlling the effects of new and additional light sources. For that reason, I recommend an addition to the PC9 lighting provisions which addresses the control of new light sources within that existing environment. The additional provisions address internal light spill and exterior lighting effects. For internal light spill, I've modelled the extent of light spill from single and multiple storey buildings. I consider that for a ground level building, provided it's setback 5 metres from the S&A boundary, light spill effects will be acceptable. For multiple level buildings which have greater light spill effects, the setback needs to increase to 10 metres. That's progressively discussed later. If buildings encroach within these setbacks, they must not have light emitting apertures, for instance windows, within the setback facing the S&A boundary. For external lighting, I recommend that controls be placed on the lighting direction, colour temperature and duration. These recommended provisions are set out at paragraph 46 of my evidence. Could I elaborate slightly at that point? Just say that, just addressing some earlier questions that came up, the rationale for not setting a lux limit per se is explained in my paragraphs 31 to 34 of my evidence. There's a progression of logic there. And the rationale for the setback distances for 1, 2 and 3 stories is summarised in the table at the beginning of attachment 3 for the modelling in my primary evidence. And the reason for 3 stories, I conversed with Ms Buckingham, and with a bit of research was advised that 3 stories is the maximum likely permitted height of a building in those existing areas.
Right.
We'll move now to my rebuttal evidence, starting at paragraph 4, purpose and scope. The purpose of this rebuttal statement of evidence, provided on behalf of Hamilton City Council as Plan Change 5 proponent, is to address the submitter evidence prepared by Ms Ashley Sycamore, planner for the Director General of Conservation, and Dr Kerry Borkin, ecologist for DOC, in relation to lighting matters. I note that neither Ms Sycamore nor Dr Borkin profess expertise in lighting. I agree that any outdoor lighting should have a colour temperature of 2700 Kelvin, but disagree with the proposed change to timer duration for security lighting from 5 minutes to 1 minute. Yeah, I think there was some rationale given in my primary evidence for that as well. In response to Ms Sycamore's evidence, paragraph 24, I agree with 2700 K for lighting colour temperature, and this is consistent with my primary evidence. I disagree with the time duration of 1 minute and recommend 5 minutes for reasons discussed in my primary evidence. Paragraph 25, the wording I propose for the new rule 25.6.4.x at paragraph 46 of my primary evidence is the same as that proposed at Ms Sycamore's paragraph 24, other than the timer duration for security lighting. In my opinion, the rule as worded in my primary evidence is sufficient without the need for further measures. In response to Dr Kerry Borkin at her paragraph 16.2, I disagree with the paragraph. While setbacks of 50 metres or more may be possible in a greenfield area, they are not achievable in an existing built area. In addition, the present level of activity of the New Zealand longtail bat and such locations is so within the present building setbacks and spill light, which are estimated to be similar to that proposed by the examples provided in my primary evidence. Paragraph 16.3, I agree that 0.1 lux would be preferable to 0.3 lux, but in my opinion it is impractical in an existing built environment. In fact, any limit is impractical to mandate in a location where development already exists by right and could potentially exceed such a limit. Hence, no such limit has been proposed, but instead mitigation measures are proposed to achieve the minimum light spill practical. Paragraph 16.4, I agree in principle that other methods should ideally be considered if lower lux or greater setbacks cannot achieve lower light levels in an SNA. But I consider that the proposed measures are impractical to implement in existing built areas. Paragraph 17, I agree with Dr. Balkin's discussion about colour temperature in principle, and Rule 25.6.4 addresses these principles as far as reasonably practicable in my opinion. Paragraph 18, there are matters stated in this paragraph with which I disagree, particularly the reference to products available on the Lighting Direct website. I replicated Dr. Balkin's search, and none of the 19 products that appeared were complete outdoor light fixtures. They were all bare lamps for use inside a light fixture. Or in 2 cases, they were actually indoor downlights. Reviewing each of there being Lighting Direct, outdoor fully down-facing security lights, all of those were listed as either 3000K or 4000K. In other words, they didn't have any 2700 Kelvin lights of that nature. However, any such issues are irrelevant since Dr. Balkin's recommendation for 2700K lighting is consistent with the recommendations in my primary evidence at paragraphs 26 and 46. So in conclusion, I agree with the submitter's recommendation to use 2700K lighting and note that this is consistent with the recommendations in my primary evidence. I disagree with the proposal to use a security light time of 1 minute in lieu of 5 minutes as recommended in my primary evidence.
Thank you, Mr. Mackenzie. Are you able to throw any light on the issue of how difficult it would be to... Oh, sorry, I didn't mean that. All right. I'll rephrase that then. Could you throw some darkness on that? On the retail issue of obtaining 2700K?
The issue has arisen before in the Westernley Amberfield case and in Plan Change 5, and is something I currently keep tabs of in the industry as to what is and isn't available. And to my knowledge at this point anyway, for standard retail lighting outlets, they don't offer the 2700 Kelvin colour temperature in outdoor downward facing luminaires. They are readily available from a number of suppliers throughout the country, which are not a lighting shop, if you like. They're actually more the professional grade of luminaire. And the other thing is interior lighting is readily available at 2700 Kelvin. Yeah. I think people tend to prefer that anyway, so it's more close to the old incandescent. And I'm just picking up on an earlier comment I think you made about market forces, so I totally agree that if there is a need for something, it will rapidly be filled.
Yeah, yeah. So I mean, there's not a reluctance in the industry to manufacture these things internationally. It's simply that the market currently prefers a whiter light.
I think part of it too is that historically the lower the colour temperature, the less sufficient the light source. So more energy, more money, as in paying a small premium to actually have that. So I think there's not been a great impetus to actually go that far in the lighting industry for residential use, but you can certainly see it coming. It's quite a hot topic in Europe, and that tends to drive what we end up seeing eventually.
Yep. Okay. And are you going to take us through your attachment to your exemplar house?
Yes, I think it might be useful. Is this something we could bring up on screen? Or do we need to? I mean, you've got them in front of you, haven't you? Yeah.
Well, I have. But others in the room might have, so If we can get it up. Yes, yeah.
Yeah, I was going to say it's just in the evidence, right?
Yeah, so it's just the appendices at the back of my evidence, which I believe are actually in that bundle.
Yep, that's it.
Perfect. Not so perfect as my eyesight.
Scroll up and down.
Oh, great, thank you, Steve. So, while we were going through these effects, I was asked if it's possible to actually model typical lighting effects in the house, and it's an interesting challenge because there are a huge number of variables that could apply. Where I've landed with this, I believe, is a moderately conservative approach to what I would expect typically in most residential applications. Purely on my experience, this isn't hard fact, it's really just basically experiential. And it's the best we can achieve in that sense. So, having said that, when we were looking at, I think it was Amberfield, yeah, Western Lee, with council, we did a bit of a tour through older and newer areas of Hamilton with a light meter, and had a look at the typical spill light happening at boundaries for a number of houses. Again, fairly ad hoc, but the answer was zero, basically. When you looked at the houses, they were generally at night, they were fairly enclosed. I think it's generally the human condition. People tend to prefer to keep insular at night, by and large, not everyone. So there is a tendency to close curtains and only turn lights on in rooms where you need them by right. So these models assume a worst case that the curtains are, well, initially for this first model, the curtains are wide open, the rooms are quite brightly lit, they're quite bright finishes, and all the lights are on. So it's conservative in that respect. And what I've done there is, that's really just a summary of all the variables you could potentially get. So, you know, they're myriad, to be fair. I mean, if somebody chose, for whatever reason, to light up the neighbourhood, there'd be nothing stopping them doing that, but it's not commonly the case. So for that model, unprompted by anything other than those reasonable expectations, did a model and typical situation with everything on, no screening at all, but with the exterior lights turned off, we were getting this 0.3 lux out to 11 metres away from the house. When we turned the exterior lights on, and the older style tilted up 60 odd degrees facing the SNA, if you like, could get out to 29 metres. But when we turned those off, because normally they would be off, they're just usually used infrequently to go outside to do something. And then come back to a standard situation, typically where you've got a lot of this light screened by curtains at night. And this is like an averaging effect to say, well, okay, we'll close most of the curtains, they might be a little bit cracked open. Let's just say we're going to close off about 90% of what's coming out. Turn the exterior lights off, we're getting back down to about 4 metres of, before we drop to 0.3 lux. So it was an indicative model, if you like, to see what ifs. We then said, well, let's look at this last scenario, which is more the typical case. Take what we've done elsewhere, which is Amberfield and PC9, and so we're going to look at a minimum setback of 5 metres, which is just a nice cushion, if you like, just a slight bit of conservatism over this bottom case. And then we've looked at attachment 3. So that was just that first case, so just to give you an idea of what happens. I think it's screened off. Is that, what side do you to the... Sorry, I'm trying to get to that last one, which is indicative of what we're talking about. Yeah. So this is the one with curtains largely closed and so forth, and you'll see this line here is the 0.3 lux line, and it's getting out here for this 4 metre mark. For interest, the 0.1 lux gets out over here about 7 metres, thereabout. That grows significantly if you look at the other cases to 30 or 40 metres quite readily. Just saying. We've then taken this, normalised the single-storey application to say let's adjust that lighting in the model so that it maxes out to 0.3 of a lux at 5 metres. And then what happens when we add a second and a third storey with exactly the same conditions? So in that sense, we look at one, which is the diagram we just showed you with 1 storey going out to around 4 or 5 metres. In fact, this one's now been pushed out to 5 by slightly increasing the amount of light coming out of the building. And then using those same conditions going up to 2 storeys, this level here grows out to 7.5 metres, 0.3 lux. And when you go to 3 storeys, it grows out to about 10 metres at 0.3 of lux. 0.1 would be off the page somewhere in that sense. So really this is just trying to give an idea of the fact that for a typical condition, what we're proposing is a reasonable proxy to try and limit this situation so we're getting as low a practical amount of light from anything that's new, that's put into this environment, into the SNA. This also assumes no screening, so I mean, most places will have trees and foliage and so forth here. No, I've lost it, I'm sorry. But that, in a nutshell, that's something important I want to bring up there. I think it's really just a case of saying, look, when you look back at that first model, you start to see the problem that, if you start trying to set this magical limit of 0.3 or 0.1 lux at a certain distance, and you've got an existing house, there's nothing to say that you haven't got it out here at 10 or 20 or 30 metres at present. Yeah. And so, and then if you're trying to install something in an area that's adjacent to an existing example like that, how do you then isolate the new from the old? And it becomes impossible. So this is really why we're trying to find another way of achieving best practice in that sense.
Mr. McKenzie, can I just to finish that helpful explanation, can I just confirm that the drafting, the taking all of that and turning it into a rule is the rule that's set out at paragraph 46 of your evidence in chief, and it's the first part of the rule. It's part A, which reads, any part of a new or extended building that is located on a site adjacent to an ECNA shall have no light emitting apertures facing the ECNA if located within the following setbacks from the ECNA, and then from a ground level 5 metres, for a second level 7.5 metres, and for a third level 10 metres. So that's the rule that reflects that analysis that you've just been walked through.
Right, okay.
And materially it relates to any new or extended building. So that's the way around the practicality of the existing environment.
And the concept of a light emitting aperture facing, what's...
Well, that's the light source that we're
yeah, not so much.
That's what I'm wondering, whether it's more than that.
Potentially use a couple of extra words in there. It's an aperture that could potentially allow interior light to emerge.
Right.
To the outside atmosphere, outside the environment.
Okay. So so presumably there's a kick-on rule for that. So if you have a particular aversion to curtains, for example, exceed all of these, and you'd then fall into some sort of rule and be made to draw your curtains or whatever. It's an interesting enforcement issue that would be.
It is, yeah. I mean, keeping in mind this is new build,
Yeah.
in that sense, so there is an opportunity in there for somebody, should they be able to and care to, create a blank walled into a building with no windows and so on. I don't know how practical that is for a residential building, but if they did that, then we're not
Well, they'd meet
concerned
all, they'd
because
meet
there
all
is
those.
no...
Yeah. I just wonder whether that's quite as tight as we want it to be, but
Well,
I understand the rationale.
Yeah, thank you. I mean, just the point about the enforcement. I mean, this whole piece of the puzzle is replete with enforcement headaches.
Yeah.
The most obvious of which is someone who just wants to change a bulb.
Yes.
Started off at 2,700.
Yeah.
They couldn't get it. They end up buying something at 3,000.
Yeah.
Who's enforcing it? How's it? You know, it's quite difficult to reconcile some of the practical realities with the rule making.
Yes.
We think we've done our best, but
Yeah.
it is very challenging in not just because of the intrinsic nature of this, but also in an existing urban environment.
Yeah. I mean, we were talking before about these days you get portable LEDs and thousands of things you take out to your barbecue. I mean, just recognise that. Yeah. Okay.
A couple of quick questions. Just on agreement or otherwise, on the 2,700 versus 3,000, that number comes up twice. It comes up in relation to lighting within SNA, and it comes up in relation to lighting within 20 metres of the SNA. And I'm a bit confused as to whether there is agreement between people. There seems to be agreement on the within, but I'm not sure about agreement on the within the 20 metres.
Yeah. Basically, all of this is really talking about lighting that's attached to a building. Somebody chose to have a garden light or whatever further away from the building, we're not addressing that. So effectively, it's getting back to this proposed rule addition, which says any light in that space, any outdoor lighting installed within 20 metres of SNA must have maximum colour temperature 2700 K. So,
sorry, that's what.
So that's
because I haven't got that.
That's the 42As.
This is the proposed additional rule.
So it's all 2,700 now.
All of it.
That's fine. Okay, I don't.
Yeah.
All right.
And,
Got that.
I mean, the reason it came up in Dr. Miller's Q&A, but particular reason why I'd acquiesce to that in this case is to be consistent with what happened in PC5 and Amberfield, where residential adjacent to SNA is 2,700K. So, to be consistent, we should keep doing that with this one.
And just one on paragraph 9 of your rebuttal. And this, if you want to go to it.
In my
your rebuttal?
Rebuttal.
Yeah, paragraph 9. Just that second sentence, you say, in addition, the present level of activity of the New Zealand long-tail bat in such locations is so with the present building setbacks and spill light. I wasn't quite sure what you were saying there in that sentence.
Yeah, it's purely intended to be a statement of fact, and I know Doc have taken issue with it and suggest I'm stepping out of my lane with this, but it's a statement of fact. Whatever activity there is at present is there with whatever level of spill light is there. That's all it's saying. So in other words, if the bats are choosing to be there, it's in the presence of whatever existing spill light's there.
So we're not saying that.
I'm not saying that it's good or bad.
No,
I'm just saying it's there.
Okay, all right, that's fine. I'm just saying that doesn't become the metric or the standard that we wanting to achieve everywhere.
No,
That's just what it is.
Exactly.
Okay, thank you.
Ewan?
No, sir.
Thank you, Mr. McKenzie. Your evidence.
That brings us to our final witness, Ms. Galt,
So,
who has been introduced in this hearing already.
Yep.
So I'll get you to just simply confirm that you have prepared a statement of evidence dated 14 April 2023 on the SNA topic, and a statement of rebuttal evidence dated 12 May 2023 on the SNA topic also. And to the best of your knowledge, it is true and correct.
Yes, that's correct.
Thank you. And can you go ahead and read the executive summary of your primary statement and then your rebuttal?
Right, welcome again.
Thank you.
Yep.
SNAs, or significant natural areas in the ODP, are currently focused on the identification and protection of vegetation and not fauna, which is recognised as a significant gap in the protection of ecological values in the city, particularly in relation to the nationally critical threatened long-tailed bat. In this respect, HSC considers that the existing ODP provisions do not fully meet the obligations arising under Section 6C of the Resource Management Act and the Regional Policy Statement. In light of this, Foresight Consulting were engaged to review the extent of SNAs within Hamilton City, which resulted in a unique outcome of two separate classifications of SNAs, the F-SNA, the floristic, and the C-SNA, the corridor SNAs, being introduced through PC9, which responded specifically to the ecological values identified within them. To address the noted gaps within the ODP, a review of the relevant provisions resulted in a number of policy and rule changes, including a change to the policy approach from absolute avoidance to an effects management approach to enable the protection of SNAs, provision and recognition of activities that are beneficial and/or have a functional need to exist in SNAs, an effects management hierarchy to address the situations where adverse effects cannot be avoided, policies introducing biodiversity offsetting and biodiversity compensation, amended policies for pruning and maintenance within SNAs, which corresponds to the amended activity status, amended policies to address and align with nature in the city strategy, which is HSC's biodiversity strategy, amended policies in relation to public awareness of SNA protection, revised activities status and standards to reflect the amended management approach signalled in the amended policies, including separate consenting pathways for F-SNA and C-SNA where warranted, and of course updated planning maps to reflect new extents of the SNAs. In relation to HSC submission points, I've reviewed and support the Section 42A report recommendations. It is my opinion that the recommendations assist in achieving the intent of PC9. In regard to the spatial extent of the SNAs, I've reviewed the Section 42A report and recommendation in light of the ecologist's recommendations, and I am satisfied with the proposed amendments to the SNA boundaries. In regard to the Te Awa Lake submission on SNA C59 and C76, I support the recommendation of Mr Dean to amend the boundaries where vegetation and clearance has already occurred or includes a path. I also support retaining at this time the SNA areas which still exist and hold ecological values, potential long-tailed bat habitat, unless specific vegetation removal consents can be provided. I have reviewed the Section 42A report recommendations in respect to the lighting effects on bats and the proposed setbacks sought by the Department of Conservation. I support the proposed amendment for the outdoor lighting for properties adjoining an SNA. I also agree with the Section 42A report recommendations that it is not appropriate to introduce setbacks sought by DOC, nor scope to do so within PC9. However, considered and support in principle the proposed lighting and setback rule within Chapter 25.6, Lighting and Glare, as recommended by HSC's lighting expert, Mr Mackenzie. My agreement is noted in the joint witness statement to include objectives and policies, specifically address to specifically address the bat habitat within SNAs, and I support the proposed new objectives and related policies. I have reviewed and support the expert evidence of Dr. Miller and the Section 42A report recommendation to not include additional SNAs specifically for mudfish in PC9. The associated ecological issues are important, but may require addressing through another plan change process. Finally, it is noted that HCC does not currently provide any direct financial assistance to gully owners, including any consent fee waivers for restoration work. I'll now move to my rebuttal, which is in response to submissions where planning evidence was provided. First one, Isidorn, Mr. Jacob Robb. The submitter seeks the removal or realignment of SNA C26 at 29 Petersburg Drive. By way of background, in August 2020, the submitter lodged an application for a non-complying resource consent to establish a duplex dwelling on the property which is located in the open space zone. The application was limited notified and 4 neighbouring landowners have submitted in opposition to the proposal. A revised application was subsequently lodged in December 2022. A hearing of the matter has not yet been scheduled. I disagree with Mr. Robb's statements in paragraphs 16 and 21 that the consent application is well advanced or advanced enough and has sufficient support from the experts involved, such that it would be appropriate to realign the SNA boundary through PC9 to avoid the proposed development area. The consent process is a separate and unrelated process for which there are several important steps yet to occur before a decision is issued on the consent application. And it is not a foregone conclusion that it would be granted. Accordingly, I do not consider the proposed development to be a relevant consideration in determining whether the SNA over the property should be retained, removed or modified. Although not relevant to PC9, I note that Mr. Dean's concurrence with the ecological effects of the removal and replacement of the area of 230 square metres of planted vegetation can be addressed, subject to a full effects assessment in the consent process, has not affected his recommendation that the SNA be retained as notified. At paragraph 22, Mr. Robb refers to an easement. I'm aware of an easement in favour of HSC applies to the property for the right to drain water. The easement area shown in red below in figure 1 has been planted with vegetation despite the easement restricting the planting and growing of trees or shrubs there. Mr. Robb considers that the SNA should be realigned to reflect the easement. I agree that it would be an absurd outcome to protect via application of SNA status under PC9 the vegetation in the easement area which is in fact prohibited by the easement. I consider that the SNA C26 should be amended to exclude the area subject to the easement as shown in Appendix 1 of my evidence. Mr. Dean's evidence is that even with the easement area removed, the rest of the proposed SNA over the property should be retained as notified. I agree with his recommendation. Moving to the Department of Conservation and Ms. Sycamore's evidence. Paragraphs 20 to 25, lighting and glare. In respect of lighting and glare, I rely on the rebuttal evidence of Dr. Muller and Mr. McKenzie. Accordingly, in terms of Ms. Sycamore's proposed changes to Rule 25.6.4x, I support the amendment to B Roman 3 to replace 300k with 2,700k, which is consistent with Mr. McKenzie's primary and rebuttal evidence. And I do not support the amendment to B Roman 4 to replace 5 minutes with 1 minute, which is not supported by Mr. McKenzie. Dr. Muller notes that whether a shorter sensor light period will minimise effects on long-tailed bats is unknown. Paragraphs 26 to 29, noise. Dr. Muller acknowledges that the emerging research indicates that noise potentially adversely affects long-tailed bats. However, there is insufficient evidence available to understand the effects of noise or to guide the implementation of effective controls and mitigation measures. I consider that the noise effects should not be disregarded simply because the research is in its early stages. However, it is difficult to implement noise standards when it is unclear what level of effects are being controlled and whether the controls will be effective. I note that Ms Sycamore's planning evidence seeks the addition of noise provisions to Chapter 25.8 of the District Plan, but no specific standards are provided. Ms Sycamore then proposes wording for a new policy to address the noise issue. I consider that the proposed policy should not be included in isolation without corresponding noise standards. I consider that further work and research is required to understand the effects of noise on the long-tailed bat before any changes are made to the district plan. In addition, I consider that there are practical difficulties with introducing a separate noise standard for new activities into an already urbanised area with its own existing noise sources and noise controls. In any event, I consider that there is no scope within PC9 to introduce noise standards in relation to SNAs. They were not included in the notified provisions, nor was the proposal evaluated in the Section 32 report. Paragraphs 42 to 49, SNA mapping. At paragraphs 43 to 45, Ms Sycamore states that the HCC's expert evidence in the Section 42A report focused on whether black mudfish should be protected, rather than considering the broader submission point seeking to include provisions for the protection of unmapped areas that meet the regional policy statement criteria for an SNA. I consider that there is no scope to include provisions for unmapped areas in the district plan, including to protect the black mudfish habitat in PC9. I concur with Dr. Muller's evidence on this point and Ms Buckingham's statement in the Section 42A report that the protection of mudfish habitat is provided through regional policy and rules and would also be expected to be addressed through any plan change process for the urbanisation of rural areas. I do not support the policies proposed by Ms Sycamore in paragraph 48 in relation to the first proposed policy. When read as a whole, Chapter 20 already references the regional policy statement criteria, Appendix 5, and the purpose. In addition, policies 20.2.1a and b address the identification and mapping of SNAs, and it is unnecessary to repeat this. In relation to the second proposed policy, I do not support the inclusion of a policy seeking recognition of unmapped sites, as it would potentially result in new unmapped areas being identified that were not identified in the preparation of PC9. It is also unclear how identification would occur. I consider that the proposed policy is outside the scope of PC9. Paragraphs 50 to 54, notification or non-notification rules. I do not support DOC's requested change to figure 1.19a as set out in paragraph 54 of Ms Sycamore's evidence. Figure 1.19a is a flowchart for determining notification and is included in Appendix 2 of my evidence. The flowchart only applies to restricted discretionary activities. The activities DOC submission relates to are those that fail a standard and default to non-complying activity status. So under the figure of the flowchart, DOC would fail the first limb and fall to be considered under Section 95 in the normal way. In practical terms, the flowchart simply does not apply, and amending it to accommodate a non-complying activity will not deliver anything useful for DOC. Instead, DOC should be satisfied that any non-complying activity that causes a minor or more than minor adverse effect on bats or any other threatened or at-risk indigenous fauna would be evaluated under Section 95 in the usual way, which will ensure DOC is a notified party when appropriate. Moving now to Te Awa Lakes. Dr. Muller and Mr. Dean address SNA C59 and C76 in their rebuttal evidence and state that the areas that have not been subject to consented vegetation clearance still hold ecological values and critical habitat. They conclude that the SNAs C59 and C76 should be retained except for the areas identified by Mr. Dean in his primary evidence dated 14th of April 2023. In relation to C76, I support the recommendation to not remove any further areas other than the amended boundaries recommended in the primary evidence of Mr. Dean, noting he also had a correction that he presented today. This is because at the date of mapping, the vegetation and the associated ecological values remain, unless the landowner presents evidence of the guaranteed future removal of this remaining vegetation, which is not necessarily what the consent envisages. The SNA may still serve a purpose. I accept, however, that if the vegetation is guaranteed to be removed, the SNA serves little purpose. Similarly, regarding C59, while it is noted that there are ecological values in the area referred to as the Pines, this area has been identified for removal as part of consent in 2021. However, noted by Dr. Muller, removal is yet to occur and there is evidence of bad habitat in the area. It is quite possible that as part of the ecological management plan associated with that removal, some critical vegetation may be retained, which would then be protected by the proposed SNA. Ultimately, I consider that the SNA must serve a useful purpose, and if all identified ecological values are removed as a result of consents being given effect to, then there may not be any useful purpose to the SNA. But until that position is made clear by the consent holder, there are ecological values that warrant protecting. A dear company, Mr. Ben Inga, paragraphs 11 to 14, proposed new explanation. I support the inclusion of an explanation to accompany the proposed new objectives and policies as agreed to during the expert conferencing and confirmed in the Section 42A report. I've reviewed Mr. Inga's proposed explanation, but I consider it goes wider than the objective and the policy intent, which is to address SNAs throughout the city but not other areas and zones. Accordingly, I suggest the following amendments, specifically to the second sentence, which is to help achieve an integrated approach across all significant natural areas in the city for restoration of long-tailed bat habitat and monitoring of long-tailed bat activity is required. Paragraphs 15 to 17, numbering. I agree that the numbering may require correction. This is an administrative issue which will be identified and resolved through the E-plan process. I disagree that the paragraphs 18 to 23. I disagree that the reference to Eurobats guideline and the objective and policy referred to by Mr. Inga should be deleted on the basis that it will make the provisions less clear, because Plan Change 5 did not do so. I have no objection to its inclusion as recommended in the Section 42A report. I note that Mr. Inga has consolidated Plan Change 5 changes in the PC9 recommended changes in its Attachment A. I disagree with the ordering of the points in the explanation, including the movement of the sentence in blue below the explanation for the Peacock precinct. I note that this is an administrative issue and will be settled once the plan changes are made operative and merged with the operative district plan. Paragraphs 24 to 27, offsetting and compensation. In my view, the general reference to best practice guidelines for biodiversity offsetting is appropriate, particularly given the draft National Policy Statement on Indigenous Biodiversity is yet to be gazetted and may well result in a future amendment to the district plan if it occurs after the PC9 is heard and decisions made. I disagree that until that occurs there should be no reference to the best practice guidelines in the district plan. If biodiversity offsetting and compensation principles are embedded into the MPS-IB, then this can be dealt with at a later stage. It is unclear when the MPS-IB will come into effect, however it could be sometime before that occurs. Conclusion. I recommend removing the easement area from SNA C26 as 29 Petersburg Drive, and the rest of the SNA extent should remain as notified. I do not support the proposed noise policy proposed by DOC as it is beyond the scope of the submission in PC9. I do not support the proposed policies relating to SNA mapping as a suite of SNA provisions already include reference to the regional policy statement and the mapped SNAs in the district plan. Furthermore, I strongly oppose the inclusion of unmapped areas being subject to the same SNA provisions as this goes beyond the scope and intent of PC9. I do not support the amendment of figure 1.1.9a. I support the removal of C59 from the SNA mapped layer on the Te Awa Lakes land if the identified ecological values are removed as a result of consents being given effect to, but only if the position has been made clear by the consent holder. However, I do not support any further amendment to C76 unless the landowner presents evidence of the guaranteed future removal of the remaining vegetation. I support the inclusion of an explanation to accompany the proposed policy related to long-tailed bats to be inserted into the district plan. However, I propose the alternate wording as set out above. The numbering issues are noted and are an administration issue to be resolved through the E-plan process. I support Ms Buckingham's recommendations regarding the referencing of documents and consider they should be retained.
Thank you, Ms Gould. Thank you. Dave?
Yes, questions. Just on the notification matter, I've got a hard copy of that which is attached to Sycamore's summary statement. So, I mean, as it stands, there are three agencies, NZTA, Kiwi Rail and Hamilton Airport, all of which I guess have assets that they are concerned about. And then you've got Heritage New Zealand, which in terms of its legislation would have some sort of responsibility. And I'm just wondering, you know, where DOC might fit into that or not. But in terms of the drivers through the, this is a bit of detail here, the drivers through the diagram, do those bodies only get involved if it's a non-complying activity? Or do the rules on the left-hand side, the fourth box down on the left, do they relate to a range of activity statuses? So they get involved maybe at an RDA level?
Yes, so those four boxes that are further down, apologies, I can't find my version. Thank you. Those are all restricted discretionary activities, right, and they're marked in the plan as with an asterisk as well.
Yes.
And that's when it falls through. You answer those questions, and that's when you get to that. Where DOC has asked for inclusion in this fourth box, you wouldn't actually pass the answer yes to that first question anyway. You'd end up with the no, and it goes straight across to a Section 95 assessment.
Right. You'd go straight across at the third box.
Yep.
Right. Okay.
The top one that says notification will be determined in accordance with Section 95 of the Act.
Right. So that's the way that the specific rules that DOC is concerned about would work. They would go across to non-complying at that point.
Because they are non-complying.
And that's what you were saying?
Yes.
Okay. All right. Thank you. The way the plan works in terms of Appendix 1.22 and 1.23 about this is what you have to assess, and then 1.22 is about this is what you have to provide in the way of information. If I look at what this proposed 1.22x in relation to biodiversity offsetting information, the first thing it asks you to do is assess the proposal against a couple of policies. And I just wondered whether that was an approach which was undertaken anywhere else in 1.2.2, and it's not. And I thought, well, I wonder why is that the case? And of course, you have to assess an application against objectives and policies. And in any case, don't you? Under 1.23, when you look at the guidance for going to assessment criteria, before you go to the ones which have got the alphanumeric A, B, C, D, E, and before you get there, it requires you to look at all objectives and policies. So I just raised the question as to whether assessment against policies 22, 1D and E is actually even necessary at that point, because you're already required to do it. Okay, and then that leaves the guidelines, and I did ask a question before about guidelines. I might leave that to ask Ms Buckingham about, because it does come up in relation to the Eurobats thing too. It just seems to me on the guidelines issue, the reference to those issues is that they've sort of come up a bit ad hoc, and having a reference to a guideline sitting underneath the objectives and policies seems to be a bit of an odd place. I mean, it's an information requirement, maybe, it could be somewhere else. So that's another point. Another planning point is in relation to a rule, or in relation to developing a property. A property owner would typically go to the zone, and they'd also probably go to any overlay that applied to the zone, and they'd find out what they could or couldn't do. If you had an SNA that wasn't on your property, you could still be affected by it because there's that 20-metre rule in relation to lighting. I just wonder whether it would be advisable in that case to have a cross-reference to say, you haven't got an SNA on your property, but you better be aware of the fact that there might be something that affects you. It's just, usually, just to summarise, you usually find your guidance within the zone or the overlay rules. You may miss that in this particular case. I can't think of another example where an overlay that sits off your property actually affects you, because we don't have any yard setbacks with this one.
No, and it's a unique, situation, trying to accommodate those setbacks and those lighting,
yes,
and where that's sat. And it didn't comfortably sit in SNA because you're not going to pick up those properties that you're trying to. The thing is, though, the lighting and glare is a city-wide chapter, so
yes,
that should also be considered across the city. But yes, I agree there could be a
someone
cross-reference.
experienced looking more broadly might say, oh, you've got this SNA sitting off the back of your property in the gully. It's not on your property, but you better have a look at that anyway. But I just raised that as an issue in terms of drafting.
I agree that cross-referencing would be helpful.
Thank you.
Yes, thank you. Just in your primary evidence at para 32, you referred to the nature and the city strategy, the biodiversity strategy, and I think, Mr Muldowney, that might have been the strategy I was thinking of, which is in your legal submissions, but I think it was referred to somewhere else as an action plan, so hence the confusion.
Right.
The 10% target of Indigenous vegetation, is that something that's stated in that strategy itself? Is that where the 10% comes from? Okay, thank you. And then I asked a question before around the differentiating between the floristic and the corridor SNAs, and whether it was an approach that had been taken in other council plans. And I think in your evidence you say it's relatively unique. In your experience, do you know of any other councils that have made that sort of distinction in their plans?
So it's different in terms of what it actually controls, but I understand that Waipa has identified they've got an SNA, they've got a bush layer, they do have a corridor area, but my understanding is that's a very wide corridor, and it's not as defined as what we're dealing with in the city. So they have got different approach to different types of vegetation or ecological habitats.
And then the other question I asked before, which I think the Chair picked up on and said it might be helpful for you to respond to, was around, so if an area is not identified in the plan as an SNA, there's not a laguna in the plan because it will be captured or it will trigger other provisions either in this plan or in the regional plans. Are you able to sort of step us through what that might look like where we should be looking to make sure that those
things.
Yeah.
And I've looked very briefly at, so there are regional policy rules or regional rules in relation to the water discharge rules that could pick up these sorts of things. I know that we do have, and I haven't put my finger on it exactly, we do have rules in our current district plan for the likes of the Ruakura area where Indigenous biodiversity or species need to be considered in the development of those areas. But I haven't got anything more detailed than that at present. I'm happy to go away and provide something a little more thoughtful, if that would be of assistance.
Okay. Last check. Yeah, that was.
Anything, Jen? All right, thank you, Ms. Gould, for now. Thank you. I'm aware that we have Morgan coming at 1:15, so I think we'd best take a, is that right, Steve? That's still on? Right, we'd best take a lunch break now, otherwise we won't be getting a lunch break at all. Yes. Is half an hour going to work for you, Mr. Wainoni?
Well, it's fine, but that completes the case for the city so far, subject to leave being reserved to come back and respond to any matters, so we'll vacate and
Right. All right, let's adjourn now till 1:15. Thank you very much. Yeah. Afternoon, everybody. Let's resume the hearing. Thank you. We were expecting Mrs. Morgan to be here at kick off this afternoon, but she's not here. So let's just move through to the next submitter on the agenda, Ms. Gillespie. Thank you. And Miss Breen, I think it is, isn't it? Yes. Welcome.
Thank you.
Slightly
Mr.
different
Chair.
forum for you? Yes.
Pardon?
Slightly different forum for you?
Slightly. It's kind of complicated because like I come in as Alexander Gillespie, but
Yeah.
I have a different reputation.
We'll set your reputation aside, don't worry. Yes.
So I'm speaking as a representative of Firth Street, the heritage part of the area.
Yeah.
But I'm also speaking, I can't help it, but with my knowledge as a professor of international law. My time at the World Heritage Convention, I was the rapporteur, and I'm particularly interested in these discussions around what is international best practice, because everyone's talking about it, but it does concern me that many people don't seem to have actually read the documents. It's a long way. My work in heritage, I think if people have been to London and they've seen the Tower of London and they've seen a visual corridor where you can actually just see the tower, the Thames and nothing behind it, that's my work. That was what I was doing when I was in World Heritage, trying to create a visual corridor. But the gap between London Greater Council and Hamilton City Council is a large one. And I'm at a point now where I never thought I'd be having to defend heritage in my own backyard.
Yeah.
Now the part I'm talking about, the Hamilton East area, the Villa precinct, is something which has had a recognition for a number of years now. And there's a coherence to it and an integrity to it. And it's been recognised since 2009. It's the planned suburb, it's a model community. It has more integrity and authenticity than many other areas. It's often confused for being English, it's not. The villas are more American. It reflects an international phase of where we're looking at with our history. But when I talk about our history, the things I wanted to emphasise was that your responsibility is, when we come to heritage, it's ethical and it's social and it's legal. And when I'm talking ethical, I'm talking about the past generations, the present and the future. And heritage is about trying to have that continuity between those lines of our ancestors and those yet to come. But it's also critically right now, it's about the communities and those who live in these areas and the identities that we collect and that we create around our heritage. The legal obligation is one I'm sure you're all very familiar with, and this is not just about future heritage, but most importantly, from my perspective, it's about existing heritage and the need to make sure that as we go through these changes, we protect what we already have and not just focus on what is yet to come. I'll be honest, Hamilton hasn't got a great reputation, and we've suffered in heritage, and you can trace this lack of heritage for cultural property back to 1901, which was the decision to actually first break up the 1 acre blocks. 1967, it accelerated, and that's when most of the damage was done to the urban fabric of our community. We were slow to recognise cultural urban heritage in our community. Our first listing was in 1977, and it was only in 1989 that we had 14 houses recognised, of which 5 were in Hamilton East. Now, that trend, we were slow off the mark, we were reticent to make inscriptions, and then it must be said we made some critical mistakes in recent times. We're probably the only area in the country that has a heritage list which has deleted properties on it, whereby we've lost church grounds, we have lost the convent. There are parts of our history which are missing, which creates a great sadness for me. And so when we turn to now, we seem to have swung full circle, and we've gone from having no recognition, a situation where we're damaging what we've got, to now that we've got a proposal for 32 historic heritage areas, and it's kind of gone like from nothing to a lot. And my concern is that we have to get the balance right between existing heritage and future heritage. If there's one peer review which I would commend for you. It's Dr. Kai Gu's report, where he looked at the proposed plan change 9s. Two things merit underlining. The first is that the special character of the current district plan, which is already recognised, should be placed as part of a core for a large project. Recognise the existing areas is what he says, and then use that as a core. And the second thing he says is that there is a part of Hamilton East, which is obviously the military settlement, which is beyond local significance. It's potentially national significance. And yet we have not fully elaborated or explored this possibility. So, to come to my point, what is international best practice? When we talk international best practice on heritage protection, we talk ICOMOS, which is the International Council of Sites and Monuments. As rapporteur for the World Heritage Convention, I oversaw some of their meetings and partook in a number of their deliberations. But to make it applicable now for what I would recommend that this body listens to are 6 principles. 1, first principle, the most important of all, people and communities are the heart of heritage. Conservation is not something that should be imposed upon them or forced on them. You need to listen to them. And so I get saddened when I see so much emphasis from people who do not live in the communities, from people, ministries in Wellington, as opposed to the residents. So conservation is about people, and that's the first principle you can extract from ICOMOS. Your second principle, it's about areas. It's not just about individual houses. And this means you must look at your ensembles and you must look to a cohesion of a place. Third principle, it's about integrity and authenticity. You can't just say a place has got heritage values. You must show it has heritage values. They must be authentic. They must have integrity. And the significance here, when I'm speaking for Firth Street, do not muddy the areas. Do not combine areas if they are not the same. If you've got an area which has got potential national significance, do not muddy it with an area which others are arguing has a debatable significance. Fourth, historic urban heritage evolves. It's not a glass jar. It's not something that you just put into one place and you just look at it from the outside. You want to make sure it evolves in an appropriate way. So it's about evolution, it's about development, it's about use, it's not about exclusion. And the word appropriate can be broken down to 3 things: scale, spatial design, spatial impact and design. Last 2 things. Best practice for ICOMOS, point 5, buffer zones. You have to start thinking about these areas. If you've got a protected area which has got good protection within it, but nothing around the side and the buffer, you will often be overshadowed by the development around it. Yet buffer zones, despite being so important to ICOMOS and being best practice, are barely mentioned in these documents. Final point, you've got to look at the other amenity values, and that is considerations of traffic and considerations of nuisance. It's not just about the place and the buildings, it's about the flow through these areas and the impacts of other developments. So, there you have it. I'm Al Gillespie. I'm trying to give you my knowledge as someone who's been involved in international best practice. I'm also trying to tell you I'm a member of this local community, and it all comes down to 2 things. People, you've got to put people and the residents in particular and the communities that live in these areas at the forefront. It's not about the developers, it's not about people in Wellington, it's about the people who actually live in these places. 2, focus on the core. Look at where the heritage values are strongest, build out from those areas, and have buffer zones where appropriate. Thank you.
Thank you very much, I appreciate it. Just on one matter. What's coming forward, and it's coming forward next week, is the proposition of sort of 3 development periods. Have you got any comment on the appropriateness of those particular 3 development periods?
no comment on the development periods per se. My focus is more about protecting what exists and making sure that the buffers around it are justifiable.
Yeah, yeah.
I become concerned when I see that some proposals blur areas. And I think that's a risk for the existing areas, and you don't want to do that, especially when the existing areas are currently underrated. I think some of the existing areas you've got are not just local significant, but national significance. But if you muddy them, you could lose that value, and you have a legal obligation to protect that.
Yeah, yeah. And we certainly observed that as we drove around yesterday through some of the HHAs. Whether they're muddied or just confused, I'm not sure which, but we certainly observed that. Dave?
Yes, and I had the same question on cohesion, came to mind immediately about what we've already seen, is that, you know, there is a variety of quality. Some areas, I mean, if you were just to take someone and say, what do you notice as you drive into this area, and it's very solidly representative, maybe a particular development period, I think the answer is quite immediate and obvious. But there's other areas you drive into and say, well,
yeah,
it's a bit sort of I can sort of see it, but it's a bit patchy.
Conservation areas, authenticity and integrity. If you don't have authenticity and integrity, whether it's cottages, villas, bungalows, or the period that you're looking for, you risk undermining everything else. Protect what's there that already has the value and expand slowly. If you're unsure of these other areas, you're better to say this should be a buffer zone and use that as a protection rather than try to inflate values which may not be there. I'm not saying they are there or aren't there, but I am saying you've got to get the buffer zone and the protection around the core correct. Otherwise it will end up being like a glass jar.
I think probably where we are at the moment, I'm not sure whether the buffer zone would still be sitting there waiting for us.
Yeah.
That's the problem, isn't it?
Yeah, well, it's also, like, it saddens me because, so, like, we're at a point now, this is 2023, but we started this in 1901. You know, and 1901 was when they broke it up the first time. 1967 was when they did most of the damage. And we all know Hamilton, and you know some of those suburbs you can go through, and they're a mishmash of heritage and 1970s building. But some areas weren't affected by that, and there's a chance to still save those areas. And when I say save those areas, I would like you to see that in continuity, not just with the communities, but also what we have lost. And we continue to lose heritage in this community, in our city, on a regular basis, and it shouldn't be that way. We have a chance to be national best practice, and that's what we should aspire to.
Suggests to me that the number of heritage areas should be fewer rather than the number that's come forward. Is that sort of, do you have a sense of that? I mean, what I'm taking from you is, without being unduly pure, there's a degree of purity that you're suggesting needs to be at the heart of whatever area is defined.
Every heritage area must have authenticity and integrity. You can't just say this is heritage. You've got to be able to justify it. And the language that I come from ICOMOS and World Heritage, you would go into an area, you would look at the sites, you would look at the streets and the layout, and you would make sure it had that kind of integrity. I do not pass comment on some of the modern proposals, but I do note that the doctor who did the first peer review, he did say that there was a problem with some of the 1960s to subsequent period. I think it was 13 sites, and you want to make sure that that's justifiable. It must be justifiable, because if it's not justifiable, you're going to find there's going to be a backlash in the community and that people will come after those zones. And if that happens, the risk is not just to what was unjustifiable, but everything that was lumped in with it.
Yeah. Vicky? Ewan? Appreciate your time today. Yeah, thank you very much. Is Mrs. Morgan here now? Still not here, okay. She has pride of place, so when she comes, we all let her in. That's how it is. All right, we'll move through then to Julie Griffin.
John today,
Sorry?
John.
Oh, is it? Well, you're masquerading today as Julie on my calendar, so feel free, yes.
You have details of my property in front of you, I guess, do you?
We have aerials. I don't know if are we tracking, can we bring them up? Do you want us to bring up the area?
I do, because that's my first question I have for you, actually.
Right. I'll just pull that up. Is it 170 State Highway? Is that
Yeah,
the
that's
one?
correct, yes.
170 State Highway.
Oh, sorry.
Yep.
The orange one. Oh, okay. Right, no, it doesn't. Show it. Zoom in.
Yours is the rear property, isn't it?
That's
Is that
correct,
right?
yes.
Yes.
Okay.
So it's the one at the bottom of the picture now, that one. That's
Yeah.
it.
Yeah.
Right, now, several weeks ago, a month or so, two back, a lady came around representing the council, pointing out where what was going to be claimed as a significant natural area. And apparently, originally, it was going to be right down by the Gorse line and Blackberry line, and the council had now changed that to include my land that just had one willow tree on it and one pine tree. And I want to protest against that, very much so, because there's no reason for that.
Right. Can anybody help on this one? I mean,
The surveyor lady actually agreed with me. She said, I don't know why they've done that. She said, but I do agree with you there.
so how far inside the boundary are those two trees?
One's just about 6 feet from the boundary, the other's about 30 feet from the original boundary where the gorse is.
Well, I guess we can look into it.
If you would, please.
And I guess what you'd ask is that be removed, if not
Yes, and
absolutely
taken down
essential.
to there. Yes, please.
Yeah, well,
Now, the other thing is, I understood that our purpose here today, or anybody that had any objections, was to be listened to by the council. But I find out that this legislation's already gone through. So I'm just wondering really what the purpose of me being here today is.
I'm not sure what you're referring to.
The SNA 9, it's already...
No, it hasn't already gone through. We're a panel of independent commissioners, we're not council. And we are hearing and we'll make recommendations on the plan change, but that's a long way ahead of us yet. This is only the third day of hearing, so...
I got a letter from the council lady the other day saying it was law already, from the Hamilton City Council.
Well, you can take it from me, it's not.
Okay, thank you very much. All right.
Don't worry about that.
Now, the other thing...
So we're here to listen to you, and you have probably another 5 or 6 minutes,
Sure.
so over to you.
The other thing is that by doing this, I'm, like a lot of people, my main asset is my home, like a lot of average Kiwis, and that's virtually all. But you're actually reducing the value of my land by doing this. And I believe that I should be given compensation on a pro rata basis according to the government valuation of my property on the piecemeal. I think that's fair and reasonable. The council has stated in the information I had that there will be no such thing, but I disagree with that, and I think it's very unfair because it is devaluing my property. In other words, if someone went to your bank account and took $50,000 or $60,000 out of it, you'd be very upset. Well, that's effectively what's going to be happening to mine, and not necessarily that figure either.
Right. I mean, the first point you're making is that you want clarification as to why part of your land is actually within the SNA anyway.
Yes.
So let's deal with that one first of all.
Yeah.
The issue of any compensation, that isn't part of what our brief. We don't have that power because we're not deciding that matter. So,
right. Well, you see, this is where I'm saying that it's outright thievery. But as I say, it's not your. Yeah. Now, the next matter is that what I've got down there, they're classed as significant natural heritage is gorse, blackberry, and tobacco weed, and a few painters. In bygone days, they were probably up there for the council for not clearing the land. But so I'm somewhat amazed as to why they really see any benefit in this.
Well, that will go to the question as to whether or not the line's been drawn appropriately or not. So that's part of that question.
I'm arguing that none of my land should be in it.
But there are two sorts, and may as well talk about that. There are two sorts of SNAs that we're talking about here. One is a vegetative one, and the other is a sort of a connectivity one for bats and so on to actually use as flight paths and corridors and places to feed and so on. So there's slightly different things. It's possible and probable that if that part of your land is being earmarked as an SNA, then it's that latter part that's being called upon rather than the vegetable part of it, if you like.
Yeah, well, I've certainly never seen any bats down there. As I say, there's a few ponies that are native. That's all. Yes. You can't get down there now. There's that much. But the other thing this also brings to me, there is another section. In fact, there were two sections of in that land there that could be developed, and there's a possibility there may still be two, but there'd be hugely extra costs if I was to develop the second one, and I would incur those, and I believe that any extra costs the council should be facing those. If someone wanted to develop that land, be it me or someone else that I sold it to, the council should be responsible because they've incurred that. So because there's extra steps to be taken in the application, I don't see why I should have to find that money.
I understand the concern.
Mm-hmm. And the other thing that's, I'm amazed at the way this has been taken, because we've got Maori land claims been going on now for forever and a day, and they'll probably carry on forever and a day too. But I think this is bad legislation, what the council is seeking to do. I mean, people that enforce bad legislation, to me, are just as bad as those that make it. I'm also aware that a lot of this stems from the United Nations, which New Zealand's signatory to, and
I think we're getting a little bit far off field on
but it comes back down through the government and to councils. But it should be mentioned, I think, and that's all. But that's all I've got to say. As I say, you've effectively taken money out of my bank account, as far as I'm concerned, and I would want compensation for that.
Well, thank you, and we'll explore later on as to why that slither of land of yours is necessary or not. Thank you very much.
Can I just help with that question? I think I've overheard it. So just to be very clear, that this is the evidence that's attached to Mr. Dean's primary statement, and what you're seeing up there is the difference between the notified version of the mapped
and what he's proposing
area and what he's now proposing. So you can see that the notified area was the original dotted yellow, what looks like yellow or green dotted line. It's the notified version.
Yeah,
and then after re-inspection, it's now the
back
new
on the fence line.
So there is a reduction in the mapped area of the SNA on this particular property.
But is it off the property or is it still on
the
property?
I mean, you can see the cadastral boundary goes right. You can
goes
see
right down to the bottom here.
Yeah.
Right. Okay. So it has been moved.
It has been moved. It has been moved. Willow tree and pine are not. Well,
it's been moved off the paddock. Yes.
Yeah, that's a start. Yeah. I'd like to see it move off the whole lot, but.
Right. Right. Thank you, Mr. Griffin. No, still not here. Okay. Tony Street.
What I didn't present the electronic version of the
Sit yourself
material.
down, that's fine.
I've
And
just
you
got,
leave a copy with
nine
us.
copies here. Shall I just hand it out now?
Have you got one copy or more than one copy there? Mr.
I've
Rice will
got,
sort, Mr. Rice will
a
sort you out.
copy there.
Yeah. So just take a seat. Yep.
Yeah, so actually I'll just wait till that's handed out.
Right.
So my name's Tony Street, and my property's at 8 Minchin Crescent in St Andrews in Hamilton. And part of the land on my property is a steep riverbank and an SNA, which I believe is a corridor SNA, has been placed over approximately 2/3 of this part of my property. So my submission doesn't represent an attempt in any way to remove this SNA in total. I'm not trying to do that, but what I'm proposing is that the area of land subject to this SNA could be reduced without any adverse environmental effects, and I'll just don't explain why. But I've attached 2 aerial images that support and demonstrate my submission. The first of them, the first aerial photo attached there, shows a boundary line of the SNA. That's not just in relation to my property, but in relation to the property next door at 16 Minchin Crescent, and also the council reserve next door on the right-hand side, that's owned by council. So you'll note that Hamilton City Council has placed a very substantially less restrictive SNA or corridor SNA on reserved land that it owns below the house right next door to mine at 4 Minchin Crescent. And I can well understand their reason for doing so. That's because land on a sloping gradient requires much greater effort and expense in terms of maintaining the land consistent with SNA objectives, and for the likes of achieving a 10% targeted and Indigenous cover and that sort of thing. So, I'm just making a comparison here. I'm not in any way trying to criticise Hamilton City Council's boundary next door on their SNA. I've got no problems with that. All I'm trying to suggest is that my SNA could be eased without adverse environmental effects here. So
the slope that we're talking about on your land is presumably the same as the one next door, or it's a different slope?
Yeah,
it's the same slope?
Yeah, both steep slopes. Yeah.
Yep, okay.
So the next aerial image on the handout shows the SNA boundary line on my property. That's the second image there. And I've calculated that the land area occupied by the riverbank of mine occupies 405 square metres of land, and that of this total area, 65% or 263 square metres will be subject to SNA covenant. And I've also used a council aerial mapping tool to calculate that the overall average slope on my riverbank is slightly steeper than 45 degrees, which is pretty steep. The riverbank adjacent to the several properties, to the properties surrounding me at Minchin Crescent, are very well recognised for their very steep slope. A key reason why maintaining the SNA covenant in my property would be very costly, is because there's practicalities, I believe, such as health and safety, or OSH issues, pertaining to people trying to undertaking, I should say, any form of preservation and gardening and SNA maintenance work and that sort of thing on steep slopes. And slipping and falling can and does cause serious injury, especially in the case of over 60-year-old folk like myself. So I next note that while the annual rates bill on my property is high at $4,200 a year, I'm not seeking a rates rebate because I know the Plan Change 9 makes no provision whatsoever for financial compensation to ratepayers. So I get that. However, I believe that a reasonable request is to reduce the size of the SNA area on my land in a way that does not detract from council's objective of providing a suitable habitat for long-tailed bats, lizards and the like. And just to expand on this point, by adopting my revised SNA boundary line, the riverbank corridor width for indigenous fauna will still be at least 16 metres wide, and that's at its very narrowest point. Now that's in pretty stark contrast to the council reserve next door, which has got a corridor of just 7 metres wide. And when I talk about that corridor width, I'm talking about from the edge of the river and the edge of that SNA boundary. So what I'm trying to say is that my SNA area could be eased. And nextly, I just make the point, my proposed amendment to the boundary line of the SNA also recognises that on the upper section of my riverbank, the vegetation is predominantly exotic, and an ecological consultant, that was Charlotte Yates of Foresight Consulting, visited my property back in March, and she'd noted during when she went down the riverbank that she'd noted the presence of a few panga and kawakawa, but these are on the lower part of the riverbank, and what I'm suggesting still protects them. So to summarise, I seek an amendment to the SNA boundary on my property in a way that makes maintaining the SNA more manageable in view of the particular challenges presented by my steep sloping site. And I believe that both a holistic and pragmatic approach is warranted. I also believe that I've presented a practical compromise that's between fostering the habitats of lizards and long-tailed bats and the like, and human health and safety related issues. And I believe my solution also helps mitigate a potential grievance that I'm losing control of part of my own land. David, that's all I've got to say about it.
Oh, appreciate that. It's a nice and clear submission. Thank you for that. And,
just a question. You've said in your submission that you're seeking an amendment to the SNA boundary line. Are you proposing that it be completely removed, or have you provided us with a plan showing where you thought it should be moved to?
Only that it's eased, only that if
I think the purple is the purple line your proposal?
The purple line there is my proposed amendment, and the green line
and presumably that purple line is on the same contour, is it? Is that why it's there? What's the reason for the line where you've put it?
Well, like ideally, David, I would have said take it all away completely, because it's all on a 45-degree slope. It varies a bit, but that's a general slope. But I'm not, I'm mindful of the needs of different stakeholders, and I'm not trying to overturn the thing in total. But all I'm trying to say is it would make it much more manageable if the area was reduced from my part.
Yep.
Thank you. Okay. I just had a question for council. I'm just on the Hamilton Plan website, and am I correct that the area to the south is already part of an SNA? So it's only the extension which covers Streets land? It seems like that's crosshatched to the south on the plan I'm looking at, whereas the proposed SNA is just across.
Yeah, I see the same thing as you. It's already directly to the south and to the east.
Yeah.
Not on the property.
Yeah, so when Mr. Street was addressing us about the difference in treatment, the difference is that at the moment that Hamilton City area is already an SNA, so it wasn't necessary to extend it through this plan change. Is that correct? Because it's already shown as
Could
SNA.
I just point out that this is a download straight off the Hamilton City Council's website?
No. What we're trying to work out is whether this area here under your yellow arrow is an existing significant natural area, which isn't shown because what's shown is the new bit that's being added by Plan Change 9. So we're just trying to find out whether this area is in actual fact an existing SNA and will continue to be one. So we're just trying to get that question.
There's no existing SNA on 8 Minchin Crescent in the operative plan.
Yes, no, I'm not talking about Mr. Street's property, I'm talking to the property.
This bit here? This bit
in
just
this
underneath?
Picture.
Yeah.
That appears to be an existing SNA on the...
Yes.
So.
Yes, to the south, yes.
Anyway, we can sort that out. We absolutely understand what you're after,
right.
And thank you for being so clear and for having the graphics. Graphics are always very helpful for us.
And again, finally, I'm not trying to be any way critical of Hamilton City Council and that reserve land next door. What I'm trying to suggest is that my SNA line could be reduced without adverse environmental effects, that's all. Thank you, David.
Thank you very much. Appreciate your time today. Right. Have you had any luck with Mrs. Morgan?
No.
Right. In that case, Dr. Fogarty, is it you or is it Mr. Fletcher again today? All three of you? You got the whole company today, did you? Yes. Right. Yeah. Let's just find the various bits and pieces that we need. We've got the statement. We've got the image. And we've got the legals. There's the legals. Right. Right. Get up front.
Thank you, Commissioners. So you all know me, and you met Mr. Fletcher yesterday with the submission that he read, and this is Ms. Burton, and it's her property that we're coming to talk to you about. Ms. Burton has asked for Mr. Fletcher to read her statement. Like many people in the public who find public speaking extremely intimidating, this is an environment that's unusual for her, and the whole thing is stressful enough. So we seek your indulgence for that, but she understands that you may have questions and she's willing to answer those. On that point, Ms. Burton has had correspondence with Mr. Sharman and regarding the site visit and so forth. She had a site visit in February this year from Charlotte Yates of Foresight, and she can speak to you about the email response, the irony of the fact that her efforts in her garden have meant that her bit of paradise is included in the SNA, whereas the neighbour directly opposite, who has not had the same input into his garden, his has been left out. The other issue is that she has canvassed her neighbours. Now, on the overhead put up here, we've shown you this here is the SNA on Ms. Burton's property. That's her property. So the little bit of white there is her house, and then you've got the SNA coming around, including the platform with her clothesline, including her little bit of grass sort of, oh, I've lost my pointer. Including the little bit of grass and her fire pit down in the bottom. But some of her neighbours are equally, there's a young couple here that half of their property in here is covered, also the neighbours down in here. Mr. and Mrs. Green are here supporting her, and Mr. Green wants to say a couple of words. He's in this house here. Their property isn't much covered by the SNA, but this little community all use the bottom of this bit of gully. It's part of their kind of communal garden. It's actually quite difficult to see the property boundaries, certainly very difficult on the ground to see where the property boundaries are. The Green property was originally part of Ms. Burton's property and was later subdivided. So there's kind of a bit of a wonky boundary line there. They are all opposed, and they have been making inquiries. They didn't recognise the significance of the communications that came through the mail, and I would submit that they're probably typical of a lot of homeowners in plan change situations. They don't recognise the significance, and their response was collectively to email Mr. Sharman, which they did, but that has not followed through to be recognised as a submission or even a late submission. So, so Mr. Green is wanting to, say a few words about his perceptions of how this part of their neighbourhood operates. The other thing that I draw your attention to is, although this is part of the Donny Park SNA, this is very much I describe it as a blind finger of the end of the gully system. And the thrust of our submissions is that it's all very well identifying a significant piece of area that is connective, and it is important, and there's no argument that the Donny Park SNA is an important piece of SNA. But in our submission, that doesn't mean that every little finger off it into private land therefore also qualifies for SNA status as being a connection or a corridor. And clearly this is not a corridor to anywhere. These are houses here fronting Donny Ave. There's no connection between this. There's no public access into here. There's not even physical access for the neighbours walking back into this area. So this is very much people's slopey sections that they have either turned into garden or where they tip their lawn clippings. The other overarching comment that I would make is that SNAs impose significant obligations and restrictions on landowners, and they should not be imposed on private property lightly. There needs to be really, it needs to be essential to meet the goals of protecting SNAs. So in my submission, you need to be satisfied that each property is essential for protecting the overall SNA qualities. And it's not enough just to say it's an extension of the Donny Park gully system. It needs to be essential for protecting those areas, those significant habitats, and significant indigenous vegetation. you've had my legal submissions. I'm going to kind of summarise through,
Right.
but it's easiest for me to keep track to actually go through it.
Right. Thank you.
In terms of the proposed national policy statement on Indigenous biodiversity, in particular, although we accept that this is not lawful yet, it's providing essential government direction. And in particular, we would note the emphasis on partnerships with landowners, so that there isn't an overall theme coming through here that this is to be protection imposed on landowners. It's to be done in partnership, and it should be, there should be transparency. And that is our biggest criticism of this, is that we have searched, we've asked for the report on the Burton property, and the best that we've been pointed out are the recommendations in the reports that have come back that have added an additional criterion. So criterion 6 of this significance criteria wasn't there originally, that's been added in. But nowhere have we actually been able to see Ms. Yates's report from her site visit in February. We've searched for, we asked for it and was sent a link back to the material that's on the website. We've searched, we haven't found anything specific to this property. And in my submission, that's not good enough when you are asserting that there are criteria of significance that warrant a particular property being part of an SNA where the landowner is opposed.
Ms. Forrest, just before you go on, I'm wondering if you can help us. Is there any case law on that particular point that you're aware of that you could direct us to about where, you know, that need for that individual assessment, that need for having a, I think you've talked about essential, any sort of case law which comments on that particular aspect that you can think of off the top of your
No,
head?
Commissioner, I haven't been able to find anything specifically linking that. In my submission, that is linked to general property rights in terms of obligations where there are restrictions, regulatory restrictions, that there needs to be clear evidence. And I draw to your attention other areas of the law, such as under the public works type legislation, looking at inland revenue type legislation, looking at things where you would not normally expect intrusions into private rights without there being strong evidence, and in fact normal RMA processes where you would not normally expect to see changes in planning and zoning without there being very clear evidence through the Section 32 process and supporting reports. And that's what we haven't found here. We haven't found any of that. And if we had, it would have been easier to actually challenge it. I've identified the relevant Waikato Regional Policy Statement policies and note the emphasis here where you're looking at the number 4, supporting, buffering and or linking ecosystems, habitats in areas significant, identified as significant Indigenous vegetation and significant habitats of Indigenous fauna. No argument that the Donny Park gully system will fall into that category, but is this corner relevant to that? Contribution to natural character and amenity value 7. In my submission, that needs to be read in conjunction to the ones above, where you're talking about Indigenous ecosystems and Indigenous vegetation and habitats, not private amenity. Policy, yeah, we had a bit of a, there's an issue with the website has updated, as I'm sure you found, updated the policy statement with the standards version, so the numbering's all changed, so we thought we would cover our bases. That provided a bit of confusion to start with. Again, policy 11.2, significant Indigenous vegetation and the significant habitats of Indigenous fauna, protected by ensuring characteristics that contribute to significance. And again, in policy 11.3, working collaboratively with landowners. In my submission, Plan Change 9 provides an areas to be assessed as an SNA if it meets one of the 11 criteria, which seems to be a pretty low bar when it would appear that anywhere slightly wet, such as Ms Burton's overland flow path, which is from a piped stormwater system, is sufficient for that to be a wetland area. That's a low bar, in my view. The objectives and policies require an assessment of ecosystems in the context of overall health and habitat of Indigenous biodiversity, and that's as per the policies themselves. In my submission, they're there to retain significant habitat connections and to protect threatened species where they're known to be living. I live in Riverlea. That's very close to an SNA, which is a known area of bat community. I have no doubt that bats are do not confine themselves to the SNA area. They fly, so they probably fly further than outside the SNA that's at the bottom of the park behind me, and they probably fly into my property too. And they probably fly around our neighbours. But that doesn't mean that everywhere bats fly needs to be turned into SNA.
You're not offering your property as an SNA. No.
Good luck. This piece of created landscape around the Burton residence neither connects significant habitats, nor is it significant in its own right in relation to any particular plant or animal species that is threatened regionally or nationally, and there's no evidence of any monitoring, of any assessment of that. Nor has there been engagement with the landowner in relation to protection of significant habitat. That's because it does not encompass any identified significant and at-risk habitat. This garden's not a corridor. It leads to no significant habitat, whether that be Indigenous vegetation or wetland. It's a created garden that has been designed to enhance and stabilise the steep bank and to provide a restful haven for the landowner, her family and adjoining neighbours. It is full of exotic bulbs that will continue to regenerate. It's not a case of, even if Ms Burton was minded to abide by the rules, and there is a question there about enforcement and monitoring in a private enclave surrounded by other private gardens, there's no requirement for her to stop her garden that is there propagating and continuing and developing. Appendix 9 of Schedule 9C of Plan Change 9 states that the assessment method criteria for determining Indigenous vegetation and the sites were assessed using the regional policy statements criteria, which is not surprising because those are the criteria for significance. Proposed SNA has been identified as a corridor SNA habitat. That is to be delineated, an area to be delineated by topographical or vegetation features, and in this case, it's the gully. The line stops right at the bottom beside Ms. Burton's boundary. Her neighbour's property begins at the bottom and goes up. His is not included. I suggest that if there is a corridor there for wetland species or for bats, they're not going to stop at the boundary of her property. They're just as likely to go on, and it begs the question as to how you are mapping and why. Is it just the fact that she's got a beautiful garden? Turning the page now, I think if we look at the particular criteria, I'm not here trying to provide my own expertise because obviously I'm not an expert ecologist or landscape architect. But what I can do is look at evidence that the methodology has been provided, has been applied correctly. So we're not challenging the methodology, and we're not in a position to do so. And in fact, we're aware of the expert caucusing, but by the time Ms. Burton realised she had an opportunity to actually have advice at the hearing, it was too late. That was already happening. So there is no expert ecologist. Ms. Burton herself is a landscape architect, so she has her own expertise. So looking first of all, paragraph 1, we found it a little bit difficult looking at the documents to figure out who was saying what. There were recommendations, and so originally we had put in that it was Foresight has determined, but now we've had another look and it's in the Hamilton City Council master data set. And we assume that that's based on Foresight input. So that data set said that the proposed SNA meets criterion 1 due to it being partially protected at the northern end by Hamilton City Council Reserve, and a QE2 covenant exists on private property at the northern part of the site. That's actually the northern part of the Donny Gully site. And there's a photograph that's in Ms. Burton's evidence that demonstrates how far away that covenant is. So it looks to be about 850 metres north. The criterion does not apply to the property. There's no link between the covenant and the justification as to why the property meets criterion 1 as a result of it. It does not adjoin the Hamilton City Council Reserve. Criterion 3, the data set says that the SNA has threatened species, so that'll be the bats. On that basis, anywhere in Hamilton that bats might fly would qualify for inclusion. Threatened fish and invertebrates have been recorded. We haven't found any evidence of any threatened fish, good luck, or threatened invertebrate on her property. And in my submission, it's not good enough to say we found some down in a stream through Donny Park. You could argue you found some in the Waikato River too, but that doesn't justify everyone adjoining the river being made into an SNA. Threatened nationally vulnerable plant species, don't know what those might be. I've referred to the Western Lee decision, and I note that that's also addressed in Council's submissions for Hamilton City. And we both agreed that there's been insufficient mapping and protection of SNAs in Hamilton to date. But to globally identify every finger of gully as being the way to do it, with I can't remember the word, rapid visits I think was in the evidence, that it's got to be better than that. Like Professor Gillespie, I would suggest identify the core and work out, rather than trying to just globally identify everything that might qualify. There's comment there that at 26, Foresight Consulting's June 22 report states that although long-tail bats have been recorded throughout Hamilton City, they do not use all areas regularly. The report states that an ecologist determines the threshold for habitat usage on a case-by-case basis. The level of significance is dependent on whether the bats are known to use the area on a regular basis or sporadically. And Foresight states that the Hamilton Gully systems provide a habitat for threatened fauna. These include long-tailed bats that are common in the southern part of the city, but are recorded less frequently across the rest of the city. So that the southern part being the Riverlea and Peacocks areas. Long finials are also stated to be found in the gully systems. Foresight states the records of these species are limited and assumptions have been made about their likely distribution in assessing some SNAs. In my submission, that's not fair. It's not fair to make an assumption that just because you're close to a gully system, that you will necessarily be significant habitat for long-tailed bats and or any kind of threatened fish, eel or wetland species. There is no evidence to suggest these mammals, fish, invertebrate or threatened nationally vulnerable plant species exist on the property or use the property as a habitat to warrant it being part of a proposed SNA, nor meeting criterion 3 of the WRPS. Criterion 4, underrepresented wetland vegetation. It's a stormwater overflow path. There isn't even a little creek or anything. It is no different from any other slightly depressed area. Yes, it may possibly trigger the wetland definition if you were looking at the criteria for a wetland and you were on a farm and you looked at that, but not to justify SNA status. And that's only because it's got some wetland plants as you would expect from a stormwater overflow path. Criteria 6 and 8. Criterion 6 wasn't in the list originally, that's been added. And that relates to the wetland habitat for Indigenous plant communities, as previously, no evidence of that. Over to paragraph 39, criterion 11, that it has a forested area that provides a buffer for wetland habitat and is a linkage for aquatic species and animals. Again, no evidence of that. And how can her property be in and the people on the other side of her gully not? We submit that Ms Burton's property is in no way linked to the proposed SNA or the rest of Donny Park. It's an isolated garden at the end of a blind finger of gully and does not connect through to any other gully system to the north. Ground truthing and assessments. The only comment I make there about these rapid field visits were Ms Yates did come in February. Ms Burton can comment on what she had said, which was also that she didn't see evidence of the property being part of the SNA, and agreed that it was her lovely garden is probably why it was caught. But we have not found anything that actually shows what she said and how her report got translated into the evidence that's before you. We're not aware that Hamish Dean has been to the property, and certainly Ms Burton's never given anyone else approval. She hasn't been contacted by anyone other than Ms Yates to come and do a site visit. Moving to paragraph 47, we submit that removing Ms Burton's property from part of the SNA will not result in fragmentation of the rest of the proposed SNA. It's an isolated peninsula. It doesn't form a corridor. It won't isolate or split up the rest of the SNA. The boundary stretches to her deck and clothesline. This doesn't provide an important ecological function or any service to the rest of the proposed SNA, and it won't impact the ecological value. Ms Burton's not wanting to do anything. She's created this garden as a haven, so she's not wanting to do any subdivision or anything. You know, she'd like to stick a garden shed down the bottom for her tools because it's quite hard to get up and down the slope, but even that would require a resource consent. The rules obligations are significant for landowners. The Section 42A author has adopted the recommendation in the Foresight report because of the overall ecological value of the SNA of the property. And in my submission, there has been a generalisation of each bit of gully finger with the significance of the Donny SNA overall. And that's evident by the connection in that comment to the covenant area and then to the HCC reserve, which are quite a long way away from her property. Noting that as in her evidence, Ms Burton has installed retained stairs, paths, playground, trampoline. She's got 1,000 Clivia divisions on order for further amenity and stabilisation planting below her decks. The rest of Donny Park is not accessible from her property, and her property is not accessible from Donny Park. Had no report, and is effectively being penalised for having looked after her property. At 54, I note that in her submission to Plan Change 9, Ms Burton noted that she was happy for notable trees to be protected. She's aware that protected trees have rules associated with their maintenance and with root protection. She recognises that there are 2 or 3 individual trees on the property that could warrant protection, and she identified in that as submission, but there's been no specific assessment done of those. It is submitted that the recommendation in the Section 42A report, in the report, that the SNA is retained over the property should be rejected for the following reasons. It's a garden, entirely designed and constructed by her, and it doesn't contribute to or reflect ecological value of the rest of Donny Park. There's no connectivity to warrant its listing, and there's been no separate assessment provided which shows how the criteria are met on this piece of land. If there are any questions from me, for me.
I do have a question, and it just picks up on your last point there, where you said there's been no separate assessment. I'm just interested in your view on where a SNA is proposed over private property. Is it your submission to us that we need, for every single private property, we need a separate assessment to make sure that it meets those criteria? Or are there some that you think don't need a private assessment? I'm just trying to think of what's the scope of what you're saying, you know, where does it end, kind of thing?
Actually, Commissioner, yes I do. If you saw, if the boot was on the other foot and someone was being asked to demonstrate that they wanted to do something that required a resource consent and that there was no wetland or whatever, they'd be expected to come up with an ecological assessment that demonstrated that it was fine. And actually, yes, in my view, if it's going on private property, because of the obligations and the restrictions, and the fact that SNA, you only need one of those 9 criteria, then yes, I think at the very least there should be a report identifying how you have assessed that that criterion has been triggered. And that's not available. And so maybe you start with the council-owned stuff and with the really significant bits, and you focus your expertise on those bits, and maybe every few years when you do a plan change, you go and do a bit more as you can afford, or maybe your rules are designed such that if landowners want to do something, they get the assessment done to see whether their property should be, is not an SNA, and it's done that way. But in my submission, yes, if you're applying those criteria to private property, then you should be able to demonstrate they apply.
What's your submission in response to, we had some evidence this morning about that some of the, I guess, submissions that we've had come before us are taking a reductive approach and not thinking about the fact that there is a functionality that arises from the connectivity in the corridor as a whole, so it's very difficult to demonstrate that a single piece of land maybe have a significant function, but if you put it all together, then it's very clearly, you know, and so I guess where is the point? If you took your approach, could we end up with a very disjointed piece of SNA which doesn't have that connectivity, and we end up with the sort of death by 1,000 cuts, and that we're not going to have those corridors, because obviously there's a different approach taken in the plan to a corridor versus a floristic And part of the, I guess, the corridor one is really that connectivity. And I know, you know, for this particular site, you're saying there's no onwards connectivity, but yeah, just interested in your view in terms of what you've just submitted to us.
Commissioner, I think there is the potential for that outcome, but that's probably why you need to start with a core and work out instead of trying to globally identify everything in one kind of sweep of the brush. But for example, the previous submitter, Mr. Street's property, for example, I think it would be easier for an ecologist to come, or a landscape architect to, well, I guess an ecologist, sorry, to be able to look and say this is part of that connectivity of the corridor and demonstrate that. But for that property, I would still expect to see the assessment of that and some comment, some evidence about his property. This doesn't fall into that. Just being at the end of a gully system does not make it part of that corridor. So I think there's a double whammy there.
I was actually going to indicate that we need to take a pause at this point because we have a submitter zooming in from America on a time schedule. So we might just, if you don't mind, we just pause that for hopefully only 5 or 10 minutes for, I think it's Mr. Carruthers. Huh?
It's just 10:15.
Yeah, well, that's not going to be the case, is it? Right, okay.
Thank you for your involvement.
Yes, no. And just whilst that's being set up, I was actually quite interested. I hadn't actually paid attention to your paragraph 10, which is where you have eco policy 2. Just whilst we're getting there, and the last part of that policy is actually was giving me some pause for thought as you were talking there. So we might talk about that a bit later on. That part of the policy says that not adversely affected to the extent that the significance of the, in this case, habitat is reduced. We might have a look at that a bit more closely. Mr. Carruthers, who's where? What's his? Sub 1, 325. He's Jeffrey Place. So what's he got on here? Does anybody know? 2 properties, single right. Garden sanctuary. Okay. Looks very similar. Yeah. Comprehensively landscaped. All right. Mr. Grothers, can you hear me?
I can hear you. Can you hear me?
You're a bit soft. Can you either maybe get a bit closer to your microphone?
Can you hear me now?
Yeah, that's much better. Thank you very much. Right, well, we're all ears, Mr. Grothers, so tell us what you want us to hear.
Thanks very much for this opportunity to outline my concerns regarding some of the decisions that have been made about significant natural areas. My submission is simply focused on a square metre block of land at 6 Jeffrey Place in Riverlea, and the proposal that it should be classified as a significant natural area. Just as a bit of background, my wife and I own both number 8 and number 6 Jeffrey Place. 8 has our home on it, and it abuts the area above the Waikato River. 6 is on the other side of the house, away from the Waikato River and on quite steep slope above the house. They're both on separate legal entities, but share a single right-of-way access. We only bought 6 Jeffrey Place and did that in about 2005 to stop anyone else buying it and putting a house on it. And it compromised our house, being on the north side of the property, creating shade, or if a house was there, in fact, someone really looking at our property. 6 Jeffrey Place at the time had purchased the weedy, unkept section. It had been sitting there for well over a decade, unoccupied, and I believe sprayed twice yearly to keep weeds down. Upon purchase, we planted many hundreds of mostly native ferns, shrubs and some trees. And over the last 18 years, these have become our native bushland. However, that enthusiasm on our part has now come back to bite us, with 6 Jeffrey Place now targeted as a significant natural area, which, if I understand it correct, means that we can't manage it as our native garden, and if we were to sell it, it would be very unlikely to attract a single buyer, a significant natural area. In our written submission, there are photos of the site being planted as our native garden in the years 2005 through to 2007. I understand that the Significant Natural Area drive is being undertaken through the Resource Management Act. And when I look at Section 85 of the Resource Management Act, it does indicate that if a local authority, through its wisdom and decision-making, renders a piece of land incapable of reasonable use, and secondly, places an unfair or unreasonable burden on any person having an interest in that land, then the local authority ruling could be overruled by the Environment Court. Now, I'm obviously not intending, but the point here is that both limbs of that test need to be satisfied before the court would direct a change to the provisions. Section 85 of the Resource Management Act indicates that it is not whether the proposed provision is unreasonable to the owner, that is, the question of the owner's private rights, but whether it serves the statutory purpose of promoting sustainable management of natural and physical resources, a question of public interest. The implication is that a provision that renders an interest in land incapable of reasonable use may not serve that purpose. But the focus is on the public interest, not on the private property rights. Now, I just need to point out that public interest in 6 Jeffrey Place is very limited to absolutely non-existent. It's located down a private right-of-way and does not have a direct boundary onto the Waikato River. No one actually has legal access to it other than the owners. Whether land is incapable of reasonable use needs to be determined on a case-by-case basis. In the case of 6 Jeffrey Place, we're talking about a 900 square metre land that was planted to mostly native plants to make it more appealing than the weedy state in which it was purchased. This has been successfully achieved over the past 15 years, but managing this native sanctuary requires removal of large tree ferns and trees to ensure home on 8 Jeffrey Place, which abuts it, is not compromised. Additionally, as trees grow, they will compromise neighbouring properties. If a significant natural area ruling is placed on 6 Jeffrey Place, the owners will be incapable of having reasonable use for maintenance of the property without gaining council consent. Additionally, if we were to sell 6 Jeffrey Place, we would also wish to, sell 8 Jeffrey Place with the house on it, we would also wish to sell 6 Jeffrey Place, which, if this is a significant natural area, would be nearly impossible. I mean, who would want to buy it? While it is noted that the landowners wish to use the land in a way that maximises its value or economic potential, does not make that use alone reasonable and others unreasonable, and that reasonable use is not synonymous with optimal financial return, being unable to sell 6 Jeffrey Place as a separate title property, if designated a significant natural area, is, in my view, unreasonable. In terms of being an unfair and unreasonable burden, with the expression burden suggests that some imposition on a landowner is acceptable, the question of whether a provision places an unfair or unreasonable burden on a person is a question of fact and degree. Financial costs are one factor leading to unfairness and unreasonableness. The 900 square metres of 6 Jeffrey Place is currently paying rates on a value of $510,000. While the owner would agree it is not worth that amount, and I certainly don't believe that would be what I would be able to sell it for, even if it wasn't a significant natural area, that is the amount used by council for determining the rates due on the property, for which, as an aside, the owners actually gain no benefit. There is no rubbish collection or sewage disposal, no provision of amenities such as water or power, etc. If 6 Jeffrey Place is designated a significant natural area, then its value will decrease significantly because any purchaser will be seriously constrained by the significant natural area ruling and able to take any development at all. The result will be likely an inability to sell 6 Jeffrey Place. So, in conclusion, I propose that designating 6 Jeffrey Place a significant natural area will both render the land incapable of reasonable use and place an unfair and unreasonable burden on any person having an interest in that land. We propose that the significant natural area rating for 6 Jeffrey Place be abandoned. This is on the basis that the vegetation is not automatically self-sustaining. We have to maintain and water that section. It doesn't sustain itself. It's of negligible environmental value, but has the potential to have significant impact on the owners. I'm happy to take any questions if there are any.
Thank you, Mr. Karadas. That's clear. Thank you. Just see if there are any questions. Ewan, do you have any?
No.
No. I mean, that's the just benefit of being clear is that you don't have any questions. So, thank you very much for your time today. The submission is very clear. The photographs are very helpful, and we'll pick through that issue. And you'll obviously hear in due course.
Thank you very much.
Okay. Thank you. Right. We'll go back to Miss Burton and her entourage.
So, Commissioner, did you have a question about?
Well, it was less of a question that I hadn't actually focused on that particular policy up to that point, and it just occurs to me in looking at that that's actually a relatively significant policy direction with respect to the criteria.
Absolutely, and to the rules.
And I guess just inviting you to add any extra observation that you might have on that.
Only to stress that when you're looking at the suite of rules, once the SNAs have been identified, in order to protect them, then the suite of rules need to address the effect on the significance of the vegetational habitat. So that's what the point of them is to make sure that there's not a reduction on that significance. And in my submission it underlines again that it has to be significant in the first place.
Okay. All right, thank you. Mr. Fletcher, are you really going to read to us?
I'll try my best and summarise as I go. Anyway, so this is Ms. Burton's statement. As it says in the introduction, she's lived at 736A River Road for over 20 years, and she's a landscape designer and consultant with 40 years of private and commercial landscaping experience. When she moved into River Road over 20 years ago, the property had been a rental and the gully at the back had been completely neglected. It was growing noxious weeds which gave her animals rashes. Since she moved in, she's taken great care of the garden at the back of the property and has been a responsible landowner. The garden is something she is extremely proud of and that is personal to her and her family. In the last 5 years, she has had more time and resources to carry out significant landscape works and upgrade the gully and garden as a whole. This has involved the planting of a mix of exotic, native and subtropic species in the gully and the installation of other garden and landscape features which are personal to her. This has included pillars and plants of all descriptions that have come from her daughter's section in Auckland. When she moved into the home, the gully was covered in ivy planted by the original owners. She has cleared all of this and mass planted the Clivia species. New Clivia plant colours not yet released in New Zealand are also in order. The garden is unrecognisable to what it looked like when she first moved into the property. She has developed a stairway using schist, with her neighbours put in retained railway sleeper steps, pathways, bridges, art, pots and seats. She enjoys upgrading her garden for her grandchildren and other children in the neighbourhood to play in. And she has also included some photographs in her statement. So we have got the fire pit, some installed planters, pathways, and the entertainment area. Ms. Burton's long-term vision is to make the garden into a sculptural walk. There is also an entertainment area with a fire pit that her family and neighbours benefit from. She'd be devastated to be required to get a resource consent to upgrade the garden or keep it in its maintained state. She's recently planted mondo grass species as a substitute to a grass lawn on the other side of the bridge where it is difficult to get the lawnmower to. Lawn and turf contractors carried heavy machinery down the steps to sow the farm many years ago. She also employs arborists to climb and maintain the trees for the more labour-intensive sections of the garden. This is also to ensure she has privacy over her deck, to which the proposed SNA overhangs. Stormwater has historically flooded her garden. Hamilton City Council agreed to install an overland flow path to remedy the flooding in April 2022. Hamilton City Council's master data set identifies that the proposed SNA meets criteria 1, 4, 3, 8 and 11 of the WRPS. Ms. Burton has not been provided with evidence as to why the part of the proposed SNA meets these criteria. She disputes that the proposed SNA meets the remaining criteria, and she's not been made aware of that her garden is a habitat for Indigenous species or has Indigenous vegetation. Foresight Consulting's PC9 Technical Ecology Report dated March 2023 states that part of the proposed SNA over her property has some open grass areas, but overall is consistent with the ecological value of the proposed SNA. Ms. Burton does not see how her garden contributes to the ecological significance of the rest of the Donny Park. In relation to the open grass areas, these have all been planted by Ms. Burton. Each year they are upgraded with lawn fertiliser, weed spray and seed as necessary. Donny Park is not accessible from her property and she disputes that there is any connectivity to link these areas together. There is no public access to her part of the gully and it does not open up to any roads. Removing the proposed SNA will not take away from the rest of the gully. Ms Burton has carried out mass planting of species beneath the drip line of the mature trees and throughout her garden. Foresight Consulting's ecologist Charlotte Yates did an independent assessment of the section on 16th February 2023 and advised Ms Burton that the peninsula over her property lacks connectivity to the rest of Donny Park significant natural area to justify it being included in the proposed SNA. Ms Burton protects the flora and fauna passionately in her section and has no knowledge of bats on her property. Bird life is avid in her garden to her delight. Ms Yates requested a list of the plants in Ms Burton's garden as it included so many exotic species. As discussed with Ms Yates, this proves that her gully is a cultivated garden. Ms Burton does not consider that the planting is consistent with the requirements of Indigenous vegetation considered to be present in the proposed SNA. As she has set out, the development she has carried out in the garden has included substantial planting of exotic and subtropical species that she has selected. Because of this, the garden looks substantially different to when she first moved into the River Road property. Ms Burton also submits that there is no wetland or wetland habitat in the SNA over her property. Ms Burton considers that having the part of the gully over her property listed as an SNA will result in unfair restrictions on her rights as a private landowner. She bought her private residence to design and develop as she desires. She has responsibly maintained her garden to keep it in the state it is today. Because of the proposed listing, she'll be required to get a resource consent for works that she has already planned to continue to upgrade her garden. She will not be able to continue the planting of a range of exotic species that she has pre-ordered. The cost of a resource consent is an unfair burden. Ms Burton is disappointed that she has not been provided with an assessment of how her property meets the regional policy statement criteria. She expected that Hamilton City Council would carry out these assessments in a transparent nature and be willing to share information with landowners. She requests that the panel reject the recommendation made in the Foresight report and amend the proposed map of the proposed SNA so it no longer encroaches onto her property. And she's happy to take any questions if you have
questions. Ms Burton?
Hi.
See you. Have we got any questions? Ewan?
No, no questions.
Oh, thank you.
Yes.
Is there anything extra you want to say?
I'm really grateful that you've accepted my entourage to talk on my behalf because it is quite intimidating, this process, and it's quite difficult for landowners to know how to actually object to the council who did such great work and who have great admiration for my garden and who I work willingly beside. But this is my private oasis that I've developed over 20 years, and it's my passion, it's my career. I've designed it to be what I want, which is not A, a public space, or B, meet any of the criteria that have recently been discussed. The overflow path of water actually dries up in summer. It is simply when the stormwater overflows from Donny Ave that it becomes a wetland. And I protect the flora and the fauna in my section. I use good nature control to do that. I showed Charlotte that, and a really interesting statement was I asked her if other landowners were objecting, and she said that there were some, and if this went ahead, would I cut down my trees? I value my trees, like my trees are my life, like my animals. My garden is my home and my personal oasis, and I'm very grateful that you will look at it as a one-off blind peninsula with exotic
exotic plants and exclude it from this ECNA burden that would be placed on them.
Well, thank you. Thank you for coming. Thank you for your and yes, well, we'll take this forward. Thank you.
Thank you so much. Mr. Green?
Mr. Green.
Feel a little bit inadequate after hearing all the other speakers to come in here, but I've really come in because we're Lee's next door neighbours, that we're very supportive of what she's doing in the gully. We invested about $10,000 in steps that would allow us to go down to the gully, and it's become a haven for our 8 grandkids who, through the generosity of Lee, go down and play and work in the gully, and we'd hate to see it taken away from her. From our point of view, that since we've been there, that the neighbourhood is so supportive, and we'd go down in the gully once a month with a bag to pick up rubbish, and 3 or 4 other neighbours would be down there doing the same thing. To show you how good our neighbourhood is, just before Christmas, the council drain in River Road flooded. It poured down the neighbour's driveway and ran through our house, and we had 6 neighbours arrive at our place to sweep it out and make sure the house didn't flood too much. And I said, if that's what the council does with River Road, what if they take over our gully? What's going to happen? So please don't take it over. Thank you.
Thank you, Mr. Green. Thank you for coming. Yeah.
Mr. Green, I was just wondering, what number property are you? You said you're the neighbour of Ms.
736.
736. Thank you.
Sorry, you share the driveway, don't you? Is that the one?
Yeah. But that's not, the water didn't come down that driveway.
All right. Where are we up to? Do you want to take a break now? Yeah, I think we'll take a break now. 15 minutes, back at 3:15, and then I think Sharp Planning, I think Kevin Sharp, I think, is on then. So 3:15, thank you. Resume. Thank you very much. And the next submitter is Kevin Sharp from Sharp Planning. And in the interest of time, Mr. Sharp, I note that at the end of Council's presentation to us earlier, that Mr. Dean recommends that the boundary be adjusted to follow the property boundary so the gardens along the edge of the SNA are excluded. I take it you're comfortable with that proposition?
Well, no, I've got broader concerns about the SNA in principle.
Yeah, but you're comfortable with that proposition?
Yes, I am.
Righto, so you don't need to cover that issue off.
No,
That's
I don't.
really what
No,
I'm
I'm going to more or less summarise my... I'll still read a component of it, but I will summarise it.
We have read your evidence?
Yes, thank you. And just to note that I'm presenting as a property owner and not as an expert witness, even though it's got my business name.
I had assumed that was the case, yes, that's right.
Thank you.
Yep.
We've been the property owners since 2007, 2008. When we purchased the property, the bush was quite low compared to what it is now. It's more or less doubled in height in that time. Our main concern is around the right to establish as a permitted activity the ability to have trees reduced in height so that they do not strike our property in a storm. That's our main concern. And our dwelling, sorry. I'm not too concerned if they strike a car on our property or fall across our property. The trees are there. We knew they were there when we purchased. It is a protected reserve, and we do enjoy the principle of having trees beside our house. We are concerned about the cost of the reserve maintenance being transferred across to private landowners, which is, I think, in breach of the onus of the principle that the reserve should be managed. We had a pest species removed just 2 or 3 years ago that was between 15 and 20 metres high. And I am concerned that if those trees grow much larger, and we had a storm, this is prior to Cyclone Gabriel, that took out quite a few trees in that reserve. And it just sort of gave rise to the concern, which we didn't have really prior to that our house could get struck if a large tree fell on it. And as I pointed out before, if it falls across our property and lands on our cars, if they're parked outside, well, that's just tough. We live beside trees. But our house is our house. It's our own significant habitat where we have to live. So that's the main thrust of our submission. The area that's defined in the Foresight Consulting Report going back to June 2022, and the area of the Bremworth Park that I'm challenging is the area above the stormwater drain near the club rooms. There's a playground that's just been rebuilt down there, and I'm not speaking about the area below that drain. That area below the drain has some kahikatea in there, and that is more natural, but the area above the drain, it appears to have been established in the late 70s with planting, and I can remember as a young man I used to stay in the area, and I can remember that area growing, and it's certainly grown much larger in extent than what it was when we purchased the property. And that's one of my key aspects there. So I'm just challenging that when the Foresight Consulting Report went through, it was a broad brush report, and I respect it wasn't a detailed assessment as such, but that's sort of been taken as a basis of some of the Plan Change 9 information, and I have concerns that something that doesn't get ground truth in the fact that it didn't even address the origin of that bush, which has become a significant amenity for the Bremworth area, but it's not naturally occurring. It's not restorative planting. It was planted originally as an erosion risk mitigation factor on that hill, and it has grown, and it contains a mix of natives, exotics, and unfortunately a lot of weeds. And one of my concerns is that under the Resource Management Act, the Foresight Consulting Report picked and chose part of the RMA to aim in its favour. And I don't want to be negative about a competing planning firm. I've not got any interest in undermining other people's business integrity. I just need to be just careful to make that statement. But I am concerned that where the RMA sets out an integrated purpose for the achievement of sustainable management, you cannot pick one clause over another in the way that they have. I'll just go through and just find that in my submission. page 7 of the electronic file in the Appendix 12 report. And when I went through and read that, they picked out just one of the parts of Part 2, Section 5 of the Act. And I believe that the matters of national importance have to be read as an integrated whole. And it also includes an onus, which I believe is lacking at the moment, because we pay rates towards this, is the management of that bush reserve. And Clause H of that matters of national importance includes the management of significant risks from natural hazards. And I would conclude that a natural hazard is a tree that falls across a dwelling if there's a risk of that occurring. Now, I think I've said the guts of my report, but the main thing is that my concern is that for private landowners who adjoin some of these bush areas, and those houses in the Bremworth area, most of those were there before that bush was planted. And the photos that I've proven from Metrolens have shown that that area was not naturally occurring as of its own right. It has been planted. So we're not challenging the SNA, but we are saying, just to mention Joan Forrett's words, that I think there needs to be more investigation as to the integrity of the SNA and the meaning of the word natural. And I do consider that the intent of the SNA legislation has been overstretched to suit a purpose which is undermining the integrity of the SNA Act and regulations under the Act. And I think coming back to the RMA again is that we have a right to our health and safety, and that should include the ability to request council to cut trees back to a height which will not strike our dwelling for our own health and safety if there is a potential risk of that. And we shouldn't have to go through a process that costs thousands and thousands of dollars to get ecology reports, and then council gets another ecology report, gets it peer reviewed, and we have to pay for a resource consent on top of that. Most people can't afford it. And we pay rates now, and that bush reserve is not getting managed. There's no plans in the SNA proposal to manage that reserve. That's one of my key concerns, and that undermines the integrity of the process. And that's it. I think that will cover what I need to say.
I appreciate that, Mr. Sharp. Thank you very much. So I mean, what evidence is there that those particular trees, as you say, above the drain, are at risk of falling over or dropping limbs? Or
we had a storm go through about 18 months ago, and we had 7 or 8 trees down in the park, and most of those came out of that bush reserve. So.
Right.
Admittedly, it's not frequent. I haven't observed previously, to be fair and open, that there hasn't been trees coming down with every single storm. There's only, I think, one came down on Cyclone Gabriel, or part of one tree. But when they grow, I think 20 years down the track, and those trees could be double the height, getting close to 40 metres in height, there becomes a significant risk of canopy cover over our house, restricting sunlight. But I'm more concerned not so much about that as the fact that if a tree did fall and we're in the house, it presents quite a risk, and the inconvenience of it as well. So.
Yeah, no, I certainly understand that concern. Yeah.
So just the information supporting the SNA, it's a corridor SNA, is it?
I believe so, yes.
It's a C, it said C, didn't it?
Yes.
C SNA,
yeah.
Okay. And yet it's an island, it's not connected to any other corridor.
Not really, no, but it is connected down. There's a peat pond down past the Bremworth Park goes down from Mandurah Avenue and it drops downhill, and then it sort of reaches the edge of a terrace where the playground is, and then it drops down into another area down below, and that area is quite wet in winter, and there's a peat pond down there. Yeah. Now that peat pond, as far as I can remember from when I often used to come to Hamilton in the 1980s as a young man, I was a racing cyclist at the time, well not now, but and I stayed in Poaka Avenue, so I used to ride up Mandurah Avenue for training, so I remember the area quite well, and that's appealed to me, so I bought there eventually as I got older. And the trees down the bottom have been there, as far as I can recall, all the time. And I believe the trees below the stream are actually naturally occurring. They're kahikatea in some cases. Above the stream, not so much. They were definitely planted. So.
All right. Anything?
Yeah. And I just want to point out too, just one clear point, is that those trees are not in our view shaft. This is not a view shaft default claim, so.
Yeah.
Okay.
That's fine, and there's no implication of that, or no one's taking any issue with that as far as I know. So, no, take it on its face, and thank you for that.
Thank you.
Thank you, Mr. Sharp. Ms. Muggeridge.
Kia ora koutou katoa, I'm Charlotte Muggeridge. Thank you. I'm also part of Harkness Henry team, if you didn't know that already, but it appears my team has left me.
Yep.
So it's just me here today, and this is not legal submissions today. This is a statement on behalf of a client, and what I propose to do is, I understand that was circulated last night, so I will just summarise and go through, and then happy to take questions and answer them as best I can for the client.
Thank you. Yep. No.
So this is on behalf of Mark and Sarah Harris, and they have a property at 27 Keswick Cres, which you can see up here on the map there. From the site visit, the area has been reduced, so that green dotted area does show where it was, and it has been slightly reduced. However, the clients don't see this as being acceptable, and they request that that boundary is reduced right down to either being removed entirely from the property, or they will accept about 5 metres from the property boundary at the bottom. So through their statement, they talk about their garden, and I think this is useful information to know, because this was a part of the Huntington subdivision. So this property is a part of about 80 lots that were created in the 90s. And when that took place, from our client's understanding, that gully was actually pretty much all ripped out, all the existing vegetation, and it was replaced with fill. And that was via a Hamilton City Council consent. And when the clients purchased that property 25 years ago, it actually had been completely overtaken with gorse. And what that's triggered then is our clients to undertake their own planting, and that's what we see up here. So I imagine a lot of the owners actually along there have completed their own planting, but our clients in particular have completed that on their own property. The reason why they planted their garden, and this is their words, is for the enjoyment, peace, privacy and solitude that they have from that garden. In the planting on their garden, they have planted one native, and that is Aspiroporium, and that, as they understand, is not significant to the gully or the property or Hamilton in general. It is a common native. Taking you to point 8 now on Hamilton City Council's Section 42A report recommendation. As I said, it has been reduced, and that was due to the retaining wall, the gardens and the fruit trees that are in there. But they do still seek that it's removed in their entirety, and I would stress that a lot, considering the work that they have put in themselves. And they outline their reasons for this throughout their statement. So starting with private property rights, the Parrises believe that it is unreasonable that private owners are impacted by the SNA listings over large parts of their backyard and gardens. It takes away the ability for private landowners to do as they please with their backyards and gardens to which they purchase and pay rates on. They do not want the public or HCC contractors to confuse this property as public property and enter without their consent. And they do not believe it's reasonable to obtain a consent for further works in their own backyard because of this proposed listing. So the regional policy statement criteria, and there has been a little bit discussed on that today, and these clients have helpfully gone through and assessed the criteria to their own garden. As you'll see further in this statement, clients are not aware of any assessment being done or available to individual properties. And of course that has caused a lack of information for this landowner to be able to do a thoroughly detailed report, but they have done their best in providing an assessment for the panel to understand what is in their backyard. So I would seek that you read that in detail, and what I'll do is just summarise quickly. You will see that there is a lot of criterion to this property. It is a large gully system, 28 hectares, but in relation to this small S&A fraction that's been highlighted on their property, this is what they have to say about that criteria. The property is not a part of the Mangaiti Park Reserve. The parishes are not aware of any uncommon plant, insect, mammal or fish species present on the property, nor any threatened or at-risk species. There is no wetland vegetation on the property. Removing the S&A on their property will not affect the size of the overall 28 hectare area. This S&A area over this property is not vital to fauna. The property has a housing block from the Kirikiriora stream, a man-made buffer. It is 3 kilometres from the Waikato River. While a healthy gully is important, reducing the S&A from a planted garden will not affect the gully. Moving through to point 35, the process used by Hamilton City Council. Reference has been made in this statement to when the parish's lawyers, Harkness Henry, asked for a copy of the assessment report that had been done on their property, and as a result of this they were directed to general assessments that had been completed. And they've stated here that they understand that there is no individual report on their property from that assessment, so no assessment of the details of the criteria have been applied to this property. They are concerned that Hamilton City Council has not been transparent with their private landowners throughout this process and has overstated the significance of the area. Other matters. Mangaiti Gully Restoration Plan, and this is, I understand, private citizens working with various groups and councils maintaining the area. This has created 3 zones, and you can't see them on the map here, but there are 3 main zones that are identified, and they are protected, maintained, restoration works are done. This property has not been included, and that is deliberate, and even though other private properties within this plan have been included. So just making that point clear that this property has not been included in that. And one other point to raise, and this isn't in the written submissions, but I have discussed with the client, is the property is already subject to the Waikato Riverbank and Gully Hazard Zone area under the Hamilton City Council District Plan. And under that zone, it is permitted to remove vegetation and maintain vegetation. However, new builds are discretionary. So Hamilton City Council already has a protection mechanism in place for this area, and that boundary, I understand, is almost in line with the S&A. So there is some comfort there to know that if this S&A is removed, it's not just as simple as being able to build another built structure on that property. It's still subject to another zone. So that's something to also, for the panel to also consider. So in conclusion, the parishes have stated that the impact of the proposed S&A over their property means that they will have to bear the cost of the resource consent should they wish to carry out any maintenance work on their property. Their garden requires significant ongoing maintenance, and this is impacted by neighbouring properties and Hamilton City Council land below. We are concerned that without regular maintenance, pest species will encroach onto their property from the neighbouring properties. They object to the proposed S&A over their property. It covers a large and unreasonable proportion of their property, which is, as far as they're concerned, as an ordinary privately owned suburban property. The proposed S&A does not meet the Waikato Regional Policy Statement criteria and has only 1 native species, and that is common. They still have not received any assessment to which states how this criterion applies to their property. We ask that the extent of the proposed S&A on the property is adjusted or reduced further to within 0 to 5 metres of the property boundary in the gully. And that is their statement, so happy to take any questions from the panel.
Thank you very much. Sorry.
I just have one question, and it's just in relation to that last point. the extent is adjusted or reduced to 0 to 5 metres of the property boundary. What's the rationale for the 5 metres? Is it kind of just because of the slope? Is it because of the type of vegetation there, or is it just kind of trying to minimise? I'm interested in the rationale.
Thanks, Commissioner. I think the clients are reasonable people, and I think they just see this as a reasonable place to meet. Ultimately, they want it completely removed. But I think that speaks to their that they still recognise that if Hamilton City Council considers that there is a significant area, then that may be the case. But I guess ultimately I would stress they would like it entirely removed.
So as far as you're aware, there's no differentiation between the slope on the 5 metres versus the 10 metres, or that's just a proposal they've come up with?
No, that's right.
Thank you.
You want anything? Thank you very much. Right. Stephen Gale here.
Yes, sir.
Mr. Gale, you've been sitting here patiently for quite a while. Have you got any paper to give us, or are you just going to talk to us?
Right, so I guess like a lot of the previous submitters, I would like to see the boundary drawn back to the property boundary. In terms of the site, there's no granularity on assessment of the sites. So it's called the Waikato River Woodridge Flagstaff SMA, which includes Featherston Park, Monroe's Walkway, Sylvester, Bernard. All I've found is patches of wetland vegetation and other vegetation provide habitat for some at-risk indigenous species, and parts of the site may include underrepresented vegetation types. It provides a buffering function to the Waikato River. So in terms of that, we're talking about a piece of land right along the northern boundary of Hamilton, from the Brigetti Bridge basically up to the golf course. And that's it. I can't find anything that says, okay, why does your SNA actually meet the SNA, why does it meet the SNA criteria? Yeah. So to talk about the land for a little while, the land originally was farmed and subdivided sometimes in the 80s, 90s. So there wasn't a lot of vegetation on that land. What there was, though, was some plantations that were done by the farmer prior to subdivision. So on our section and adjacent in Featherston Park, there is an area of woodland, and that woodland is exotic species, pin oak, swamp cypress, that sort of thing. When I look at the SNA and how it's been delineated, it appears to follow a tree line. So you can see it follows the riverbank. Where there's no vegetation on the riverbank, it's not there. Where there's a tree existing, it surrounds the tree, and so it's surrounded the trees on my section. It's pretty arbitrary, really. Criteria. So apparently I meet criteria 1, 3, 6 and 11. Criteria 1, it is indigenous vegetation or habitat for indigenous fauna. Those currently is recommended to be set aside by statute or covenant by Natural Heritage Fund, etc., etc. You guys will be familiar with the word in there. I don't think I meet that criteria. 3, it is vegetation or habitat that is currently habitat for indigenous species or associations of indigenous species that are classed as threatened or at risk, endemic to the Waikato region, or at the limit of their natural range. I would like to ask what evidence exists on that, because I'm not aware of any indigenous species that are using my section as a feeding ground, or certainly there is things like fantails and grey warblers and that sort of thing, but they're fairly common. Section 6, criteria 6, is the wetland habitat for indigenous plant communities and or indigenous fauna. Now, yes, there is a seep goes through there. That land at the basis of the River Road, I guess, embankment down to the river, is prone to seeps and springs, and a lot of them have been drained and brought together. So we have got a little bit of a seep there, I will say that. 25 millimetre deep, 50 millimetre deep maybe, most of the year. Is that a substantial habitat? Maybe 10 or 15 metres long on my section. I think they pushed me the boundaries there. 11. It is an area of indigenous vegetation or habitat for indigenous species, which is either naturally occurring or has been established as a mitigation measure that forms, either on its own or in combination with other areas, an ecological buffer, linkage or corridor, and which is necessary to protect any site identified as significant. I contend that this is not naturally occurring. I don't know what corridor we might be constituting. It seems to link Dresden Park with subdivisions. So I don't think I could meet that criteria either. In terms of this question now, what does it mean if my property is identified as having an SNA? There are various examples. Pruning, maintenance or removal of indigenous vegetation in an SNA for purposes of restoration. Well, I will say that underneath the canopy of the exotic vegetation, I've planted a native garden. I don't consider it natural though. Would that say that I can't carry on developing and pruning the indigenous garden that I have? Pruning, maintenance or removal of indigenous vegetation or trees associated with construction of a new infrastructure and public walkways and cycleways. Once again, the emphasis on indigenous vegetation. Pruning, maintenance or removal of indigenous vegetation or trees associated with operation, maintenance, renewal or upgrading of existing infrastructure and public walkways. Yeah. Planting of pest species or planting of exotic vegetation in an SNA not provided requires a consent. If anything, I'd be removing pest species. Earthworks not expressly permitted. I guess if I chose to develop that section and it was deemed an SNA, then that would be a barrier for me. The question is, should it be an SNA?
Well, you're very clear that it shouldn't.
I am very clear that it shouldn't. The last consent requirement, I think, there's two more. Additions to the replacement of an engine. I guess what I'm saying with this list is all these criteria don't apply to that section. These criteria are there to preserve an SNA's nature, I suppose, and none of them apply. I could cut down those native trees and not transgress against any of these requirements.
All right, that's second.
Yeah, I mean, I guess you can look at all those things two ways, can't you?
I'm sorry.
Yeah, I guess you can look at all those things two ways, and it comes back to whether on that property the values exist to warrant it, and you're saying they don't. So we hear that.
Yeah, I'm saying it is not a natural situation. We're adjacent to the Waikato River. Clearly, that is a natural feature. But then there's park, and then there's us with exotic vegetation on.
Thank you for your attending today. Mr. Gale, thank you. I won't say last but not least, yes, Ms. Hooper and Co. Yes.
Excuse me, Commissioner, have you got me down?
I've got you down, yeah.
What we did not see today?
We haven't finished yet. Why are you asking?
Because you just said that last time.
Ah, sorry. Your name was mistakenly added onto them, but I didn't think that was appropriate. Don't worry. Yeah. Right, welcome, Ms. Hooper.
Tēnā koutou katoa. Ko Michelle Hooper, toko ingoa. He kaumahi, aho mau te papa ati whai. Tēnā koutou, tēnā koutou, tēnā koutou katoa.
Now, we've obviously had all the material over the last few days and rebuttal and so on and so forth, so we can take much of it as read, but in your hands.
Thank you. I was going to ask if I could take it as read.
Yep.
So listening this morning and this afternoon, there's been quite a few points that have come out that I'd like to talk to on key points to clarify. Because I think in some cases the position has been a little bit mischaracterised, so I just want to clarify some key points. So I think the first point that I'd like to talk to is the identification and protection of SNAs. So the Director General's seeking policies in the plan that areas of significance include both mapped areas and unmapped areas. When I listened this morning, it was characterised as though we were seeking out of scope scheduling. That's not the case, and to actually fully map may not even be possible. The mapping exercise and the Section 32 report recognises that not everything's mapped, scientific information is not complete. So I just want to be clear that that's not what we're asking. And when I heard that this morning, I thought, wow, that sounds outrageous that that's been asked, but like, hang on, that's not what we're asking. So I just wanted to make that very, very clear. What I think, Commissioner Morrison, sure, I think your question about the lacuna, I think you've hit the point of what I was trying to get to. So the evidence, I've referred to a quote out of Mr. Inder's evidence, and I don't propose to read that out because you've read that already. But the point there, and it was a point, I think Commissioner Sargent, you also made that in the Amberfield hearing, which is that if it's not mapped, it doesn't get protection. And that gets argued in the sense that the objectives and policies only apply to the mapped areas. And that was one of the key reasons the Director General appealed the Amberfield decision, is that that's actually wrong in law, and the Environment Court agreed with us. So I've referred to the Cabra decision there, but Amberfield is also, the Western Lee decision also covers the same point. So essentially what the Environment Court says on the point is that if areas of significance gain no protection because they have not been mapped, this would not only be contrary to the decisions of the High Court in relation to these issues, but also to the clear obligations under Policy 11 and Part 2 of the Act. Now, Policy 11 is not relevant here because that's Policy 11 of the Coastal NZCPS, but Part 2 of the Act is relevant, and that's Section 6C. And my friend, Mr. Maldani, I thank him for the submissions on the importance of Section 6C. So that direction from the court is very clear. And essentially what we're looking for is not out of scope changes. We're looking for fine tuning and tweaking to really capture and reflect what the law requires. So Section 6C of the RMA requires decision makers to recognise and provide for the protection of areas of significant Indigenous vegetation and significant habitats of Indigenous fauna. The Director-General submits that Section 6C will apply if the area meets the significance criteria in the Waikato Regional Policy Statement. And when we talk about meeting the criteria, the policy that you mentioned just before, Commissioner Hill, Eco P2, I think that's very relevant in that working through. And the key point is that it's not losing the extent of the significance. That additional wording that you referred to. So I fully agree that that's quite important and that's part of the puzzle. So Section 6C has been present in the RMA since first enactment, and it applies absolutely. It does not have an activity qualifier like Section 6A. And moving to the question about is there a definition of significant natural area? Where I've seen definitions, it really reflects back to the wording in Section 6C. So first principles is Section 6C, the wording there is significant Indigenous vegetation and significant habitats of Indigenous fauna. And the ecological evidence is clear. Indigenous fauna they're not picky. They don't just go for the Indigenous trees, they also go for the exotic trees, and that's how something that doesn't, on the face of it, appear to be significant, it is significant to the Indigenous fauna. So it's that link in, and I think you've had clear messaging on that. The RPS does have a definition. Significant Indigenous vegetation and significant habitat of Indigenous fauna is any area that meets one or more of the criteria in APP5. So, and in terms of, I had a quick look to see if there's any statutory definitions, and while the plantation forestry is not relevant to this hearing because we're talking about forestry, the environmental regulations there do have a definition. And it's the Resource Management National Environmental Standards for Plantation Forestry Regulations 2017. And I just refer to this purely because of the structure of the way that this definition sets out. So that defines significant natural area means an area of significant Indigenous vegetation or significant habitat of Indigenous fauna that is identified in a regional policy statement or a regional plan or district plan as significant, however described, and is identified in the policy statement or plan, including by map, a schedule, or a description, or by using the significance criteria. So I think that general theme carries through. So moving to the next point. We also have the objective I in Te Ture Waimoana o Te Awa o Waikato, which is the vision and strategy, and that protection and enhancement of significant sites, fisheries, flora and fauna. So that includes fauna, the vision and strategy, and that has a status, as you're aware, of a national policy statement, but even better than that in that it trumps other national directions. So that's got quite high significance, and quite important and quite pertinent to this plan change is objective 22.1 in the district plan, which is part of this review, which requires significant natural areas are protected, maintained, restored and enhanced. So that's the objective that these policies relate to, and the objectives, that's part of the framework there. So at paragraph 12, I explained that Ms Sycamore has set out 2 proposed policies and evidence in chief that would address the Director General's concerns and be the most appropriate, efficient and effective way to implement the objectives identified above. Actually, after above, I just want to put a full stop there and delete the next 4 lines. That was, and on the basis that that is the point that Ms Sycamore will talk to you about.
Sorry, what paragraph are you at?
Paragraph 12. So that is the point where I stop the legal and the planning comes in to explain the relief. What I do want to point out as a legal point is that in the section 32A, appendix 12, which was appendix 12 to the section 32A report, at paragraph 9.1, it specifically notes that planning mechanisms need to acknowledge and account for incomplete scientific information. So the Director General submits that there is scope for these policies. The section 32A report contemplates it, the law requires it, and the policy wording as proposed by Ms Sycamore would just close that lacuna. So the SNA mapping exercise increases certainty as to the location of SNAs. However, it is highly likely that the mapping exercise has missed areas. The unmapped areas of significance identified through a resource consenting process should still be afforded the protection in section 6C and the relevant planning objectives. It would be contrary to section 6C and the planning objectives if areas of significance gain no protection because they have not been mapped. The proposition that an area that meets significance criteria in the RPS will not be protected until such time as it has been identified and added to the plan through the first schedule process is incorrect as a matter of law and planning practice. And as I noted before, if something is identified through a consenting process as being significant, then the relevant objectives and policies would kick in, and that would include ECOP2. So move now to the next point, the landscape-wide approach. So we're often, well, I've heard the ecologists say many times a landscape-wide approach is needed. And it's kind of turned into that game, I don't know if you remember it, and I won't, the name's not appropriate, but you sit in a circle, you say a word, landscape-wide approach, and then by the time it gets to the end, and what you're getting is city-wide approach. And I think what we're saying and what's getting to you are 2 different things. So I've got a quote there from the Western Lee decision, which is essentially pointing out the issue here, which is the threatened nationally critical status. It's the rate of decline, and that there needs to be a unified catchment approach. So my point there is that when we're saying a landscape-wide approach, we're talking about the landscape-wide approach of the areas where the bats are using, not necessarily a city-wide approach which captures areas where the bats are not using. So paragraph 16, pika pika are present in Hamilton City. They're threatened, nationally critical, which is the highest threat one step away from extinction, and that's due to the rate of decline. And they're highly philopatric. They're loyal to specific locations. Not a specific tree, but specific locations. You can't take away all their trees in one area and then expect them to just move. And as Dr. Borkin has explained in her evidence, and I think Dr. Mueller has as well, the pika pika population are mainly located in the southern part of the city and the adjoining peri-urban area. The Waikato River, southern Hamilton Gully systems and the Peacock Structure Plan areas are considered particularly important because they contain roosts and connections between roosts and places that bats feed. And BAT surveys have confirmed that there is less activity within the parts of the Hamilton that are highly urbanised. Therefore, a unified catchment landscape-wide approach should focus on protecting and enhancing the home range of the pika pika, being the area that they relatively regularly use. So the key point here is PC9 presents a critical stage in the spatial planning that is urgently required to be undertaken by not only Hamilton City Council, but it's Hamilton City Council, Waipa District Council and Waikato District Council, to ensure that the local population of pika pika that are currently present in the area persist and do not become extinct. Now, fully recognise that this plan change hearing only deals with Hamilton City Council, but just making the point that this is part of a bigger picture and it's a critical stage. The pika pika are here and they're still here. And it's easier to protect something that is still here and keep it here than to lose it and to try and bring it back. And I think when you're dealing with a threatened nationally critical species, once it's lost, can't bring it back. So moved out now to setbacks. And I think the next three topics, setbacks, lighting and glare and noise, are almost linked. So I'll cover those a little bit jointly. So a point that I think is coming out in some of the themes and the discussions today is that not all SNAs are equal. So I just want to clarify that we're not seeking equal controls throughout. So if there's no bats present, we're not seeking noise, lighting or for bats. What we're seeking is what is appropriate for the particular species, threatened species, at-risk species, or fauna. So there does need to be a little bit of nuance applied, and the Director General seeks that, in that we're not seeking controls that are not needed. So earlier on, I think when Mr. McKenzie presented, there was reference to my paragraph 21 and 22, where I've referred to a paragraph in his evidence. And I think that the key point there is that where there's existing buildings, where it's highly urbanised, bad activity has reduced. So I think proceeding on the presumption that because they're there at a reduced rate means that that's okay to roll out is an incorrect presumption. The bad ecology evidence suggests that if the peri-urban area is developed on the basis of present building setbacks and light spill, then there will be a significant reduction in bat activity. So the existing built areas that are most frequently used by pika pika are either close to, accessible to, or adjoining wide open, and I'd like to insert the word green spaces. The wide open green spaces are an important factor for the continued presence of pika pika in Hamilton City. And as noted by Dr. Borkin in her evidence, pika pika like quieter and darker areas, particularly gullies, parks, farms, lifestyle blocks, and open green spaces. So I think there's a consensus amongst the bat ecologists where they agree that less light and noise is better. They also agree that wider setbacks and or buffer planting is a suitable tool to achieve the objective of reducing lighting impacts on pika pika. Which takes us back to that objective 20.2.1. So just remind that, bearing in mind, we're always heading back to the objective, the goal, which is that significant natural areas are protected, maintained, restored and enhanced. So on the topic of lighting and glare, protection is not defined in the RMA, but it has been interpreted as meaning keep safe from injury, keep safe from harm, injury or damage. So the case that I've quoted there at footnote 21, the Forest and Bird and New Plymouth District Council, that case, Forest and Bird was successful in obtaining a declaration to the effect that council actually has a duty with respect to the significant natural areas. I think a question was also asked about whether other councils are taking a similar approach, and my take around the country is that yes, that is becoming a more common approach in that protection. I think the key point on lighting and glare is that the ecological evidence identifies that roosts can become unsuitable when exposed to light. So the Director General submits that the protective action required by Section 6C of the RMA and Objective 20.2.1 in the district plan requires a proactive approach to the threat of lighting and glare effects on bat habitat. And I think that rolls back quite clearly with ECOP2, which is that the significant indigenous vegetation and significant habitats of indigenous fauna shall be protected by ensuring the characteristics that contribute to the significance are not adversely affected to the extent that the significance of the vegetation or habitat is reduced. So if you create a whole lot of noise and light effects on a roost and you lose the bats, then you've reduced the significance and it's no longer significance. At what point it's unsuitable. So I'll talk to the two outstanding issues here, colour temperature, and I think that was discussed at length this morning, so I won't go too far into this other than to say that I think that's an important point, that market forces would correct any issues around supply. If the rules required 2007, the market will meet that. And the guidance on that, which Dr. Bork will be able to talk to, clearly recommends the 2,700K. So there is ecological evidence and ecological guidance that recommends that. The other point is the duration of motion sensor timing. Again, there's guidance, and Dr. Borkin can talk to the guidance that recommends the 1 minute duration. I think from an evidential perspective, there is evidence that light affects bats. From a human perspective, if you've got an outdoor lighting on a motion sensor, it's dark, carry your shopping inside, you shut the door, you're not really going to care if the light goes off after a minute versus 5 minutes, but the bats will. So I think in terms of there's a, the light will stay on while motion is happening. And there's no evidence to say whether a 1 minute timer versus a 5 minute timer is material to the occupiers of those houses. So moving now to the topic of noise, there is a growing body of evidence to confirm that noise has an effect on peka peka. The ecology evidence identifies that roosts can become unsuitable when exposed to noise. So we submit that the protective action required by Section 6C of the RMA and Objective 20.2.1 requires a proactive approach. So similar point made for noise as there is to lighting. So we've come to the scope issue here. And I've referred to an Environment Court decision which has said that a submission not be on scope simply because not elevated in the Section 32 report. But I do make the point that it's about the protection of the bat roost, for example, and that it's the adverse effects on that. And I think that is clearly part of the plan change. So when we go to Ms Sycamore will talk to this in her evidence, but if you look to what she has put forward, it's a policy standards. And I'd like to refer you to section 75 of the RMA, if you have that handy. So section 75 deals with the contents of district plans. So I think what I heard this morning is a characterisation that we're seeking standards and rules, but that's not what's in the evidence. And Ms Sycamore has clearly put forward a policy, and the policy that's been put forward is to ensure that noise does not adversely affect Indigenous fauna and significant natural areas. So the point on section 75 that I'd like to make is that the objectives are for the district, and that's an existing objective. The policies implement the objectives, and C says the rules, if any, to implement the policies. So if any, you don't actually have to do it by a rule. So section 75(2), a district plan may state the methods other than rules for implementing the policies for the district. So Director General's not asking for standard or rules on this, we're just asking for a policy, and the district plan doesn't need to have a rule on this. And I think the policy that we're asking for implements the objective. How that objective, what method is used, could be a range of ways, but it's just really touching on the policy and how that relates to the objective. So all roads lead back to the objective, which eventually leads back to section 6C of the RMA.
Could you talk me through exactly how that policy might play out in practice?
Sure. And I need to be careful I don't get into too much of the planning evidence, so Ms Sycamore can tell me when to stop it on this point. So just call out to me when you. So in terms of that policy, so it's a little bit fluid, and that's why we've asked for it to be a policy rather than a rule or a standard. So it's so the wording that Ms Sycamore has proposed is ensure that noise does not adversely affect Indigenous fauna in a significant natural area. So that there could be a range of ways that could play out in practice. Just trying to think of an example.
For example, to help you out, on a development, say we have some sort of intensification development going forward, it would have to be that a policy would be referred to in that case. It'd probably be better if there was an assessment criteria attached to that consent requirement.
Yeah, so I think, and that touches on the point is that we understand the issue of existing, and that we're part of a key concern is greenfield areas, but also intensification of areas. So, for example, I live adjacent to one of the areas that's been mapped as a SNA, and it's a quiet residential area, houses. So that policy is not really going to come into play because it's residential houses. But if there were a consent application to put a new intensified activity there, for example, a pub, a restaurant that might have, or a wedding conference venue, then that policy would come into play. Like, I'm trying to think of an example of when noise becomes an issue. So you might have something that's going to be held for events like weddings where you're going to have loud music late at night. And in that scenario, noise, if it's around a residential area anyway, is a problem for a range of reasons. It's not just the bats that are going to be upset about the noise, it's the neighbours. So I think having a policy there just puts it in the system, so it's something that's considered through that consenting process. But we were only asking for a policy, so there is a little bit of fluidness there for the council through that consenting process to determine the methods at which it would address that policy. Does that answer your question? Ms. Sycamore could probably do a better job.
If you might have some time to think up some examples.
Just before you move off the scope, just interested in terms of Harewood, and I understand your submission to us is that the submission is on the plan change because it's about protecting the habitats of significant species, and therefore this policy is one way, I guess, of implementing the objective. Can you talk me through Limb 2 of Clearwater and how
Sure.
that's met?
And I did write some notes down when you asked that earlier. I'm just going to find where I did that. Yes, I think a comment by my friend Mr. Maldani was, who would have thought there would be a noise control coming? So I think, well, here's the public notice that I received. The public notice said the purpose of this plan change is for the identification and protection of historic heritage or natural environments. So it said the identification and protection. So I think right from the outset, in that original post notification that arrived in our letterboxes, that it did actually go to protection. And then it went on to identify significant natural areas. And the summary also talked about the changes to ensure greater alignment with the RPS. And I think that links into the RPS provisions, which I'll pipe back to ECOP2, which goes back to the protection by ensuring the characteristics that contribute to the significance are not adversely affected. And I think noise is clearly something that would adversely affect it. So my submission on that is that it is it's not out of left field, that was in their protection.
So you're saying it's that people could reasonably and have anticipated that in order to protect the corridor SNAs, which are the ones really for the bats, that they could have reasonably anticipated that noise would fall under that protection heading?
Yes. So move now to, and I'm just conscious of time, biodiversity offsetting and compensation. So on this topic, I refer to, and I thank Council and Council Alpha Council for confirming that good practice guidance is supported. So that's a key point that the Director General seeks. And I think that's underlying, I think Commissioner Sargent, you raised a point earlier about the notification about what's DOC's role to Papa'atiwhai. And we're here performing a statutory advocacy function, which is Section 6 in the Conservation Act. And underlying what we are mostly seeking is good practice for biodiversity. So I think good practice guidance is a useful tool to assist with the proper implementation of the effects management hierarchy. So the helpfulness of the good practice guidance is that the concepts of offsetting and compensation are explained in this guidance, and they set out some key principles that have been developed to aid proper implementation. Offsetting and compensation are quite complex, and when you get into a complex resource consent, it gets very, very complex. So that guidance just helps keep things on track. And that guidance was used and is used by central government, MFE, in the development of these national policy statements. So it's that 2014 Good Guidance document is what is used as essentially the go-to document in central government. And you'll see from the NPSFM and the draft NPSIB that the principles, it's all quite common and it's very similar and is based on that good practice guidance. So I submit that the following good practice guidance is the most appropriate and the most efficient and effective way to achieve Objective 20.21. The Director General therefore agrees with the recommendation in the Section 42A report to add an additional information requirement that references the good practice guidance. That's been the base, as I've just explained, and there's no material inconsistency, and the protective action required by Section 6C of the RMA means that it is entirely appropriate to follow the good practice guidance. So I think in terms of future-proofing this plan change for the NPSIB, if it does come in, I think this plan change will be more robust if it's following that good practice guidance, because that is consistent with what's in the NPSIB. So the Environment Court has recently held that decisions on the expected outcomes of offsetting and compensation will ultimately come down to the body of expert opinions. So this is, you may recall I referred to the transcript in the Te Kuha decision at Plan Change 5. This decision has now issued, and that's the decision I've referenced at footnote 34, and that was uploaded with the cases that came with the legal submissions. So in that case, the Environment Court said we are left with the competing opinions of ecological experts on the likelihood of the expected outcomes, and have come to a decision based on that body of expert opinion evidence, with no further reference to the use of the BCM. So the BCM and models are something that experts work on, but ultimately the decision that the court, or that the information the court's making its decision, is based on the expert opinion. And where good practice guidance comes into that, what the Director General says that good practice guidance assists the experts in reaching the expert opinions. Having a requirement to follow good practice guidance generally improves standards, and it results in a more robust and consistent approach by experts.
Sorry, it's getting a bit late in the day. I must have missed what BCM was.
What, sorry?
Must have missed what BCM.
Calculation.
Oh, sorry, the biodiversity compensation model. Yeah. The moving to the next topic, because I'm just conscious that my two witnesses need enough time. The notification, so I'll just touch on this briefly because Ms Sycamore has covered that quite very extensively. So the fundamental, going back to first principles, the RMA was enacted to encourage involvement in the resource management decisions. Submissions and evidence enable more informed and better decision making. So us as submitters, we're here to help inform your decision. So we submit that the expert evidence of Ms Sycamore be preferred here. She will talk to the points raised by the council's planner, but there's a subtle aspect there which needs to be clarified, and I'll leave Ms Sycamore to talk to that. So in conclusion, on the legal submissions, we support the intent of PC9 to the extent that it recognises Section 6C and the provisions of the RPS and the vision and strategy, the higher order objectives. And what we are essentially seeking is fine-tuning and tweaking to actually close engagement with the ecological evidence, so what the end outcome matches the reality for the species that are threatened. So I will now...
I'm going to pause you there, Ms Hooper, because the time is running on and time is running over. Mr Paisley has been waiting and was scheduled, so I just want to bring him forward and then we'll revert to the department.
Witnesses?
Yeah. Yeah. So, Mr. Paisley, if you want to come forward, and we'll make sure that you get underway, and then we'll come back on department's witnesses.
I could borrow you. Well, basically...
No, you're not going to borrow her.
So in a nutshell, I've submitted my submission screen. My name's Robbie Paisley. I live at 5 Roberts Way, and basically, thank the good Lord, there's no bats at our place. We live just across the bridge. We've got everything they hate, lights, everything like that. The reality of it is, I'm not going to bore you. I'm just going to sit here. The fact of the matter is, I've worked hard all my life. I was a little farm boy out in the country. My parents had nothing. I managed to get through. I went to boarding school. I was bullied for 5 years at boarding school. I've been through hell and through my life and all the way to get through it. I started a business. I ended up with a $43 million company. I ended up going with South Canterbury Finance, went broke. They took me down through no fault of my own. But anyway, cutting a long story short, at 60 years old, I've bought a place, a beautiful place at number 5 Roberts Way, to the fact that the council hadn't even looked after the driveway. I've spent $10,000 cleaning the street. I've planted $20,000 worth of trees there. When the people before it that had it, I'm the second owner of the property. It was a gully, it was a farm dump. The guys down there, they planted the carry trees, they planted the place, it's beautiful. I spent a fortune on it. And basically then some bastard that I've never met before comes along, draws a line through my property and says, hey, we're going to put an SNA on it. I sincerely in my heart, it's and I'll be honest, I actually never ever thought how the Murrays would feel and get that through to my heart. And all my life I've been bullied and I've actually had a guts full. And this, to me, there's absolutely nothing on there. There's no natural flora on the place. There's absolutely nothing, but the place is absolutely gorgeous. It's beautiful. There's the people before me have spent a fortune on it. I've spent a fortune on it. And you know what the best thing about today is? Mr. Ewan Wilson's here, and there's no one in this room who could tell you about being bullied and actually being taken over than Mr. Wilson. So what I please propose is, can you please take my property? We've got plenty of other property. It doesn't affect it, and can you please remove the SNA from my property? God bless you.
Thank you, Mr. Paisley. Just before you go away, I don't want to bully you, but sit down, would you? Just take a seat. Just take a seat. There may be some questions. Just a second.
Yeah. So in brief, the bit that's got the SNA on it in your property.
That's 50% of it.
What's it comprised of, vegetation-wise?
It's just tree. It's been, to be fair, the people that bought it, it was a DOC property, and the guy was the curator for DOC that bought it, him and his mate, the one right next door. And then they subdivided it off because Roberts Way used to finish at Fernwater, and they bought that land and subbed it off. And he's actually got some of the most beautiful ferns and things they've done a really, really great job. The reason that they sold the property was that when, the only reason they spent $500,000 on the house before they sold it, but what they did was, with COVID came, their children were overseas and were never coming back, so they came back to Tauranga to live in Tauranga, so we were just in the right place at the right time. And I had a beautiful place out, and I used to own a company called Te Kora Transport, and I had it. So, but the reality of it is that and what really got up my goat was when I actually first emailed off to some person in the council to go back there, they said, oh, yeah, don't worry about it, it's, like it is, it's my land, we bought the land and we've done that, and I just want to own the land, and there's no significant flora there, there's nothing there, and I can certainly guarantee you there's no bats there. There's more light there than anything, and realistically it's of no significance, and it would be really appreciated to do it. But in my view too, and what I'm feeling from and what I've just heard from today is, I'm a solutions man too, but if people are going to you're going to take private property or put an S in, surely the council should go and say, well, if you're taking 5% or 10% or 15% of someone's property, their rates should be reduced accordingly. There's got to be a solution there, or buy the land. But I've been through hell and back, and I've paid $2 million for that property, and it's mine, and I want to keep it, and I don't want anyone else walking onto it, or anyone else having the rights, or the council, or anyone else coming on to do that, and like I said, through there, I've spent $10,000 down that cobblestone highway there paying cleaners to come and... When I first went there was that much crack on it, and I've had it cleaned, I've done that. We've gone right down there. I've been down with a bucket and shovel all the way down Fernwater, and we've got the place. And last year we put on a street party for the community, and we love the place, and I really love it. But all I'm asking for is you're human beings, you're all human beings. There is absolutely nothing, if you remove it off, it's going to cost you nothing, and it's going to mean a hell of a lot to me and my family.
All right, just hang in there.
How long have you owned the property?
2 years next month.
And my next question is actually for council. Am I correct that there's an existing SNA over it from the ODP, and it's just a small extension that's being proposed through PC9? That seems to be what the plans are showing. Am I correct?
Yeah.
Yeah.
Ewan?
No, it was the same question.
Right. Well, thank you, Mr. Mayor. We have heard you.
Thank you, and God bless you, and please don't do it. And I understand that we're right on the river and we love it, and we'll look after it. So thank you.
Well, we look forward to the party invite.
You come to the party. I'll bring Mr. Wilson.
Right. Thank you. Charles, you want to return? Thank you.
Oh, sorry to hold you up, and God bless the
Because no one else will, is that what you're saying?
Hopefully he's done the
I just want to, before you go, I just want to clarify that I don't understand the SNAs to be requiring public access on private land.
Yeah, no, it's all right. Let's not have an argument. Yeah, it's fine.
So I'll now introduce Dr. Borkin to present her evidence. And
Yep,
she's going
thank
to
you.
stand
Dr. Borkin, welcome again. Yep.
Tēnā koutou katoa, e tupua te maro o te maunga o te aroha, e te taha o te awa o Waihau. Takuta Kerry Borkin is my name. I prepared a statement of evidence dated the 28th of April 2023, and I do have some corrections to my statement of evidence. They're set out in an appendix to the summary statement. Would you like me to read that?
Yes, tell us what the corrections are.
Right, so it's to my paragraph 19.1, and it should change to read, Eurobats 8 guidelines also focus on minimising the amount of time that bats are exposed to light by recommending only using lights when they are needed, full stop. Other international guidance documents for minimising the effects on lighting on bats particularly recommend that any external security lighting should be set on motion sensors and short 1 minute timers. And the footnote would also be changed to the correct one. So I just wanted to clarify which documents I'm talking about.
Yeah.
So this is actually Eurobats 8, not the one that was pointed out earlier today. So I think we've made sure that you're provided with a copy.
We do. Yes.
And the document that talks about the 1 minute timer is this one, which I had a copy of earlier. Great.
But just on that, have you got? I went back and saw Mr. Mackenzie's evidence where he had those both referred to. I mean, is there a preference? It seems to be Eurobats as a preference.
I prefer this because it's more specific in its detail, but this one has the details about timers and so on. So it's kind of a combination of both as well. But I generally prefer Eurobats 8. Okay. So would you like me to continue with my summary?
By all means.
Okay.
Yeah.
The long-tailed bats, or Pikipika, are a highly mobile species that is ranked as threatened and nationally critical, the highest threat ranking in the DOC threat classification system. This is due to previous and continuing habitat loss, and because each studied population where the predators of bats aren't controlled to low levels are declining. And habitat loss can occur, for example, even when trees are not removed because they're exposed to amounts of light and noise that bats cannot tolerate. Pikipika are present throughout the Waikato region, and they use parts of Hamilton when roosting, feeding, breeding and socialising. And most often bats are detected in the southern part of Hamilton and in areas that are less urbanised, quieter and darker, particularly in those gullies, parks, sports grounds, farms, lifestyle blocks and other green spaces. And while some Pikipika may roost within the currently urbanised areas of Hamilton, most quickly leave these areas around their roost and they fly to the less developed areas to spend most of the night. And in Hamilton area where there is higher housing density, more traffic, more roads and more light, there are fewer bat detections. And this means that in urbanised areas where there's unrestricted light and noise and insufficient distance between these impacts and where the bats are flying or roosting, that bat activity has already declined. So these bats are highly philopatric, they're loyal to specific locations, and they're particularly at risk in the Hamilton area because they regularly face the loss of roosts. That's where they shelter during the day and rest and socialise at night, and the loss of functional habitat. And roost and habitat can lose their functionality due to urbanisation. That's including traffic and increases in housing density, and when exposed to noise, light or tree loss due to felling, removal or trimming. Now, roosts can become unsuitable for bats to use even when they're not felled or trimmed if they're exposed to high level of noise, light or weather conditions because other trees that have been surrounding them have been removed or trimmed. And this can mean that bats use roosts or areas less or might not be able to access those areas that they previously did. And lost roosts are really difficult to replace because newly planted trees may take up to 80 years to form the types of cavities that bats might use. Artificial roost boxes that I'm sure you've seen now around Hamilton, they're a short-term fix. They require high levels of maintenance to ensure that they're safe for bats to use. And the temperatures can vary really widely. And we know little about how to replicate the conditions that bats actually need in a roost or where to put them so that they are attracted to or suitable for bats.
Just before you move on, I had a question. What is short term? If they're regularly maintained, how long can these artificial bat roosts last for?
Right, so I actually visited Hammond Park in the last week and I understand that there is a condition that requires those artificial roost boxes to be maintained annually. One of the predator-proof bands in one of those areas is already not working, it's broken. So that must have happened within the last, it's meant to be fixed before maternity roosting season, which should have been November, so it would have been fixed maybe October last year, and it's already broken. So it really does require quite a lot of maintenance. Yeah, so and within about 6 years, if there's nothing happen, then the boxes themselves start to deteriorate as well.
But if they are regularly maintained and checked, whether that's 6 monthly, 3 monthly, yearly, as required, can they be a sort of a long-term solution, or are they always a short-term fix?
Because they're not high quality, so the problem with artificial roost boxes is that the temperatures go up and down, widely, but also wildly. So
Yeah.
they're kind of all over the place. They're not the stable temperature that is something that would be useful. It's like like a warm home. We don't want one that's freezing cold and then really hot. Something that's better for us to live in is something that's quite a lot more stable. And it's the same problem with artificial bat roosts as well.
And I think your evidence said we just don't have the knowledge yet of what the perfect thermal sort of environment is for the bats in those roost boxes.
That's right. Yep, we're not there yet. So I was saying about these wild climatic variations, some of the implications of that is when they use those roosts, then they've got fewer weaned young and they have lower rates of survival as well because they have to regulate their temperatures more often. So as we've heard, there's currently no proposed restrictions on noise to protect the function of SNA for bats, despite the recent research that I was involved in, which has found there is less bat activity in the presence of noise. And this known effect will therefore remain unmanaged. And this means there's a risk of areas within SNA losing their functionality for bats because of noise. Options recommended by other researchers as ways to mitigate noise impacts on fauna include, but are not limited to, noise barriers, substrate alterations and speed limits on roads, and restrictions on events and their locations. So moving on to light, adding light to an area that results in less bat activity in that place. And in my evidence, I outline best practice principles for managing the impacts of light on bats. And in both Eurobats 8 and the Bats and Artificial Lighting Guidance Note from the UK, these encompass a lot of these best practice management tools. And the proposed light rules focused on lighting do not follow all best practice principles in either of these documents. In my opinion, these should be followed, including A, the use of 2,700 Kelvin rather than 3,000 Kelvin because of the associated reductions in blue wavelength light that bats are sensitive to. B, the lower lux levels in line with international best practice, and or wider setbacks to reduce the amount of light that SNA are exposed to, and if you're following that international best practice, it would be 0.1 lux rather than the 0.3 which the current setbacks are modelled on. Reducing the length of time that lights are on, including the restricting of light on sensor timer to 1 minute. And D, increasing distances lights are set back from areas that bats use. And these areas bats use, bat habitat, include roosts, both those communal and solitary, and places used for breeding, foraging and commuting. When trees are felled, both colony sizes and home ranges, those areas bats use, get smaller. The rules associated with tree felling, removal and trimming, in my opinion, allow relatively large areas of trees to be removed or trimmed each year. And this raises the risk of high levels of cumulative loss to SNA. In my opinion, this amount should be reduced. In their current form, the proposed rules will run the risk of habitat in SNA losing its functionality for bats and being used less often by fewer bats. So I'd also like to note that it was indicated on 2 occasions this morning that I agreed with the proposed inclusion of the citywide rules during expert conferencing. If you read the JWS, you'll see this is not the case. I did not agree with those in their inclusion. And this is for the following reasons, which I also discussed in my evidence. The bats are not citywide, they're focused in specific areas. The scope of the citywide rule is too narrow. As Ms. Hooper has discussed, when I talk about landscape wide, I'm meaning far broader than that as well. The proposed rules are excluding some areas used by bats, and they appear to focus only on areas considered significant, which, in my understanding of the discussion around those rules, means the near roosts or in areas of high bat activity, so it's including large areas that are used by bats. And I consider that, in my opinion, this will be insufficient to protect and enhance the bat population. So in summary, providing rules that focus on protecting the functionality of SNA for bats by managing the effects of noise, light and tree loss will protect the integrity of SNA as a whole for a range of fauna. Thank you.
Thank you, Dr. Borkin. The points of disagreement between you and the others is very, very clear, so I don't think there's an issue in terms of understanding where you're at on that. Any questions?
Just one thing. I think in your primary statement, you talk about the allowing of 50 square metres or 100 square metres at para 20.13. You say that at present that's allowed depending on whether the site is a property or asset, and tree felling at this level will reduce the functionality of SNA for bats. What is an appropriate level in your view, if there was to be a standard? So it seems you don't agree with the 50 or the 100, but do you have any, advice for us on what would be an appropriate level, or is that level 0?
That would be amazing, wouldn't it? And some of the evidence that I've found from overseas, even removal of 5 metre section of trees was enough to reduce the amount of how often bats were using it. So it would need to be reduced fairly significantly for me to be confident that that would not reduce functionality.
Okay, thank you. That was all I had.
I think a main point of disagreement is simply that on one side we have Dr. Muller saying that in actual fact we need better evidence and perhaps be able to quantify the risk a bit more. You're saying no, prevention is really important, and you act now and you worry about the data and so on coming in behind later on.
We do have data that shows that evidence.
There's still disagreement between the scientists, quite obviously, on the implications of the data. So it's an interpretive disagreement. All right. Thank you, Mark. Mr. Kamal.
I'll just stay sitting if that's okay.
You might need to speak up a little bit more as well.
Should I get closer?
You have to put it right close to you. It's one of those.
Should I touch this or will
Yes.
Okay. Right. My name is Ashley Sycamore. I prepared a statement of evidence dated 28th of April 2023 and rebuttal evidence dated 11th of May 2023. I am a signatory to the Planning Joint Witness Statement dated 20th of March 2023. I was unable to attend the Ecology and Planning Expert Conferencing session on 14th of March 2023 because I unexpectedly had a funeral to attend that day. Prior to working at the Department of Conservation as an RMA planner, I worked as a planner at Hamilton City Council for 3 years and was mainly tasked with processing subdivision and land use resource consents. As such, I have practical experience implementing the provisions of the Hamilton City Operative District Plan. Point 6 onwards summarises my planning evidence, which at this time, and aside from the notification/non-notification rules section below, has not changed from my statement of evidence and rebuttal evidence. I have reviewed my evidence and have identified that my opinion has changed on the topic of notification/non-notification rules since my evidence was prepared. This relates to figure 1.1.9a, which is attached to the back of my hard copy summary. Figure 1.1.9a within the ODP is a process to determine notification of resource consent applications. It is noted that most activity examples within figure 1.1.9a are restricted discretionary activities, though there is one example of a discretionary activity, being a show home in the residential intensification zone. I consider that my original recommendation to amend figure 1.1.9a to include reference to an infringement of rule 20.5.6 and or 20.5.7 would be inappropriate given this would default to a non-complying activity and the usual notification assessment under section 95 of the RMA should instead apply. I consider that it would still be appropriate to update figure 1.1.9a to allow limited notification to the Department of Conservation where an activity causes minor or more than minor adverse effects on threatened or at-risk species for a RD activity. I consider an appropriate standard for this scenario is activity 20.3L, being the construction of new public walkways and cycleways through a SNA, including associated pruning, maintenance or removal of indigenous or exotic vegetation or trees and associated earthworks, which is a RD activity within a CSNA. I note that this recommendation links to a submission point by the Director General of Conservation, who held concerns with the permissive nature of the activity status for the construction of new public walkways and cycleways through a SNA. It is noted that the recommendations version of PC9 amended activity 20.3L from a RD activity to a discretionary activity within a FSNA. Activity 20.3L within a CSNA remained a RD activity. To achieve the above, I recommend that activity 20.3L, construction of new public walkways and cycleways through a SNA, within a CSNA be altered from a RD activity to a RD asterisk activity, with the addition of the asterisks triggering an assessment under figure 1.1.9a. Following this, I recommend that figure 1.1.9a be amended to include the below wording or wording to like effect. Is the activity identified in Rule 20.6 Roman numeral 2. This is to be added to the fourth chart on the left of the flowchart. If yes, then does the activity cause minor or more than minor adverse effects on bats or any other threatened or at-risk indigenous fauna? If yes, then the Department of Conservation / Te Papa Atawhai will be considered an affected party on a limited basis. To build on the point around the discussion earlier, this morning there was some discussion on Waka Kotahi, Kiwi Rail and Hamilton Airport. They're included in that flowchart and I acknowledge that those are all asset owners. While Heritage New Zealand was also mentioned, they are in the flowchart and they were raised as perhaps they've been included in this figure due to legislation requirements, though I can't confirm if that was the reason that they were included. I just would like to note that DOC also has legislative requirements under Section 6 of the Conservation Act 1987 that has relevance to SNAs. I'll continue unless there are any questions on that point. Hamilton City's boundaries contain long-tailed bats, which are nationally critical threatened, and their habitat. This population faces increased fragmentation of its habitat from planned and proposed development. As detailed within my planning evidence, I have proposed changes to the district plan provisions in regard to the topics summarised below. It is my opinion that these recommendations assist in achieving the intent of PC9. While I support the new lighting standard Rule 25.6.4X for sites adjacent to or within SNAs, excluding the Peacock precinct, I request 2 amendments to the standard, being a maximum colour temperature of 2,700K, and just note that I've written maximum colour twice, so delete one of those, in place of 3,000K, and a motion sensor timer of 1 minute in place of 5 minutes. I consider the following amendments to Rule 25.6.4X are necessary to minimise the effects of lighting on Indigenous biodiversity, including the long-tailed bat, as detailed further within the evidence of Dr. Kerry Borkin. If the wording changes above are not supported, other provisions that minimise the effects of lighting on Indigenous biodiversity could be included in PC9, such as increased building setbacks for lighting standard 25.6.4X and planting buffers. Noise. As detailed further within Dr. Kerry Borkin's evidence, noise is one adverse effect on Indigenous biodiversity as a result of development in proximity to SNAs. In lieu of a setback provision being included in PC9 to minimise adverse effects resulting from development on Indigenous biodiversity such as the long-tailed bat, I recommend that additional provisions for noise be added to Chapter 25.8, Noise and Vibration, of the District Plan. In my evidence, I have recommended that a new noise policy be included in Chapter 25.8 to ensure that noise does not adversely affect Indigenous fauna in a SNA. And just to build on the conversation earlier, I would like to note that I intentionally recommended a new noise policy rather than a new noise standard. From a planning perspective, I consider that it would be difficult to implement a noise standard of this nature in the district plan. As such, I consider that a noise policy would be more appropriate to ensure potential adverse noise effects on Indigenous fauna are assessed when an activity goes through the resource consent process. I further note that there are some sections of the ODP that only have objectives and policies without any rules. I consider that there is no requirement for a policy to be proposed in conjunction with a rule, which relates to Section 75 of the RMA, which Ms Hooper referenced earlier.
So what would that mean in practice, just picking up on Commissioner Sargent's question in terms of consenting? Does that mean someone that's wanting to do a development in an area where there might potentially have some impacts on an SNA would have to get an ecological assessment done by a BAT expert if that policy is adopted, even though it's not a standard?
Yeah.
What is the practical implication
It would
from a consent
depend on the
perspective?
activity status. Let's use the example of a non-complying activity, say something that's not anticipated in a particular zone, whether that's adjacent to an SNA or within a SNA. Let's use the example of maybe a wedding venue and a car park that adjoins a SNA that would have lots of people and cars coming and going, and that would potentially result in noise effects. That would require an assessment under that noise policy that I proposed. That doesn't necessarily mean that it would require an ecological assessment, but you may need one to prove that there are no adverse effects on Indigenous fauna in relation to noise.
So it bites in relation to non-complying activities close to a SNA.
And discretionary.
Yeah. But potentially not RDA.
Potentially not, unless there was assessment criteria included.
Except it probably gets caught with your other recommendation further up, isn't it, with respect to minor or more than minor adverse effects, since more than minor and, well...
Yes, though
in
that
fact, minor,
wording we've proposed only relates to one specific activity, which is RD, and that's the one around construction of new public walkways and cycleways.
So you're tying it specifically to that activity?
Yes.
And that activity status to both
Because
both
that's
elements.
an RD activity, whereas once you get to discretionary non-complying, you
I
have...
was going to ask you at the end, but I'll ask you now, why include minor in that?
That relates to just some other wording that was in the flow chart. I just thought we'd keep it cohesive.
Well, let me ask you why include the word minor in there. that case? I mean, if it's a minor adverse effect on a bad, then why would you require that?
Well, then it would be notified to DOC if there's minor effects on long-tailed bats.
If it's a minor adverse effect, I mean, almost by definition, a minor adverse effect is not something that requires a great deal of attention.
Right, yeah, that's true. Yeah, I captured some wording from another part of the flow chart for Heritage New Zealand, where if there's minor effects on heritage, then that would be notified to them.
It's fine. I just wanted to know whether there was something specific there. But, all right, carry on to the end.
We covered noise, didn't we? Yes. Biodiversity offsetting and compensation. The Director General's submission requested that PC9 provides clearer guidance on the use of offsetting and compensation. An additional information requirement under 1.2.2x was recommended in the Section 42A report in response to the submission point. The wording of 1.2.2.x ensures that any assessment in line with this information requirement would be required against the best practice guidelines on offsetting and compensation, which is important if in the future there are new or updated best practice documents. I recommend that the proposed information requirement 1.2.2.x be retained as notified in the recommendations version of PC9, which includes the reference to most recent best practice guidelines. National Policy Statement for Indigenous Biodiversity. If the NPSIB is gazetted before decisions are made on PC9, I agree with the Section 42A report that any required adjustments to PC9 should be considered and made. It is anticipated that the NPSIB will be gazetted in 2023. SNA criteria. The purpose of SNA is under 20.1c of the recommendations version of PC9 references an outdated section of the Waikato Regional Policy Statement. I recommend that the wording of 20.1c be updated to reference the SNA criteria under Appendix 5 of the WRPS. SNA mapping. The Director General's submission sought additional provisions in PC9 to protect unmapped areas within Hamilton City that meet SNA criteria for significance under Appendix 5 of the Waikato Regional Policy Statement, as required by Section 6C of the RMA. Within my planning evidence, I recommended 2 new policies be included in Chapter 20 of PC9 to identify and recognise areas of significant Indigenous vegetation and significant habitats of Indigenous fauna. Policies, I agree with the amendments to Policy 20.2.1F, G and K. Note the numbering of Policy 20.2.1K is proposed to change to Policy 20.2.3A, and I recommend that these 3 policies be retained as notified in the recommendations version of PC9. Eurobats evidence. The evidence of Dr. Kerry Borkin, Dr. Hannah Mueller and John McKenzie all reference and rely on the Eurobats guidelines. The Eurobats reference will be helpful to district plan users who need to consider or address the adverse effects of light spill on long-tailed bats. I support the inclusion of the Eurobats reference, and I recommend that the text within the explanation section of the lighting and glare objectives and policies be retained. And that concludes my summary of evidence.
Thank you, Mr. Cole.
Yes, just on the sort of a desire for a sort of apparent automation for an SNA to become, mapped within the plan pursuant to a resource consent. I mean, that's simply not correct legally, is it? I mean, like, in my mind, there must be a difference between the protection afforded by the recognition of SNA features pursuant to an assessment carried out on a resource consent. That's consistent with the Act. To give it that protection, that's important because it's significant. But the creature of the district plan can only be modified by way of a Schedule 1 process. You can't get around that. Is that your understanding?
Sorry, what was the question?
So the question is, can the plan, in your view, can the plan be modified without a Schedule 1 process that is a plan change?
I don't have a huge amount of plan change experience in terms of from a council perspective, so I'm not certain on that.
That's what I thought you were saying, Ms. Hooper.
That's almost a legal question, so could I respond to that?
Not almost, it is one.
It is one, yes. Sorry, it is a legal question. So I think that the wording that we're proposing is an extension of the policy.
It's on page 12 of Ms Sycamore's
Yes,
evidence.
and that's what I've got here. So it is the recognise that areas of significant Indigenous vegetation, significant habits of Indigenous fauna include sites that are mapped and sites that are not identified on the maps but meet one or more of the criteria. And from a legal perspective, I jump into that definition that I referred to before. Which, I've just got to find the page. So an example definition of an SNA refers to a significant natural area means an area, significant habitat of Indigenous fauna that is identified in a regional policy statement or plan district, or is identified in the policy statement or plan, including by map, a schedule, or a description, or by using the significance criteria. So simply in this policy, what we're looking, or what we're seeking as relief is that reference, that trigger back to the significance criteria, because I think by law, if it meets the significance criteria, then it is significant. So if you've got if it's a red car, it's a red car. If it's got something that's significant and meets the criteria, just the fact that it's not mapped doesn't mean that it's not
significant.
Not significant. So that's the legal point. But Ms Sycamore has, we talked about that example that you'd come across as a consent planner, and I think it'd be useful if you talked to that briefly.
Yeah, my time at Hamilton City Council, there were some examples of when we came across an application with a site that had a threatened or at-risk species on the site, and then it would be difficult to deal with in terms of, for example, there was one with black mudfish on the site. It's difficult to get a applicant to do any sort of assessment around that, though it does meet the SNA criteria under the Waikato Regional Policy Statement. If it's not mapped in the Hamilton City Council Operative District Plan, there's not a huge amount we can do, so the onus goes back onto the applicant to then talk to the regional council about their requirements. So I think it would be helpful from a council perspective as well to have some policies around unmapped SNAs to assist in those examples, because it sort of gets into murky waters and it's not helpful for council to have that risk for a development that has a threatened or at-risk species on a site, and there's not much they can do about it from a district plan perspective.
Can I just add to that briefly? We recognise that it would be impracticable to map. I think the example given was all the drains, but so I think this is a practical way forward, and it is something that is done in other plans. I believe the Auckland Unitary Plan may have a similar wording.
But I take it from that you're not wedded to the wording here. You're looking for the principle to be accepted, and then perhaps to finesse the wording on the principle.
Correct. We're not wedded to the wording. We're looking for tweaking, fine-tuning to make sure the underlying key legal principles are carried forward in practice.
Just one that's probably more for you, sorry, up, down, but it came up when I was just reviewing my comments on Ms Sycamore's, and it was in relation to the NPS-IB, and she made a statement that if it's gazetted before decisions are made, then it would need to be considered. So two questions: any intel on timing for gazettal of that? And secondly, if it is gazetted before our decisions come out on this particular plan change, would the department be seeking an opportunity to readdress us on the implications of the NPS-IB at that time?
So in response to that, so intel, I have been, well, I was recently on secondment to MFE, so, but I can't talk to. Yes, I can't share any intel, sorry. But I think if our submission on
Have you scheduled an appearance later on in the year on this matter?
The submission that we've put, which supports the Section 42A recommendation of good practice, I think puts it in good stead for being in line with the MPSIB.
Okay, so you may not need to come back and address this again.
Correct, if that good practice guidance is incorporated.
Or if the MPSIB stays in its draft form, current draft form.
Correct.
Yeah.
Yeah.
'Cause if it varied significantly, then the guidance would be different to what the end result was.
But wouldn't it be the case that if the MPS is gazetted and becomes operative before our decision is out, then we have to consider that?
Oh, absolutely. Yes. Yeah. And
But you're saying that you wouldn't want to come back?
I actually thought it would be gazetted in December. So I was disappointed that we went through in December. So I think there's still quite a lot of motivation to get it through, but I can't give you any impressions because I don't want to give you false information. But yes, we would need to come back.
That's right. We're just fishing. All right. And did you want to sum up, or that's it?
Just very briefly, I had I think just very briefly on the difference between the ecological evidence, I think I just refer back to that general point that, which going back to that New Plymouth forest and bird case, which is that the protective action required by Section 16, Objective 20.21 requires a proactive approach. So that's would be my summing up.
Yeah. All right. Thank you very much.
Thank you.
Thank you. All right. Steve, what have you got to tell us? Have we got a rescheduled hearing? Have we got a rescheduled hearing for Miss Morgan?
I'll sort it out tomorrow.
Right.
She was sitting in reception across at the office.
That's what I wondered, whether she got a different building.
Staff told her, of course, to bring somebody down, but they didn't phone.
Oh, okay. Right. All right. Well, we'll get her here eventually.
We've sorted out they'll phone me next.
Right. Anything from council?
No, thanks, sir.
All right. Well, in that case, thank you very much, everybody, and we're adjourned till 9 o'clock tomorrow morning.